Welcome back to our short day, our short Friday in day 4. We're at day 4. It's going to reach the point where I'm going to have to check before I start trying to guess what day of trial that we're at. Ah, already done with the first week. Already done with the first week. Where are we at, guys? Where are we at? I might do a little recap. Might do a little recap over this weekend. Sit down, rewatch, re-listen to those openings, recheck my notes, see where we're at. If that was supposed to be our roadmap and our commitment to where we're going, how are we doing so far? Not seeing a whole lot of facts, science, and data proving that Karen killed John O'Keefe with her car. We know that this morning we're going to get Dr. Garrey Faller. And this is going into Karen Reed's blood measurement and the retrograde extrapolation that they did to try to show, try to show what her blood alcohol content was the night before. You might remember from the first trial that because of just the variables that are involved in this type of calculation, it ended up with a massive range. I don't even remember the numbers, but it was something like from 0.07 to 0.25 or something like that. Could have been any of those things around the time of the driving. And that's just because it's been there's such a delay between when they're trying to calculate her blood alcohol level for about 12:30 the night before, and when they actually get her blood, which is after 9 a.m. the following morning. So it's only going to be so precise. There's also a little bit of an issue here because of how they did the blood draw, and so that's why Dr. Faller came in last time. They took the blood while she was at the hospital, and it wasn't part of like an ordinary DUI investigation. So a little bit of a question about the protocols that they used. Are they reliable? Are there, because of the differences between clinical blood testing and forensic blood testing, are there other factors that could influence that measurement? These are the types of things that came out during the last trial. You guys know what my theme has been. I'm going to keep repeating it. This doesn't matter. This doesn't matter to the defense theory. She's not charged with DUI. They're not defending DUI. And, if this is my closing, I'm telling the jury, yes, she committed DUI, and she told you she committed DUI. And if that's what she were here charged with, we wouldn't be here. We wouldn't be here. But she's not charged with that. She's charged with murder. So, it doesn't matter to their theory. Does it matter to the case? Well, it depends on your theory, right? Yes, she's charged with vehicular manslaughter by virtue of DUI, driving under the influence, recklessly causing the death of another person. But your theory of defense is what matters, and that's what drives what's important in court and what isn't. And so their theory here isn't, Karen hit him, but she wasn't drunk. If your theory was Karen hit him, but she wasn't drunk, then you're going to go all in on this blood alcohol test. You're going to go all in on the limitations of it. You're going to go all in on the variables. You're going to hit that time gap, all the uncertainties within that time gap, the assumptions that you have to make. If that's your theory of defense, you're going to go hard at it, but it's not. That's not the theory of defense. The theory of defense is she didn't hit him with the car. So they don't need to go hard at this. They're going to, though. We already know they're going to. They did last time. I mean, go hard at it. I don't know how hard they went at it, but they certainly took some swings at it. Ms. Little handled the cross-examination during the first trial. It looks like this time we'll probably get Mr. Alessi. That might give us a little interesting contrast too, to go back and take a little peek at how that went the first time versus how they do it the second time. Speaking of contrasting, I just wanted to check my vibe check on Michael Camerano. Mike Camerano testified yesterday, and he was the friend of John's who met up with them at CF McCarthy's. It was John and Mike Camerano and Kurt Roberts, and then later Karen joined them. And so I wanted to go back and check my vibe check because I'm like, this guy, he seems different. We're starting to see this pattern of just increased anxiety, resistance, and dare I say, even hostility to Karen. It's part of what David Yanetti drew out with his cross-examination of Daniel Whitley. Like you tell your story multiple times, and by the time you're telling it now, you're making it sound a lot worse for Karen than you did the first time you told it. Similar pattern with Mike Camerano, guys. Maybe not as extreme, but there was definitely one inconsistency that jumped out at me during his first trial. He testified he never saw them argue or fight, and he wouldn't even call it bickering if they disagreed. He wouldn't even call it bickering. This time, yeah, he calls it bickering. He actually made a point of saying they didn't really argue, but they would bicker and they would banter, you know. So in his memory, he's dialed up the conflict between Karen and John. Not such an important point, but just kind of the way the mood of the evening as he depicted it in the first trial was a little bit different as well. Talking about Kurt, for example, Kurt Roberts, he wasn't initially going to go out with them, but Mike tells him you're a pussy. So then he goes out. So why is Kurt a pussy? Because he wasn't going to drink. I don't know. But you know, doing that guy thing that they do. Guys like to neg each other and stuff, and that's how they show affection to each other. Some guys, anyway. And then he also had that story. I remember as soon as I read it in my notes, I'm like, oh yeah, I remember that because Kurt Roberts apparently just disappeared at some point. He didn't say goodbye to anybody. And so Mike Camerano called that the Irish goodbye. Or maybe it was Mike Camerano himself did the Irish goodbye. He just kind of left. He didn't really say any. I had never heard that expression before, and I've actually never heard it since. So I'm not in Boston. I'm not in a, particularly Irish American community. I don't know that I would be in a position to hear those kinds of jokes, but it just, comes across as a little bit more lighthearted. The first telling was a little bit more lighthearted than the second telling that we got. Granted, yes, he was still emotional. He was still affected. But overall, it's like there was more fondness in that memory than there is now. And so that's a theme I can't help but notice. It really seems to be starting to emerge as this dialing up of the antagonism towards Karen. So it's interesting. I have so many ideas, and it's just only so much time to be able to do stuff while the trial is going on. There's like so many roads I'd like to go down. Another thing, I've got like Substack ideas that I want to try to push out over the weekend. And I'm going to do my best to try to get something out. So I already talked about, I want to go back and look at Judge Bev tipping her hand here with the ABA rules, the retention, and finding the discovery violation because they didn't keep the text messages with ARCCA. Definitely want to give you some thoughts about that. But the other thing I would love to do is put some of this revisionism in context in light of this book, I keep telling y'all about it, but it was so, I just enjoyed it so much. I recommend it so much. It was such a great read, Duped by Dr. Saul Kossin. And so he wrote a whole chapter in this book. This is a book about false confessions, and how they, contribute to wrongful convictions and stuff. Like, why do we believe these? Why are they so powerful? What types of effect do they have? He has an entire chapter on how false confessions can taint everything that comes afterwards. Because as soon as people learn, oh, that person has confessed, starts to revise their memory. And he gives the example of the Amanda Knox trial, where like friends, neighbors, eyewitnesses, stories change. Stories change, like originally down to like alibis and where she was seen and stuff like that. People's recounting, their recollection as they express it, changes after they learn she's confessed in prison. And so it kind of seems like maybe we're seeing a little bit of that here. Maybe we're seeing a little bit like that same similar type of phenomenon. It's just a confirmation bias. If John's friends got through the first trial and they think she's guilty, and they've talked to each other, and they've gotten more and more entrenched in this viewpoint, I could see that same type of thing happening, where just the replaying of it, that rewriting of the memory, it just starts to become more and more and more negative. And where the first time we're remembering this relationship and this evening and these interactions between these people, just some of the most congenial people you can imagine, never saw them fought, never saw them argue. They were in the best mood. They were lovey-dovey. Everything was fine. No mention of the plumber, jealousy. In fact, they don't even bicker. Wouldn't even call it that. But when we come back and replay it this time now, it's maybe small, but now they bicker. Now I want to be very clear. Am I suggesting they should have cross-examined Mike Camerano on this? No. No, I'm not. Why? Because it doesn't matter. It doesn't matter to their theory of the case. It doesn't matter. People who fight, people who are, even if this was a fighting, bickering kind of relationship, most couples that fight don't kill each other. Someone doesn't die as a result of that. That is an extreme domestic violence to escalate to that kind of point. That's an extreme manifestation of that dynamic. I've talked about this case from that standpoint of domestic violence, and I think that's such an important framework that has somehow gotten overlooked in all this. And maybe it's just because the Commonwealth hasn't charged it as a domestic violence offense. I have to go look at the Massachusetts criminal code and kind of how they formulate these kinds of things. So the way it works in Washington is, you get charged with a regular crime. Say there's a domestic assault. You're just charged with a regular assault, but they will have an enhancement, or they will have like a designation. There's like all different ways that they can handle it to kind of, characterize it as domestic violence. And they do that for a lot of different reasons. Sometimes that'll make the punishment worse. Sometimes it's just literally for purposes of the fact that there can be collateral consequences for crimes that are designated as domestic violence offenses. And the primary one that, jumps to the top of my head, deportable. Makes it a deportable offense if you're not a citizen. The other one that jumps immediately to my head, gun rights. Federal gun rights significantly affected by a domestic violence designated type of conviction. So different ways of being able to do that under different. It's going to be going to be a factor of state law. So that's how we do it in Washington. I don't know specifically how they would normally do it in Massachusetts, but bottom line being, they didn't do it in this case. Doesn't seem like there's nothing that stands out that designates this in particular as being a domestic violence offense. Not 100% sure. This is actually something I litigated in Washington. Not 100% sure that's something that they would have to include in the indictment for the jury to make the finding of whether there's domestic violence, or whether it would be constitutionally permissible for a judge to make that finding. The reason why I mention this is there's a whole line of case law that deals with who gets to decide what facts, and it particularly goes to sentencing. I'm talking about a Prendy Blakely Bookley. If you're like the sentencing nerdy people like me, you'll know that trilogy. But these are a bunch of cases that came out starting in the 2000s, where what was happening is somebody would get convicted of a crime, and then they would go to sentencing, and the judge would make all kinds of findings about, you particularly suck, and this crime was particularly bad, and then they would use that to increase somebody's sentence based on just kind of the judge's own opinion about the crime. And so that started to be litigated in terms of, well, does that violate your right to a jury trial? Shouldn't a jury be finding all of the critical facts that are needed to decide both did you commit this crime, and kind of what's the permissible range of punishment that you should be subjected to? So those cases started to come out of the U.S. Supreme Court, like I said, in about mid 2000s, early 2000s. And they concluded, yes, a jury has to make any fact that could potentially increase the consequences of sentencing. Jury has to find. So I've at least attempted to litigate this and get a ruling on this in Washington, because there are ways that domestic violence designations can specifically increase your punishment. There's specific fines and fees that are associated with it. It can subject you to different conditions of community custody, require you to do different programming when you're in prison. There's all those collateral consequences that we talked about as far as gun rights and so forth. Looks like they're getting ready to get started here.
You are unmuted.
So I'm just saying this because I'm not sure it would have to be in the indictment.
Good morning.
But it's not there.
The court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial.
Thank you. So good morning. I heard the counsel wanted to see me about something.
Yes, please.
All right. Why don't you come on over to sidebar?
And we're going to start right off at sidebar. So anyway, I don't know then, in this context, if Karen Reed were convicted, is there a possibility for Judge Cannoni to make a finding this is a domestic violence offense, sentence it accordingly, subject her to all those collateral consequences? I don't know. I'm not sure legally how that stands in this posture. But really wasn't the point I was getting at. It was just that for whatever reason, the domestic violence aspect of this crime just kind of has fallen off the radar. And it hasn't been something that has really been discussed as far as I can tell. This would be a domestic violence crime. Like if there is an opportunity to charge it like that, an enhancement, a designation, something like that, this would qualify almost certainly, because these are people in an intimate romantic relationship. And states will have different definitions of what domestic, what counts for purposes of domestic violence as far as like how close are you, but it's usually going to be things like people you live with, people in your immediate biological family, and your romantic partners. So this is a, you know, this is a allegedly what the Commonwealth theory is a murder of a domestic partner, an intimate partner. That's a domestic violence crime. And so, you know, that framework is an important, it's an important aspect of this case to try to understand the dynamics of what happened and help us kind of make sense of does the Commonwealth theory, does it hold up? Does it comport with what we can see and the dynamics that we can see for ourselves? Uh, does it comport with that? Does it make sense? And it's important because, you know, in domestic violence relationships, again, we talked about this. There's bilateral violence just because we tend to look at the relationship and typically evaluate, like, okay, who's the primary abuser in the situation? The one that's being abusive. It doesn't mean that the primary abuser is always the one that's abusing, because you have reactive abuse. You have self-defense. You know, battered women syndrome is a whole thing because because you're talking about a situation where it's not the primary abuser who has inflicted the violence. And so these can just be very complex and very nuanced types of situations to try to evaluate. So it's just important. It's just important context, you know, to try to get a sense of would Karen have behaved like this? Is this consistent with the dynamics of the relationship? Would it have been different from the dynamics of the relationship? Granted, we don't have a ton, but you got a lot of text messages. You have that family dynamic. We'll see what we get. You know, what else we get over the course of this trial. But it just gives a little bit of perspective about how would we predict these people would behave under these types of circumstances, and are the theories that are being presented to us consistent with that? One of the strategies of abusers, oftentimes, push you to your limit. Push you to your limit, so you react. And then you get punished for that reaction. Then you get blamed for that reaction. That will be held against you. And now the abuser is the victim. That's part of the whole Darvo process. It's not me, it's you. You made me do it. All that stuff. These dynamics, you know, probably as old as time, probably as old as human relationships. They're just far too common for it to be, you know, some new thing, some situational thing that's like, you know, just evolved in recent history. It's probably been with us for a long time. Probably, I mean, I don't know. Something I'd be interested in maybe doing a little research on. If there's anybody in the chat that knows anything about this, definitely intrigued by it. But just kind of from an evolutionary standpoint, is there an argument that this is a strategy? That domestic violence is, you know, it's with us because it's a strategy. Control can work. I don't know. It's tough stuff to think about and talk about, but it's important because that is ultimately what this case is about. That's the allegation, is that that's what we're seeing here. We see this dynamic, and somehow it has reached this point of extreme, deliberate, explosive violence. It's not anybody's theory of the case. It doesn't matter in that sense, doesn't matter in the legal sense, but I think just in a human sense, as far as getting the perspective on justice and right and wrong and understanding what happened. I think it's important for that. But definitely not the defense strategy. Defense strategy, she wasn't hit by a car. She wasn't hit by a car. The Commonwealth was supposed to give me facts, science, and data to prove to me that she is. I haven't seen it yet. But yeah, today we're going to get some facts and science and data about blood testing. So I remember one of the things that jumped out from this guy's testimony in the first trial. I'm going to be very interested to see if it gets repeated. If it does get repeated, if it gets jumped on. He acknowledged that if you're doing a blood test for alcohol, you need to follow a different protocol than if you're taking a blood draw for some other type of test. And that's because normally when you take somebody's blood, you have to sanitize their skin. And the normal way to do that is with an alcohol swab. Alcohol swab, testing for alcohol, that's potentially going to be a problem right there. Because you can't, stick your sterile needle through alcohol and just trust that none of that is going to contaminate the sample that you're drawing. So they use an alternative type of sterilization when you're doing an alcohol draw, and commonly it's betadine or iodine or something like that. But that's not normally what's done in a hospital. Like you go into the hospital lab and you need blood work and you get your blood drawn. No, you're getting alcohol swabbed. Well, it was a remarkable thing that he said, because he acknowledged, yeah, you have these different protocols, and so you need to use an alternative sanitizer when you're testing for alcohol. And so they never use the alcohol swab for an alcohol test. Great, you shouldn't. But then he kind of went further to say all of the alcohol swabs have been removed from where they do the blood draws, like to make sure that it doesn't. This doesn't make any sense to me, because most of what you're doing is not alcohol blood draws. And it's not like a different ER or a different place where you go to get an alcohol blood draw. They don't have like a special designated alcohol blood draw room, as far as I know. And they just talked about her going down, with the phlebotomist to the place where the phlebotomist does the blood draws, and they've removed all the alcohol swabs. Really? So you swab everybody then with betadine or iodine? I really doubt it. People don't like that. It's, that brown stuff. It stinks. It's kind of gross. Yellow. It gets you a little yellow stain on your skin. People wouldn't like that. People wouldn't like that. No, you just nice clear alcohol, and after a few minutes it'll evaporate and no residue, and then you just have that that little piece of gauze and the stuff that I don't even know what you call that. It's like, it's not tape, but it's, I don't know, the sticky stuff that they wrap around to keep the gauze stuck there. So that was just a little odd. He's trying so hard to insist that there's absolutely no way that they swabbed Karen's arm with alcohol before they did the blood draw, that he took it to this extreme of, they don't even have alcohol swabs there. Well, but you would, because that's normal. That's normal. Unless you have a special alcohol blood draw room, which I would think you would have told me about that. You would tell me if that's how they didn't use an alcohol swab, because she was in the special room where they don't have any alcohol swabs, okay. But that's not what he said. He said they took the alcohol swabs out of the entire area. So it probably does. Again, does this matter to the theory of the case? No. If I'm the defense attorney, am I digging into this? No, because it really doesn't matter. I'm just interested to see if it comes up, how it comes up, because it was just such a peculiar thing to say. It seemed like to me. It was such a digging in insistence on how, they absolutely did it right in this case because they don't even have alcohol swabs there. It's very, very difficult to believe. And I do remember, one of the things from juror Ronnie's interviews. Several people on that jury the first time had some kind of medical background, nurses, EMTs, just different people in medical settings. If there's people with medical backgrounds on this jury, are they going to be like, I don't think so. I don't think so. I'm pretty sure they're going to have a lot of alcohol swabs over there in the, over there in the phlebotomist little blood draw area. Probably going to be mostly alcohol swabs. Because part of what he said too is normally the hospital, it's not part of their normal blood work. They don't normally test for alcohol. It's a special thing that they do. If they're just doing a normal blood work, they're not looking to see if you've got alcohol in your blood.
You are unmuted.
All right, why don't counsel calm down?
Going back to sidebar already. Back and forth this morning. So yeah, anyway, it's a very small thing. It was just something that I remembered. It caught my attention the first time, and I was looking over my notes this morning to see, remind me what we're going to get from him. The other stuff, the way that they handled his testimony the first time, as far as the cross examination that Miss Elizabeth Little did, it was. She raised the issues that you kind of expect to be raised if you're challenging a blood draw, a blood test. She raised the fact that the type of testing that they did, it's plasma testing, but the legal standards for DUI are based on whole blood content, whole blood volume. And so that means that the the alcohol concentration in the plasma is more concentrated than the alcohol concentration of the whole blood. And that's for a variety of different reasons that can affect that, but it mainly has to do with how many other like red blood cells and stuff like that do you have in your blood? And there's a lot of variability between people on that. So there's a kind of standard forensic factor that they use if they're going to calculate plasma concentration to whole blood concentration. And this is a common theme throughout alcohol testing is they make a lot of assumptions based on, we think this is the average. This is kind of how it works for the average. And so that's how we're just going to calculate it as if you're part of the average and make those assumptions. So with plasma concentration, the factor is 1.18 most of the time is the one that they use. And so that means the whole blood concentration is 118% more or less. No, let me get this. Let me make sure I'm saying this correctly. The blood plasma concentration is 113% more than the whole blood concentration. So they have to go back and calculate that if they're taking this plasma concentration and trying to convert that into blood. But again, it's an average. And some of the other stuff that that Ms. Little went into that I wasn't as familiar with is that what they're actually testing for with this type of alcohol testing in this setting. What I'm used to for blood testing for alcohol, testing a DUI or something like that, and they take your blood, send it off to the lab. They're doing gas chromatography, mass spectrometry, and this is where essentially what you're doing is you're measuring the alcohol because alcohol evaporates, that's in the head space, uh, of the tube once they, get everything separated. And so they go through and they chemically analyze that and get that type of measurement. It's a direct then basically measurement of the alcohol itself. This particular test that the hospital is doing, they're not directly measuring the alcohol. They're measuring metabolites. They're measuring byproducts of alcohol in the bloodstream. And then so you got all these levels, right? You're not measuring, so you're extrapolating from that, given the number of these metabolites, that translates into this amount of alcohol under this set of assumptions. So Ms. Little went in and raised what some of the other issues can be in terms of there can be other reasons why these metabolites are present. They're not the kinds of things that are only there because all this is in your system. They're naturally produced, and there was an implication that possibly Karen's MS could produce some of these metabolites as well.
What? You absolutely did not. Come on.
As far as this question goes, it's going to be state by state. It just depends. So in Washington, we have extremely strict rules for admitting blood and breath tests for alcohol in court. One of the issues we have here is that under our law, blood testing can only be performed by our state laboratory, and our state laboratory is slammed. So we're having issues, and we have for some time now, with significant backlogs. And that means that there are things like vehicular manslaughter cases and stuff like that, where you might be waiting a year. You might be waiting a year for the lab to get to that blood sample, because they don't have the option of just shipping it off to a private lab and doing whatever testing that lab does. So we are very, very strict on that, and it's caused some problems. Like, they've been trying to get some legislation passed to maybe modify that, but we're probably particularly strict. I don't think that's normal. So it's just going to depend on the state and what their requirements are for admitting this. Some might be more lenient. I really don't know. I mean, the fact that they're using it in Massachusetts suggests to me that yes, they can. Otherwise, it would have been challenged. So they can go in and criticize the foundation of it, but if they didn't have grounds to exclude it because it didn't meet some statutory or regulatory requirement, we would have heard that.
Hear ye. All persons having anything to do before the Honorable Beverly Canoni, the Justice of the Superior Court, hold it in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
For the record, before the court is Commonwealth versus Kerry and Reid, 22 CR 117. The parties are present. Our 18 jurors are present. The matter is on for trial.
Thank you very much, Madam Clerk. Good morning again, counsel. Good morning again, Ms. Reid.
Good morning, jurors. When we leave you out there, we're very much aware that we're leaving you in another room waiting, but we were working this morning to help streamline things, and we were successful, so we do appreciate your patience. I do have to ask you those questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone nodded affirmatively or said yes. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did any of you happen to see, hear, or read anything about this case since we left yesterday? No. Thank you. Everyone said no. All right, folks, as you know, this morning we are going on a view. And a view is simply, we're going to a place that you've heard about and that you will continue to hear about during the course of the trial. The purpose of the view is to help you better understand the evidence, which you'll hear during the course of the trial, and to help you appreciate the location and its surroundings. So the view that we're going on is part of the case, and it means that the observations that you make there can be used and considered by you in your deliberations on this case in reaching a verdict. So we're going to, you've heard 34 Fairview Road in Canton. The lawyers and I will accompany you. For the Commonwealth, we'll be accompanied by Attorney Brennan, and ADA Lally, ADA Schillinger, and for the defense, Attorney Yanetti and Attorney Little. The lawyers will have the opportunity, Mr. Yanetti and Mr. Brennan, have the opportunity to point out various things that they may want you to direct your attention to. Otherwise, there's no conversation between the lawyers and the jurors. So it's simply in a few minutes, you'll hear a little bit from each Mr. Brennan and Mr. Yanetti about what they want you to look at. And then when we get there, they'll direct you, look in this direction. They won't be able to testify to you, but they'll direct you on what they want you to look at. While you're in the view, you're not to take any notes, you're not to take any pictures, you're not to conduct any independent investigation at all during the view or any time during the trial. You're not to return to this scene or ask anybody to go back there for you. Today's your chance. You'll see photographs during the course of the trial, I bet, but today's your chance to really look at everything. So the best way to summarize a view is that your job is to simply stop and look. It's really no more complicated than that. So your responsibility is to see the place, observe it carefully, and to remember what you see. Now, during the trip to and from the view, and while at the view, you're not to discuss this case or anything about it with other jurors. We'll be accompanied by court officers who will direct you, and the court officers are there for all of us. So you'll be under their supervision until you're returned back here. So that's basically it. We'll be leaving in a few minutes, but first, before Madam Clerk swears the court officers in, Mr. Brennan, do you want to make a view opening?
May I?
Please.
Thank you, Your Honor. Good morning, ladies and gentlemen. As Her Honor explained to you, we're going to go to 34 Fairview Road. We have some exhibits that are already in evidence. You haven't had a long time to look at them, study them. But essentially, we're going to go to 34 Fairview Road. I ask you to pay attention to the street, the front yard of the home. And you'll see to the left side of the front yard in the corner, there'll be a car. It's the Lexus that we've spoken about, the defendant's Lexus. And you'll also see a flagpole and a fire hydrant. And so I'd ask you to take a look from different vantage points. Take a look from that area where the flagpole is, from where the fire hydrant is. And you'll see on the street before the grass is a little firm, concrete that comes up a little bit. I'd ask you just to note that as you go there. One thing I'd suggest is it's April 25th, 2025, not January 22nd, 2022. So the weather will be very different. The temperature will be different. The conditions will be different. We're going to go there probably at 10 o'clock. It won't be the same visibility. It won't be the same elements and the same weather. So keep that in mind when you're looking around. When you look at the Lexus, a couple things I'd ask you to look at. There is some evidence already in photographs of the right rear tail light. When you look at that tail light, it will be different than the photograph that is in evidence. It has been removed, so it will appear differently, and you'll later hear testimony explaining that process. Also, I'd ask you to make a note on the Lexus about the height of the bumper. I'd ask you to make note of the height of the right rear tail light. I also ask you to take note of, on the top of the hatchback, there is a part that protrudes. I ask you to take a look at that as well. Thank you very much.
All right. Thank you, Mr. Brennan. Mr. Yanetti?
Thank you, Your Honor. Good morning. As I told you at the start of the trial, my name is David Yanetti. I have an office in Boston and in Durham. And on behalf of my co-counsel, we will be accompanying you on the view that you will take today. Although the view is not evidence, I suggest to you that you will find it to be helpful, important, even necessary as you later do your investigation of this case within the four walls of this courtroom. You've already received into evidence, some photos and videos, but there is no substitute for your own two eyes. As we all know, photos and videos sometimes can be misleading in terms of relative distances, depending upon the perspective from which the photo is taken. But your eyes are the best computer that you could bring to the view. When we get to 34 Fairview, we will be pointing out certain things that we'd like you to observe. The house, the second floor window to that house, the 3 front doors in the front of the house, the driveway, the street, the front lawn, and the flagpole. And we'll be asking you specifically to consider the distance between that second floor front window and the front lawn. The distance between the front doors to the house and that front lawn. The distance between the driveway to the front lawn. And we'll be asking you to take a good look at that Lexus, to stand next to it, to size it up, to take it in. You were all selected as jurors because the parties entrusted that you would do a proper investigation of this case within this courtroom. On behalf of Ms. Reed, we have every confidence that you will do a proper investigation. Thank you.
All right,
You
jurors, I
will
have to make
not
something
know
very
well.
clear. So the purpose of this view is to help you better to understand the evidence that you'll hear during the trial and to help you appreciate the location and its surroundings. The view you'll take is part of this case. The observations that you make while on the view may be used and considered by you in your deliberations in reaching a verdict. So at the end of the trial, when I explain to you what is evidence and what is not, I'll remind you that your observations on this view can be used by you in your deliberations. Also, while you're in the view, the same way you're not to take any notes or photographs, you're not to conduct any investigation on this case. You really are simply to stop and look. Okay? Those are the instructions. We will see you in a few minutes. All right? Thank you. Oh, sorry. Madam Clerk has to swear in the court officers.
You could all raise your right hand, please. Do each of you solemnly swear that you will take the jury upon the premises in question and there suffer them to view the same or any property, place, or thing bearing upon the issue in the trial as the parties may think necessary? That you will not permit the parties to enter into a debate in the hearing of the jury, nor any person to speak to them unless it be the attorneys of record, then only to point out such places or things as they may deem expedient for the determination of the issues. That you'll keep the jury together until they shall return to court, unless the court shall otherwise order, so help you God. Thank you.
All right. Thank
All
you.
right, please, just follow me.
So I guess we're not getting Dr. Faller first. We have more confusion with the scheduling. Are we coming back after? I can't think we're coming back after the view to watch it, but I don't know. I guess we'll see where we get. Interesting approaches here. So Mr. Brennan wants them to look at the street in the front yard. He wants them to see the Lexus over there at the left corner, the flagpole and the fire hydrant. He wants them to look at it from different vantage points. He wants them to pay attention to a little berm at the street. Is that the raised rock hard ground that he's going to claim caused John's head injury? I don't know. But he wants us to pay attention to the little berm. He wants them to notice that the weather will be different. And as far as the Lexus, look at the right rear tail light, noticing that it's been different because it has been removed. But he wants them to pay attention to the height of the bumper and the tail light, as well as the protruding top of the hatchback. Protruding top of the hatchback. This is new thing too. Don't remember that playing a role in the last trial. Is that now going to be the cause of the raised surface that caused John's head injury? I don't know, because he hasn't told us why. We don't know. We don't know. Would have been nice to have kind of had a preview and opening, right? Especially from the party that's going to give us the facts, science, and data to prove a car accident. You already have a theory of how that accident happened, right? You have a mechanism by which it happened. What struck where, what happened, produced what evidence. And so if I've got the facts, science, and data on my side, and that's my case, that's what I'm going to tell them in my opening. Here's what happened. The Lexus did this. It hit John like that. Here's the effect it had on him. Here's the injuries that it produced. And here's how he ended up in his final resting spot. And so if it produces evidence, then I've been able to tell them, here's the evidence that's going to be on the Lexus. You're going to see it here. You're going to see it here. But he didn't tell them any of that. He just told them, take notice of it. They don't necessarily know why or what they're looking for. Mr. Yanetti, a little bit of a different approach. His concern is more about the relative distances between things. Because yes, photos and videos can be very misleading. They can be very misleading depending on the point of perspective and depending on your focal length. This is one of those things that I think it came up in the audit. I think it came up in the Canton audit. I don't remember if they went into much detail, but they also talked about it in Delphi, because in Delphi they had a highly trained, very good forensic photographer. And it's a skill set. It's a specific skill set because you are trying to minimize the distortion that you get from different focal lengths. If you're interested in this kind of thing, look sometime. Just do a Google or a YouTube search or something like that about people will do comparisons. Like portrait is a really good one, right? A portrait is a really good way to look at the different effect that you get from a very long lens and a very short lens. Typically, just pro tip guys, typically wide lenses up close tend to be more flattering for portraits than long lenses from far away. So that's just kind of the norm. I use a 35 millimeter lens if you're interested. Yeah, you get some, it's, people think that photography is like just a mirror image of reality. Oh no, it's not at all. It never has been. It never has been, even before like digital retouching and stuff like that. There's all kinds of effects in photography depending on, your focal length, your exposure. but then also how you develop that photograph. We learned when I was in high school and I was taking photography back in the old darkroom days. I loved the darkroom so much. I really enjoyed it. It's a great time. It's a little bit of magic that happens watching the image bloom onto the paper and the developing fluid. But you learn different techniques. Ansel Adams used oh God, what did he call it? Burning and I forget. Burning, and it wasn't shading. But anyway, what you do is you're exposing the paper on from a light source on an enlarger, goes through the negative and then onto the paper. And so to get, like, say you want this part of the photograph, to be a little bit lighter, then what you do is you like have a piece of paper that you just cut out everything except, cut out that little spot that you want to be brighter, and you hold that paper over it and you just kind of move it. So you get like blurring, you don't get a fixed line that shows, oh, there's, this part's dark, this part's light. You just hold it over for part of that exposure. And you just end up, that part is a little bit brighter. You do the opposite. If you want it to be a little bit darker, hold something over it, just move it while you're doing the exposure. So there's always been manipulation in photography, and just the nature of it is not, it's not to produce a mirror of reality. It creates an image, but different factors affect it. Oh, another fun thing you can look at sometime is like the difference between what the world looks like to different animals. And that's based on all kinds of things, like where that's a little bit different because that's getting into stereoscopic stuff. But it is like a hawk's vision, they can really zoom. They got that major telephoto. A fly vision, they got eyes on both sides of their heads and they have like a nearly 360 view of the world. Lenses are amazing things, but they are not necessarily giving you accurate depictions. They have their limitations. So definitely a focus of Mr. Yanetti, one that I can very much relate to and understand, because no, we did not have high-level forensic photography at the scene at 34 Fairview. Really at any point, but certainly not on the morning of January 29th when John was discovered. So we'll see, those will come into evidence, I presume. Very, very grainy, very low quality, dark, etc. But also the perspective, the perspective can tend to create a sense of distance. It can tend to create a sense of compression, just depending on focal length is the main thing. Focal length and vantage point. So he wants them to focus on the relative distances with their own eyes and not rely on the photographs, because those photographs might make that lawn seem a little bigger than it is, seem a little further away from the driveways than it is. And that's a very important point for the defense, that John wasn't there, because all these people in the house, leaving the house, driving by the house would have seen him. He would have been seen, and yet not a single person driving right by where he would have been lying there in the fresh snow saw him. So that's a very important point for the defense, is don't rely on these pictures. Use your own eyes to gauge how close these things are. Pay attention to the house, the second floor window, the 3 front doors, the driveway, street, front lawn, and flagpole. He wants them to pay attention to the distance between the second floor front window and the front lawn. He's already hinted at that a little bit, but we didn't hear that in opening, as far as tying together the significance of that. The significance of that, this is the Albert's bedroom. And all of this chaos was going on out in the front yard the morning that John was discovered. And nobody woke up, nobody came outside. And is that plausible? Is it plausible that somebody would just sleep through that? The difference between the distance between the front doors and the front lawn and the driveway and the front lawn. Very much getting to these people are leaving the house. They say they never saw John. You need to get a sense of how plausible that is. And then take a good look at the Lexus, size it up, take it in. Got that little dig in at the end. You will do a proper investigation. You will. We already know. We already know these guys didn't. We already know law enforcement didn't, but you will. I don't necessarily love that. It's a fun dig, right? That's a fun dig. Dunk. But they're not. No, they're not there to investigate, and they're not there to solve the crime. It's not their job. And that's not your theory. Your theory is reasonable doubt. Your theory is reasonable doubt. They're not there to investigate the crime and solve it. And you're kind of hinting that that's what they're going to do. Don't do that. They're not there to solve anything. They're there to ask questions. They're there to ask questions. So even though it's kind of a fun dunk, don't love it. Little bit of the same issue with size up the Lexus. Well, but what? They don't know. They don't know yet what they're supposed to be paying attention to. All they really know is that this Lexus was supposed to have been involved in a collision, hit John O'Keefe, and killed him. You know, hit him hard enough to kill him. But they don't really know what to look at. This is another area where they could have been, you know, we know there's going to be a jury view. We know they're going to get to see this stuff. There could have been a more specific description and opening. You know, they could have told them. We know John wasn't hit by the car because it doesn't line up with the with the injuries and with the damage to the vehicle. Okay, we got that. We got that from the 10,000 foot view. But you could have given them specifics. You could. You'd be like, look, you'll hear testimony that if a car struck a human body at the speed that the Commonwealth claims this accident took place, here's the type of damage you would expect. You'll hear testimony that the amount of force that would be required to produce the damage that you see on Karen's vehicle is significantly less than the forces that would be produced by a vehicle hitting a human body at a high rate of speed. You know, something like that. I don't know the specifics of what ARCCA is going to say. If ARCCA gets to say. But so that was an option. You know, of course, you don't have to. You don't have to. It's just if you were thinking down the road to the fact that they're going to go on this view, that is something you could have previewed for them. Now, I don't know when they decided to take this view. Obviously, I don't know. You know, whenever I just want to be clear, whenever I'm talking about like, here's what the defense did or what they could have done, or here's what the Commonwealth did or what they could have done and stuff, you know, there's so much I don't know going on behind the scenes. You know, there's been a whole planning process. There's been a whole there's just a whole thing, you know. I always want to kind of just claim like, yeah, I'm over here sitting in my house watching them do it. I'm not putting in the hours. They're over there 24/7 now living this case. I'm over here watching what they do and having some thoughts about it, and court's done, I get to go up and go outside and go mow my grass, go walk my dog. They are living with this case 24/7 right now. So we're in a very different position, very different context. I get that. I'm not trying to like suggest I'm better or I'm right or anything like that. Just pointing out there's different ways that things can be done. But it's just you could have. You could have, and then the jury would have already had the roadmap. You know, the clearer you can make the roadmap, the more specific you can make the roadmap, the easier it is for them to follow. And so when your theory is he wasn't hit by a car, there's reasons why. There's things you're going to rely on to make that case. And a lot of that is going to have to do with the condition of that vehicle. So you could spell it out for him. And then that's the nice thing about the trial is as the trial goes along, you get to remind them. And so now when you're giving them this presentation, what to look for, remember what I told you in opening about the forces involved. Pay attention to that Lexus and the amount of damage that's on that Lexus. And then they're going to be following you. They're going to understand. So part of the issue here is that this view is happening, from my perspective, pretty early. The jury still knows almost nothing about this case. Not my preference if I'm the defense lawyer, but also recognizing it's not going to be up to me. It's going to be up to Judge Canoni. She gets to decide when we do the view. She has decided right now. And so there it is. You gotta deal with that. Preference would be, for the defense standpoint, have that view like right before closing, maybe not that late, but just towards the end, after they have had quite a bit of time to evaluate what they've been heard and what they've heard and what they've been shown. Maybe between the Commonwealth's case and the defense case. I might like that if I'm the defense attorney, because then I can point out, here's the things based on everything the Commonwealth has just presented to you about their theory and so forth. Here's the things I want you to focus on, because these are the doubt things. Maybe then, but not right now, not before they know much about the case, because they don't know what matters. They don't know what matters. They can go and they can look around. Okay. But they don't know really why the relative distances matter. They don't really know how the flagpole, I mean, they got a general idea flagpole and the fire hydrant is kind of over there where John was. If they were like paying real close attention, they're going to have a general idea from the video that they watched. Okay, this is the general layout of where things were. But in terms of like, measurements, details, if the car was here, he ended up there, what does that mean? If a Jeep was parked here versus a Jeep wasn't parked here, here's how the sights would be, here's how the vehicles would have moved, like those types of things. And if I remember correctly, that came up with Juror Ronnie in the interview as well. That the view didn't really know what they were looking at. They didn't really know what they were looking at because it just happens too early in the process. So, knowing that, it's good to be helpful to the jury as much as possible. Is it absolutely critical to put all that in your opening so that the jury, knows what to look at? Not necessarily, but it is an option. It is just an option to be thinking down the road to that possibility, recognizing this was an issue last time. They didn't know what to look at. I'll tell them what matters in my opening so that they'll have a better idea when they go to that scene. I've already told them. This is what you need to be looking at on the car. This is what you need to be looking at in terms of the relative distances, why the bedroom matters, and so forth. I mean, they kind of did, but it just making a point, guys. Well, super short morning. It's looking like the link is like still going. Like they haven't killed the live stream. So I don't know if we're coming back after. That seems odd to me, but I don't know. Seems like this view is probably going to take a couple hours at a minimum. I don't know, how far is it from Dedham to Canton? Not Canton, Ohio. That's a long way. 20 minutes. Okay, they say 20 minutes down the interstate. So take them half an hour to drive there, stand around, look at it for, I don't know, half an hour back, maybe an hour and a half. This is going to take 2 hours. I don't know. I'll go through some of your comments and questions, and I guess I'll just see what unfolds. So Susan C has gifted 5 Andrea Burkhart memberships. Thank you so much for that, Susan. Really appreciate your support for the channel. MK is a new member as well. Welcome, MK. Luna Cat, I just want to tell them all to keep with facts, not all the emotions of each side. This is hard for everyone, and only the facts can be the facts. Yeah, you know, there's so many different perspectives on playing to emotions in trial, right? There would be some people that would tell you, some lawyers that would tell you, you wouldn't be doing a good job if you didn't try to emotionalize the trial, if you didn't try to tug on the heartstrings of the jury and capture their sympathies. Why? Because it's effective. Emotions are effective. They're persuasive. It's never been my strategy. You know, I've always been like you, more of a facts-based person. Feelings can be very misleading. Feelings don't necessarily, reflect reality. Feelings just can be very distorting. Think about things like, the 9 stages of grief, for example. You know somebody's gone, but you get in that anger stage. That feeling of anger, part of the processing. Anger is a distorting emotion. If you look back on your old memories through a lens of being angry, how is that going to color when you're doing that rewriting? How is that going to recolor that memory? And so it just it has a potential to distort your perspective, what you pay attention to, how you process it, and stuff like that. So to the extent that we're trying to get at some sort of truth, some sort of common understanding through the trial process, I don't consider feelings to be particularly helpful to that. But it is how humans work. It's how humans work. A lot of people would say, if the emotions have already led you to another direction, the facts aren't going to change your mind. Oh, that like hits home a little bit for me. It really does. It really does. That's your cognitive dissonance, right? You believe something and you have an emotional attachment to this belief. Maybe it's my own reliability of my memory, my own motivations for what I'm doing, my own goodwill as a person. Very fundamental one. Everybody, thinks they're a good person. Some people struggle with that because experience, life, treatment, abuse, things like that can devalue them, and they start to internalize that. But part of the reason why that is a troubling place to be is because it's in conflict. It's because you recognize that's wrong. I do have some value. That's part of why you struggle with it so much. But you have these fundamental beliefs, and so then something comes up that challenges that, and it's challenging. Your memory is incorrect. Well, what? That's gonna create a lot of feeling of discomfort in me. Why is, I can't rely on it. That's really undermining my core assumption. They think I'm lying. That undermines my view of myself as a good person. They think I'm here to just put her away. I'm just here to convict her. Goes to your motivation. And so there's different ways that people will react to that, but the most common one, you resolve it through your cognitive dissonance. You tell yourself a story that allows you to reconcile. You tell yourself a story that allows you to reconcile this competing, this challenging new information with what you already think and want to believe. So, yeah, I have a vivid memory, very vivid memory. That's the story you can tell. It happened even though the video, shows that it didn't. It still happened. The facts don't always win if the emotion is really compelling. So I'm with you, Luna Cat. I'm on the same page. I'm a very fact-focused person when I'm in trial. I don't necessarily know that that's right. I mean, there is a reason why there are so many instructions that the jury is given. There's so much law around, it's misconduct potentially to, try the case in a way that's going to inflame the passions of the jury, to make arguments that encourage them to decide things on the basis of emotion. Like, it's because we understand how powerful that is. That, the law, at least theoretically, is geared to restrict that. But if you're a realist about human processing and how it works, is that realistic? I struggle with this. I got to tell you, struggle with it. Liviosa, I am 100% FKR, but I can't shake off the odd feeling that I haven't seen Karen once be even a little bit emotional when speaking about John. Yeah, everybody is going to focus on Karen and what they think of her and what their perspective is and how she should behaving how you would want her to be behaving and stuff like that. And that's normal. That's normal. It's something you'll do if you're judgmental of somebody, certainly, and you want to look at reasons to be like, I think you suck anyway, and here's my confirmation. But it's also something that empathetic people will do because you want to understand things from their perspective. You want to put yourself in their shoes, and you think to yourself, God, if I were in that position, how would I act? And then if that doesn't correspond, if that's not congruent with what you see, then it might cause you to question a little bit, well, am I making the right assumptions here about this person and their perspectives and who they are and what they're dealing with? I have a lot of thoughts about this because I was a public defender. You don't get to pick your clients, and you're dealing with the volume, the volume work, the Walmart level work of the criminal justice system, not the occasional high profile case that gets people's attention, not the occasional wealthy person that gets caught up in it and goes and hires the private lawyer and to fight it and so forth. You're dealing with the mass of what gets moved through the criminal justice process. And so what you find, you know, criminality clusters, crime clusters, the people who are the perpetrators one day will be the victims the next day. It runs in families. You're tending to deal with stuff that has environmental, you know, socioeconomic, all these different kinds of correlations to you know, one of the best predictors of criminality, having a parent with a history of criminality, you know. One of the best predictors of you being locked up at some point in your life is if you had a parent who was locked up at some point in their life. So again, guys, we're talking about patterns and what people learn and what people are able to normalize. And you grow up in an environment where, you know, stealing stuff to pay the rent and get drugs and whatever is normal. You'd be surprised how normal that can seem to people and how weird it is, how kind of stupid it seems to, you know, go in and punch a clock to do some lame job. Like, why would you do that? And it's not, you know, it's not the fault of a child who's exposed to that environment and learns it. It's just not a particularly healthy lesson to learn. So I bring this up in response to this question because, you know, as a public defender, you don't get to pick your clients. And a lot of your clients, they've been there before. They've been there before. They're part of the system. They're part of the cluster. You know, they've learned bad stuff generationally. They're not necessarily somebody you're going to point at and be like, obviously it wasn't him because he's so upstanding, he would never do anything like this. No. So I'm very comfortable as a public defender with the fact that bad people can be and often are innocent. Just because you might not be a great person doesn't mean you committed every single bad thing that you're accused of. Even really bad people spend the majority of their time not committing crimes. And so you have to kind of, you know, it's part of what I just got used to having to do as a public defense attorney is depersonalize what's going on, you know. Just because somebody did something bad in the past doesn't mean they did this different bad thing that they're being accused of right now. You have to deal with that a lot. And so I see that play out in the situation of, you know, is Karen likable? Is Karen not likable? Is Karen showing, you know, the right emotion? And, you know, should she be saying different things? Just all that kind of thing. It's people trying to understand, you know, who is she and how does she work that would lead her to function like this? And is that something that I like? Is that something that I relate to? Does that seem like something a murderer would do? Or does that seem like something an innocent person would do? Very normal to scrutinize the defendant very closely and try to get a read on them, try to figure that out. But it's so important. It's so important to remember that, yeah, even if she sucks, even if she's like the worst person ever, she's awful, doesn't mean she committed the crime. The only way you know if she committed the crime is by looking at the evidence of whether she did it or not. And I feel for Karen. I do. And I want to be crystal clear as well, because we've talked about patterns. Okay. When we looked at those text messages, toxic patterns in the relationship. Is Karen a saint? I don't think Karen's a saint either. You know, talked about yesterday how I don't think John is a saint. And it's unfortunate that these messages are part of the justice for John, because from my perspective, it really tarnishes him. doesn't make him look good. Karen had her own role in that relationship. Is she a saint? No, she isn't. And we need to be thinking about this already in the context of this trial, because we already know about the little game she was playing with Higgins. Was that cool? No, it's really not. It's really not cool. I don't like what Karen did there. I'll just come out and say that. We haven't seen it yet in this trial. It'll come out. Karen's not a saint either. And we already know this, and we know it's going to come out at trial. But it doesn't mean she killed John. It doesn't mean she killed John. But I do. I feel a lot for her because the defendant is always going to be under a massive amount of scrutiny. And there isn't anything that they can do right. You're always going to have, at a bare minimum, some portion of the population that is very heavily influenced by the fact of an accusation, that are very judgmental, very quick to reach a decision, who will just decide she's guilty and that's it. And now we're closed. Brains are turned off, not taking in any new information, don't care. And then everything is going to be interpreted consistent with that. And so there's always going to be people that no matter what she does, in their minds, it proves she's guilty because they've already decided that. And that's that confirmation bias. Everything will be interpreted in a way that reaffirms what you already want to think. So if Karen gives interviews, wow, that makes her look so guilty because she won't even testify at trial, but she's out here saying all these things, and look at these ridiculous things that she said. If Karen doesn't give interviews, well, if I were innocent, I would be shouting it from the rooftops. I would tell it every opportunity that I had. There's no right thing that she can do that's going to please everybody. And so at some point, she just has to do what is authentic to her. And some people are not going to like it. And that's just how it is. That's life. Haters are everywhere. They're always out there. And that is what it is. You can let that bother you or not. You can let that, rock your boat or not. So I do. I have a lot of sympathy for Karen and the scrutiny that she's under. As far as her not being emotional when she speaks about John, I wouldn't want her to fake an emotion that she doesn't feel. I wouldn't want her to fake it. That would be worse. That would be inauthentic. If she doesn't actually feel it, to try to pretend that she did, it would be transparent. It would be, it would be the Amber Heard crying without tears, just like the acting coach told us. Her problem was she couldn't actually generate real tears when she needed to fake cry on screen. And then there she is in the courtroom, fake crying, not able to generate any tears. It's just, it's too obvious when you're faking it. She needs to be authentic. That's the most important thing, because then I can at least trust you to be honest. I don't have to like what I see, but at least I can trust that what I'm seeing is honest. And so, yeah, I think the reality is she doesn't have a lot of emotion when talking about John at this point. And would it be better if she did? I don't know. It's been 3 years. She had to have had very ambivalent feelings anyway, because it looks like this relationship was already kind of at a crisis point, and there's a lot of negative feelings are already built up at this point. She's already got one foot out the door. have the playing with the Higgins. We have her saying, I shouldn't even be coming to your house because every time I do, it causes problems. If you're not coming to the house and hanging out with the kids, you're not having a long-term relationship with a guy who's a caregiver to children. So she was probably, already kind of starting to emotionally callous with respect to John. Then it's been all this time. Then she's had this threat to her own well-being, her own future, her own security that she's had to deal with for the last 3 years. And so I do have sympathy for what I think to some people might come off as though she's so self-centered. She's focused on herself. She doesn't care about John. Well, yeah, her relationship with John was falling apart before this happened, and now she's having to fight for her life. I can sympathize with that. But it's tough. It's tough being a defendant, being under scrutiny, knowing that, people are going to be trying to read into everything that you do. So appreciate that comment. Noor with a super chat. Thank you so much for that. Noor. Tin Cat, I think it was helpful that on cross, Camerano agreed that the way everyone was acting that day was consistent with the past year of the relationship. Yeah, I mean, he wasn't bad. He wasn't like, he didn't like transform it into, I was like, now I was suspicious of this relationship and I thought maybe there was hidden abuse, or something like that. Like, he didn't go that far. He didn't go that far at all. I just noticed that little tweak between last time. He wouldn't even call it bickering. This time he volunteers. Well, it was bickering. They would bicker. But yeah, the bottom line is they weren't acting in a way that was unusual. There was no indication of some like serious shift that would tend to lead you to suspect maybe there's going to be some kind of escalation. Maybe there's something bubbling under the surface. No, it's just normal. This is how they always are. It's how they always are. I think that's I agree with you. I tend to think that that's helpful as well. The rural juror, they wouldn't get rid of all alcohol swabs because other labs that need the alcohol as opposed to the iodine or allergies to iodine or shellfish, etc. Yeah, it was just, I mean, I have never worked in a hospital. I had blood work plenty of times. Been down to that lab to get the draw done. Obviously not at this hospital, at my own hospital, but different places, they tend to kind of more or less be set up the same. And yeah, you get swabbed with alcohol every single time. I mean, very, very difficult for me to believe that there's no alcohol swab available in the area of this hospital where they do the blood draws. It was just such a strange thing to say. I didn't know people would be allergic to iodine. I didn't know. That's news to me. So yeah, that would be all the more reason why you think iodine wouldn't be your default. If you've got a potential allergen that can be your default, or something that is not a potential allergen but could undermine a tiny percentage of some of the tests that you do in that hospital. It just seems like you would go with the one with the potential to, if you're specifically testing for alcohol, could be an issue, but most of the time you're not testing for alcohol anyway. 0 patients. Ugh, it's not about her being drunk. She was. Yeah, I mean, I buy that she was buzzed and she probably shouldn't have been driving. I buy that she was, probably DUI. How much? How much I think is fair, is she blackout drunk? I don't think so. She's not described that way by anybody. It doesn't sound or look, when we watch that surveillance video from the bars in the last trial, doesn't look like she drank that much. Yeah, a lot of stuff can go on behind closed doors, but you know, and kind of what I'm thinking about is just in terms of tolerance, alcohol tolerance. People with severe alcoholism can have, I mean, people with severe alcoholism, you will see blood alcohol concentrations from these blood draws that would kill. It would kill me. I'm pretty lightweight. I don't drink much anymore, like at all. Too old, man. It's too hard on me. It hits me too much now, like the poison part. You don't recover, don't deal with it very well. And I've kind of always been that person who, like, if I am gonna have a drink or a couple drinks or whatever at a party, I'm gonna have a drink and then I'm gonna drink a big ass glass of water. I drink a lot of water before I have that second drink. You just get so dehydrated. It's so bad for you. And so, yeah, if she drinks a lot, if she's like a severe alcoholic, she can drink a lot and not show it. That you would expect that. She could have a very high blood alcohol concentration and still be pretty functional. Interested. I know we got some lawyers in the chat. What's the highest BAC? What's the highest BAC you've ever seen in a case, in a police report? What's the highest one you've ever seen? I'll give you mine. 0.45. 0.45. Nearly half of somebody's blood was alcohol. This guy was this was not a case I was a lawyer on. This is actually when I worked in a court. I was a court clerk. And this guy he was just, he's severely alcoholic. He would constantly get arrested for public intoxication. And he'd be brought in and they'd dry him out, which is like one of the unhealthiest things you can possibly do with an alcoholic is dry them out without medical intervention. Like, you can kill somebody that way. You can die from alcohol withdrawal. You typically can't die from like heroin withdrawal, opioid withdrawal. It's very painful, very unpleasant, but it's typically not going to kill you. Alcohol withdrawal can kill you. But they dry him out and, it's a minor petty charge. He'd be back out and next time we'd see him again. Oh, what's his blood alcohol content this time? 0.45. It's the highest I've ever seen. That would kill me. That would kill me. But so for that guy, you see him at like a 0.2, 0.25, more than 3 times the little legal limit. That's like his baseline. That's his function level. So you can have a lot of variation. If she's a serious alcoholic, yeah, she could drink a lot more. She would have a high tolerance. Wouldn't necessarily show it in her behavior, would still be highly functional. It's just that I don't really have any evidence of that. I really don't have any evidence of that. I mean, when you're talking about that degree of alcoholism, the quantities that are consumed are mind-blowing. Mind-blowing. And catches up with you health-wise. Catches up with you health-wise. Karen's got a lot of health problems, but no indication I've seen that she's got anything alcoholism related. And typically when you have MS, alcohol isn't really good for it. Not saying you're everybody's gonna go sober. Obviously Karen didn't, but typically, it's gonna be a thing to minimize. Save for special occasions. Stressful on the body. The body needs to avoid stress when you have MS. So yeah, I mean, I think this is just really a question of like, how drunk was she? Does it even matter? It doesn't matter to the defense. Who cares if she was drunk? Who cares if she was blackout drunk? It doesn't matter. Scientifically, John was not hit by a car. So it doesn't matter. But it's just part of the thought process that goes around with trying to understand what happened in this case. You know, the explanations I've seen. Well, you know, she was just so blackout drunk that's why she got in the rage, and then she doesn't remember. And you know, I don't buy that. I don't buy that. I don't think she was that drunk. But yeah, it as far as the defense is concerned, it doesn't matter. It doesn't matter. She could have been out of her skull. She still didn't hit him with a car. Jay Coop, why is the jury going so early in the case? I feel like they will forget, they will be shocked how small the yard is. Because it's up to the judge. Because it's up to the judge to decide when they go on the view. That's why they're going right now. Now, why did she decide to do it now? Oh, I don't know. We don't know. She hasn't told us. She hasn't told us. Convenience. Maybe purposeful. Maybe she's, you know, thinking, oh, well, we want them to get this information in before their heads are too full with other stuff. Maybe she could be thinking, by the time they know enough to know how all this fits together, they're gonna draw some really strong conclusions from that scene. We better not, because boy, that yard is small. She could be thinking, I don't know. I don't know what she's thinking. But yeah, I agree. This is early. It's way too early for my liking. I don't think it helps either side for it to be this early. You know, the point of this view and going to this trouble is so that it's helpful for the jury, so that they can understand the case better. And they don't have enough context at this point for it to really help them understand. Memories are not photographs. They don't even get to take notes out there. They don't even get to take notes out there. So 2 weeks down the road, the Commonwealth's going to rest, and they're going to have, you know, this accumulation of all these news stories and these facts and these theories and these data, right? Because the Commonwealth is going to give us science, facts, and data. And they're going to have to just rely on the non-photographs that they have in their mind to reconcile all that with what they've heard. And so what's going to happen? What's going to happen? How does memory work? How does memory work? You're going to rewrite it based on the impressions that you formed as the trial has gone on. If we get through the Commonwealth's case and the jury's like, I really like all of these witnesses who left the house and said that they never saw John, and there's so many of them, like they can't have all made it up. Kind of think your mind is going to rewrite that. Suddenly the lawn seems a lot bigger, a lot darker. You're going to be able to envision it in a way that would be consistent with what you want to believe, which is, I like these people. I don't think they're lying. I think they were telling the truth. You're going to give them a little help. If you think these people are sketch, look at how shady they're acting, and then they're all trying to claim that they left us. They all went right by him and nobody saw him. No, it's going to shrink. It's going to shrink in your mind. And that front lawn is now a tiny little postage stamp. And John is practically right outside the dining room window. So it really doesn't help either side for this view to be so early in this case. Because they can't photograph it in their minds. Their minds are just going to operate the same as everybody else's. They don't know how to make sense of it right now. They don't know what's important, so they don't know what to focus on and fix and try to store away. They don't have the context for it. If we did it later, they would already know, okay, here's how the Commonwealth says it went down. If I'm trying to evaluate that, does that seem realistic? Does that seem reliable? When I look at the scene, I'm going to be thinking about different things. I'm going to be focusing on different things. Different things from the case might be important to me. I might not care at all about the fact that nobody woke up, the light never came on, nobody ever came outside. I mean, I'd be like, they were trashed. They probably passed out. Of course they didn't wake up. So I might not care about that at all. But I might really, really care about what exactly is the angle between the point of impact where Karen's car would have hit John and where John ended up. And what does that tell me about the mechanism of how this accident took place? By the time you've heard all the evidence, that might be really important to you. And so if you're going out to the scene, that's what you're going to be paying attention to. But you didn't know that at the time. You didn't know that ahead of time. And so you just kind of took it for granted that they told me I need to look at the front window. So I paid attention to the front window. But then I get through the case and that doesn't matter. It's way more helpful for the jury for it to be later. So why we're doing it now, I don't know. Judge Bev didn't tell us. The rural juror, the defense should point out that Karen could have drank more after getting home, which would impact the extrapolation. 100%. Extrapolation is only as good as the assumptions that go into it. And there are so many assumptions that go into it. One of them, very important one, is the point of last alcohol consumption. It's based on constants in the rate of alcohol absorption after you drink it, and then alcohol leaving your system. And so it takes that measurement at a certain point and then infers, okay, if this is the point of last alcohol consumption, this is where you would be in that process. And because that's where you would be in this process, we can evaluate then how much alcohol you would have had in your body at the time that we're interested in. Because you're not taking the blood alcohol sample at the time of the accident. When you are actually like driving under the influence and killing somebody or not, you're taking it an hour, or in this case, 9 hours later. So in this particular case, this came up with, what was that guy's name? Cornelius Harrell. Was that him? He was the guy. He was like one of my favorite witnesses. I think he was one of Jeff's favorite witnesses too. He was the extrapolation guy from the Massachusetts State Police Lab, and he didn't give a shit, man. He's like, yeah, maybe it is a lot of assumptions, not necessarily very precise. Like he would kind of give it all up that, yeah, this might actually be bullshit. But it would come out through him. It wouldn't come out through this particular doctor, because the doctor isn't who did the retrograde extrapolation. It would come out through Cornelius. I think it's Cornelius Harrell. But yeah, very important assumption. When was the last alcohol consumed? Because that tells you where you're at in that curve of absorption and excretion. And so he had done it back at like 12:30, 12:45, something like that. And that was to give her the benefit, the benefit of the doubt of, actually, I don't even remember. Maybe it was back at 12. Anyway, he was putting it, sometime before the accident, like after they left the bar, assuming she's not drinking in the car, assuming, kind of giving her the benefit of the doubt of that assumption. But the problem is, if Karen Reed, and I think I said this at the time, I've certainly thought it. If Karen Reed goes home, she leaves John there, she's finally like, fuck this guy. He's been telling me to go away like for months. He's been texting me. He tells me I suck. He doesn't even like me. Doesn't want me around his kids. doesn't give a shit about how I feel. I try to get him to apologize, and he won't even pick up my call. You know, not interested, fine, I'm done. He wants to leave me sitting out here while he's in there partying. I'm out. Okay. She's reached her breaking point. She's going back to his house because the kids, you know, you're pissed. Might you have a little bit more to drink? Might you have a little bit more to drink? You might. You might. I don't know if she did. I'd love to ask her. That would be, you know, if I'm her lawyer and I can ask her that in private, confidence, where nobody would ever know the answer, I'd love to know. You know, I'd love to know. Did you happen to go home and have a few more drinks? Because it wouldn't surprise me, just given this this whole context, this whole situation. You're really pissed. And we heard in those texts earlier, you know, she does seem to, I'm not going to say like self-medicate with alcohol. I don't know if it's necessarily like that big, but she has that attitude of like, oh, you know, it's been a shit day. Let's get a drink. It'll make it better. You know, it's a CNS depressant. It's that paradoxical effect. Doesn't actually make you feel better. It actually is a depressant, but it numbs bad stuff. It numbs bad feelings. So, you know, shit day, go have a drink, numb it, make it go away. You're really pissed at your boyfriend, and that's kind of your coping. It's a common coping mechanism for you. Plus, you've already been drinking this evening, so you know, judgment impaired, inhibitions lowered, etc. Might you have a little bit more to drink? You might, and yeah, that would destroy the entire assumption behind the retrograde extrapolation. It would destroy it. And so, you know, you don't have to have Karen on the stand to say that. You can just point out, like you're saying with Cornelius Harrell. Your assumption assumes that she had nothing to drink after she left the waterfall. You have no idea if she went home and had a few drinks. And if she went home and had a few drinks because she was pissed, that would blow up your entire calculation. Yeah. He would have to acknowledge all that. And he probably would very cheerfully, because he did last time. He was very willing to acknowledge, yeah, this is kind of trash, but we do it anyway. It's a very important point. It's only as good as the assumptions that go into it. Laura Michelle, can the defense play Karen's entire interview in closing? The defense can only play Karen's entire interview in closing if the entire interview is admitted into evidence. And the only way, there's two ways the entire interview is getting admitted into evidence. One is that the Commonwealth offers it, which is not going to happen. The Commonwealth prefers to cherry pick it. That's what benefits their position. They want to take it out of context and just highlight the things. They don't want the jury to see the other stuff where, you know, she comes off as sympathetic, or, you know, she provides more explanations and stuff like that. So that's one option, but that isn't going to happen. The only other way the entire interview comes in is because the defense convinces Judge Cannoni that under the rule of completeness, in order to fairly evaluate the meaning of Karen's statements in the clips that the Commonwealth is playing, they need to hear the entire interview. It's the only way for it to be fair. And I'll leave you to your own assumptions about whether you think that is likely to happen or not. So that's the only way they can play it all in closing, is if it is in evidence. You can't bring in stuff that's not in evidence in your closing. So if it's in evidence, they can. But if it's not in evidence, no, they can't. Oh, I saw this. Yes, I do. I think the view is too early in the case. We already talked about that a little bit. I would much prefer for it to be later. My choice. I'm the defense attorney on here. I want it at the conclusion of the Commonwealth's case. So now we are perfectly positioned that I can tell you all the things I want you to look at to show you that the Commonwealth's full of shit. and then I already have a preview of what I'm going to be showing you. You know, what my case is going to be, and where I have a better argument on the no collision stuff than the Commonwealth does. And I'm going to be able to tell you to look at that too. So it's just going to have better context. It's going to be more meaningful. Michael Milano, stall now so they can complain how long the defense is taking, just like they did last trial. Yeah, I know. Mr. Lally can call every single person who is on scene for like 2 minutes to say the same things that all of the other witnesses said, many of which are completely immaterial, like who shoveled the fire department apron and why is that important to do that? I mean, wasted days on this repetitive stuff. And it's the defense who gets, can we move it along? Can we move it along? Are you going to be finished? You think you're going to get done? Yeah, I mean, I will give credit where I see it. Hank so far is putting on a much better case than Mr. Lally in that respect. He is putting on a much more streamlined case. Now, we're only a week in and he's a little all over the place. So, like, I don't know if we're going to go back and hear from the other firefighters now. I assume we are, but I don't know. Maybe, are we going to hear from all of them like we did with Lally? Maybe. Is he going to cherry pick just the ones who testified before? I hit him. Which is going to give us Flamati and McLaughlin. But leave out Kelly because he didn't hear it. Let the defense call Kelly. Is it going to be like that? I don't know. We'll have to see. He's a little bit all over the place in terms of just his chronology and his organization. If I'm brand new to this case, I'm not sure I'm completely following it. It's kind of like I have a puzzle where, you know, some pieces are starting to come together. You know, I got a little corner over here and a little clump of matching things over here, but I don't necessarily see the whole picture. It's kind of how I feel like Mr. Brennan is putting his case together. But I will definitely give him credit for, so far, he's more streamlined. He's not spending nearly as much time with these witnesses. He seems to be doing a much better job of getting out what he wants to get out and then just being done. Not meandering through like the totality of anything they have to say, regardless of whether it's significant or not. Now, I may very well disagree with him about what's significant and what isn't, just like I do, you know, on occasion with the defense. But he's at least much more focused than Mr. Lally was. So I do have to give him some credit for that because that will be more efficient. That will move us along quicker. By his own estimate, case 2 to 3 weeks for the Commonwealth. That's less time than it took him with Mr. Lally. Mr. Lally took what, like 5? I mean, he took a long time. So already saving a little bit of time there. But yeah, why do I suspect if there starts to be a little bit of a time crunch, it won't be because Mr. Brennan forgot to call witnesses yesterday, I guess. Confusion. I don't know about that. It won't be that. It will be, you know, defense, can you move it along? It'll be defense, can you move it along? We talked a little bit about it yesterday because, you know, there are times when I don't take issue with her doing that. I didn't really mind it during the cross of Daniel Whitley because I kind of agreed it's really not going anywhere. The point's been made. You're belaboring it. You're just being combative for the sake of being combative. You're doing the combat for its own sake so that you can beat this guy down and force him to say the thing the way you want him to say it. And, you know, I understand some people who like the combat aspect of the trial. They want to see a good throwdown. They like a good fight. They like that. They like that. They're enjoying it. The conflict avoidant people, they are hating it right now. They are hating it. They are so uncomfortable sitting there watching Mr. Yanetti go after this guy for what might seem like nitpicky things. Were they that important? Were they like critical facts to the case? Not according to their theory. But point just being, I can kind of sympathize with it because she does have that role as the judge. She has to maintain the order in the courtroom. She is, you know, responsible for keeping things moving. It's just the double standard yet again that we always see. There was no get it moving, Mr. Lally, with just insane, pointless repetition. But you know, the defense needs to get their people here. They need to be, you know, they need to be on the ball. And we're seeing that same pattern again. You know, Mr. Brennan doesn't call witnesses for a whole afternoon. Most judges, that's going to piss you off. Most judges is going to be like, that's you're wasting our time. You're wasting the jury's time. You need to be more on the ball, more respectful of the commitment that everybody else is making to this process. It's not just about you. Okay? You need to get your shit in order. Most judges are going to be very pissed about that. Not Bev. Oh, there's just some confusion, so we get a half day. But if it was the defense, yep. Law and Lumber. Hey, Rob. Brennan's theory is the opposite of defense. He just wants to hear the defense theory first because that's how this is supposed to work, right? Yeah, just whatever they say, I don't say. That was my, you know, it's kind of my read on the opening. It's the head fake. He's trying to say we got the facts, science, and data, you know, science, facts, and data on our side. He doesn't. We all know he doesn't because we saw the last trial. We saw Trooper Paul versus ARCCA. Okay. And we know, you know, we know who has the weight of the science on their side. But he's going to head fake that out there just in case he can, you know, outmaneuver him and have a credible argument to make there. But then he told us what's really going on, his real backup position. Well, it'll be corroborated by Karen saying, I hit him. It's just the I hit him case again. So yeah, in terms of the facts, science, facts, and data, he has to be reactive to the defense because it's not on his side. And that explains so much why he's desperate to keep ARCCA out and why he will, you know, like Emily pointed out, if ARCCA having a different opinion than your expert is going to destroy your case has bigger problems. But it's because his case is reactive to the defense case that this is a huge concern for him. It's a huge concern because if he doesn't know how to go in and criticize and nitpick and try to pick apart what the defense is saying, then he's going to have to concede the ground of the science, facts, and data. And that's not really a good place to be in. You can't get up and be like, ladies and gentlemen of the jury, even though the facts, science, and data make it really look like there wasn't a car accident here, Karen said so, and so it happened. You can't say the quiet part out loud. That is, in fact, what he's doing. But you can't say it out loud. You can't call it out like that because then the absurdity of that is a little bit too immediately apparent. So yeah, that's the only way. That's the only way he can try to win that battle. Try to claim that victory with the science, facts, and data is if he can go in and nitpick the defense. Because what the Commonwealth has been able to come up with of their own accord is trash. Bella's mom. God, you guys with the names, with the screen names. Bella's mom. How do we really know if feds are laying in wait to come in and reopen the invoice litigation if Karen is acquitted? As far as I'm concerned, we don't really know anything about the FBI other than what has been made public through the TUI process, because we haven't heard it from the FBI. We haven't heard it through any type of official channel. And that's pretty much where I'm at on that. I don't really see why the prosecutor and the chief of police would be the only people that would be notified. Now, are the defense necessarily going to tell me if they've been notified? Maybe not. It's possible that they were. It's just a bit odd to me that given the public nature of this case, the fact that this investigation has been acknowledged, it is out there. They provided the TUI stuff. Josh Levy wrote that letter to the judge explaining our view on this trial is quite a bit different than theirs. It's already out there. If we're going to publicize the fact that it's being over, that it's over, why wouldn't we just say so ourselves? Why are we going to use these people as mouthpieces? I don't know. Doesn't particularly make a lot of sense to me. So I think it's justified to take a skeptical position about it. Obviously, as we know, law enforcement can and does lie to the people that they're investigating. They can lie to anybody, really. They can lie to witnesses too if they want to. They can lie, and so there's no guarantee that they're telling the truth to these people. I think there's plenty of reason to be skeptical until you just, time will tell. If nothing happens, more likely that they were right, that this is true. They really did call these people and tell them, and they were telling the truth when they told them that the investigation was over. Or we get more information, or somebody, finally speaks with their own mouth, maybe after this trial is over. I don't know. I don't know. But I think skepticism on that is justified. Lawyer nurse, HB is going to say the top of the hatch is the cause of the right eye laceration and hematoma as per Commonwealth reconstruction expert. Thanks for your clear commentary. So his arm was out, but the hatchback hit him over the eye. Now we have to position John for this to happen. This is no longer a side swipe, right? If his head and his arm, this side of his arm are like at the tail light and the hatch. I'll be very interested in seeing this reconstruction, because I have a hard time visualizing that, and then I have a hard time squaring that with, so then he was hit full center of mass, which means the bumper would have hit him first, unless he's like leaning. The car would have made contact with his center of mass to project him. So where are the injuries? Where are the injuries? If all he has from the car hitting him are some cuts, some scratches, no breaking, no swelling even, really, no bruising, no contusion on his arm, just these scratches and a little eye cut. That didn't hit him hard enough to project him. Not buying it. Absolutely not buying that. Oh my God. If this is where they're going, I mean, I'll take your word for it. If this is where they're going, that honestly sounds it might be even worse than Trooper Paul's arm sideswipe. I mean, the arm sideswipe at least explains why there's no injuries on the rest of his body. Really doesn't explain the movement, the projection, and where he ended up. It's not how it's going to work if you're just hitting the arm. Your arm is not your center of mass, so it's not going to move your center of mass. This is going to be a problem for his lack of injuries unless, yeah, I don't know. I gotta see. I gotta see how they explain this. Thank you for that. I'll be interested to watch that play out. Jennifer Hoff, we appreciate your time, Andrea. Well, thank you, Jennifer. I appreciate all you guys being with us here this morning. Appreciate you joining us. It's part of what makes it fun for me too. Have a little watch party. We're all watching this trial anyway. Have a little watch party. Talk about what we think. Have this awesome chat. Bloodhound 09. Can jurors pace off distances, or is that considered investigating? I mean, I would think they can. I would think they can. They just can't take a note of it. They'd have to like remember and then, write it down when they get back. Would that be considered investigating? I don't know. It's not real clear. They get to look and they get to evaluate, but they don't get to like analyze what they're actually faced with. I mean, that seems like if pacing off distances is investigation, then that kind of seems like where the line is drawn. You may be an empty vessel, but you may not seek to process the information that is presented to you. That's I don't know. It's a great question. I guess for practical purposes, if we were to ask Judge Cannoni this question, what do we think the answer would be? Is that investigating according to the judge? What do you think? I'm willing to think she'd probably think it's investigating. Judge Bev's Warzel gummage hair is sorry if I got that wrong. I don't know if this is a reference I'm maybe missing, but AB, what do you make of Kerri scurrying over to grab John O'Keefe's phone as soon as his body was removed and taking it back to her car before handing it over to cops later on? Very sus to me, wondering if Jen was in there with her. What's sus to me mostly about the phone is just how it got to where it ended up with Proctor and Buchanan, and whose hands it passed through along the way. Kerri picking up the phone doesn't particularly alarm me. It really doesn't, because if she did see it there and like knew, she saw it being left. Yeah, you might pick it up, make sure it doesn't get left. Give it back to his family, hold it for him, when you see him at the hospital. I don't know if people are necessarily thinking they're most logically with a circumstance like this, staring him in the face. She's not necessarily thinking this is a crime scene. The police should be in charge of this phone because this phone is evidence. I shouldn't be involved with it at all. I don't know that that's necessarily their responsibility. And so she's still in this mindset. I'm giving her the benefit of the doubt. You know, if she's in a mindset of we're responding to this emergency situation and we're helping my friend, we're helping his family, and oh, I see his thing that it might be lost if it just gets left there, and he will want it if he gets better. His family might want it. Yeah, you know, I might pick it up. I can see that. Now, why the law enforcement on the scene is allowing that to happen is a different question. Why the law enforcement on the scene is allowing her to take the phone, that's a different question. But as far as her doing it, I can see a good faith explanation for that. But I really want to know, who did she give the phone to? Which first responder? Because that's where my, you know, my spidey sense is tingling, if you will. If the phone was messed with, could have been Proctor, or it could have been somebody whose hands it passed through on the way to Proctor. The lack of chain of custody of the phone is a concern. So I want to solve it. So if her explanation is I gave it to a first responder, I already said I'm asking every single one of them. Did Kerry Roberts give you that phone? Because somebody needs to close the chain of custody for the Commonwealth, or I am going to the jury at the end of this case and I am telling you that right there is reasonable doubt. They can't tell you where John's phone has been and who has done what with it. They can't assure you that that phone is in the same condition as it was when, according to the Commonwealth's theory, John O'Keefe was hit, projected, fell on his phone, and laid there, you know, until he was found the following morning. They can't assure you it's in the same condition, that it has integrity, that it hasn't been tampered with, that data that could be incriminating hasn't been modified, particularly when we already have evidence of some sus behavior, not just in the people at the house, but also the investigators, potentially collaboration to some extent to get the story in line. If they can't, the Commonwealth can't close the loop on this chain of custody problem, I'm arguing that's reasonable doubt. Because they want you to rely on all this health data, Waze data, all this stuff on the phone, but they can't assure you that phone has integrity because they don't know where it's been. No first responder steps up and takes it. Now we're back looking at Kerry Roberts again. Okay. I'm willing to give her the benefit of the doubt. On the whole, I misunderstood the question. At least in the sense of, I don't think it's technically perjury. I don't think it would or should be charged as perjury. It would be an abuse, in my perspective, of the prosecutorial power to charge that with as perjury. Because that is a conceivable explanation. Perjury is a very high bar. It has to be an intentional misstatement. You can't prove that. And I'm in favor of fewer frivolous prosecutions overall. Not just, no frivolous prosecutions against the people I like, but do the frivolous prosecutions against the people I don't know. I want fewer of them altogether. It does not fix the harassment of the duck people and the Turtle Boy charges and Karen Reed herself. being charged with things that shouldn't be charged. It doesn't fix that to do more bad charging. It doesn't. So I don't think it's perjury. I'm willing to give her the benefit of the doubt, at least for purposes of argument. Yeah, okay, it's plausible. She had heard Jen McCabe say that. They were doing the timeline together. I could see how that question could be misunderstood as asking her what she had heard, as in, what have you been told about this incident, versus what have you heard, as in, what did you hear with your own ears at the scene? It's not implausible. But I might reconsider that if now I also can't back up her story that she gave it to a first responder. Every single one of the first responders who was there, it's like, yeah, no, I didn't give it. I didn't get it. Well, now then I'm really questioning who Kerry Roberts gave that phone to. I'm really questioning who she gave that phone to, and not as much plausible deniability around the phone, the custody of the phone, in my perspective, as around, answering a bad Lally question. Lally's questions are terrible. They were awful. I couldn't follow half of them. He would think his way through the question without knowing where he's going or where he's going to end up, and just stammer his way through. Terrible, terrible questioner. But I gave it to a first responder. If you didn't, that just seems a little hard to misremember. Seems a little hard to misremember, particularly when you sat down with Jen McCabe and put all that effort into making a timeline. You made a timeline, but back when it was fresh in your mind, you didn't write down, note, clarify who you gave that phone to. Maybe you don't know the person's name. Was it a firefighter or a police officer? What did they look like? What were the circumstances where that happened? If you're like working over your memory in the following days to create the timeline, wouldn't you have like solidified that? So if I think Kerry's lying about the phone, now I'm going to be much more likely to think Kerry's also lying about that answer she gave at the grand jury. She loses the benefit of the doubt. Oh, she says she misheard the question, but I don't buy her explanation because she lied to me about what she did with the phone. That's kind of how all that fits together. As far as, the effect on her credibility and stuff. That's really how I see it. I can understand her picking it up. I can imagine a scenario where, she is acting in good faith, and that is what a person acting in good faith would do. But lying about who you gave it to, a lot harder for me to find good faith in that. And then if that's the case, and there is no first responder to whom you gave that phone, I'm gonna be starting to think you might have lied about it. And if you lied about that, what else? What else did you lie about? Sham wow. Can the defense sprinkle in clips of Karen's interviews in their case in chief? So once again, the limitation with the interviews for Karen to introduce them is that they are hearsay when she introduces them. When the Commonwealth introduces them, they are not, because they fit within an exception to the hearsay rule. They are admissions, or just in Massachusetts, they interpret it broadly as statements of a party opponent. So Commonwealth is on the caption, Karen Reed is on the caption, opposite sides of the case. Karen Reed is the party opponent to the Commonwealth. They can enter her statements. The Commonwealth is in the advantageous position in a criminal case where they are not a witness. They are a prosecutor. And the witnesses that they rely on are not the Commonwealth. They are just witnesses. So Karen doesn't have a party opponent in a criminal case that this applies to, that she would be able to admit statements under this hearsay exception. But the Commonwealth can admit her as a statement as a party opponent. When she wants to introduce them, they're hearsay. So she can't. They have to fit within some type of hearsay exception. The number one exception that will apply for a defendant to be able to introduce their own statements after the prosecution has entered some is the rule of completeness. And that just says if it's necessary to give context, to understand the portion of the statement that the Commonwealth has presented, to consider more of the statement, then the defense can put in that more of the statement that is necessary to be able to understand the part that the Commonwealth said. That's the limit. And so some judges might interpret that broadly. Some judges will interpret that narrowly. Some judges will say, not very many, but some will say, for example, that this happens all the time with interrogations, defendant interrogations. Person will say, I didn't do it, I didn't do it, I didn't do it, I didn't do it, I didn't do it. And 5 hours in, been broken down, maybe I did it. And the Commonwealth or the prosecution will go in, just tell the jury that part. Said maybe I did it. Some judges, not very many, but some would say, you can play that entire interview. If they're going to cherry pick that, you defense, you can play that entire interview because it's necessary to put it in context to see, where it happened, understand it, evaluate it. Did he really mean it? Is this the product of coercion, etc., duress? Oh, they're moving the camera around in the courtroom. So I don't know. Maybe they are going to come back. I don't know. I'm just hanging out to see, notice some action there. Not looking at the fan now. They're looking at the window blinds. They're back in session. Wow.
Who is your next witness?
Your Honor, the Commonwealth called Dr. Garrey Faller to the stand.
Thank you.
That was fast. Glad we stuck around.
Start us off, sorry.
Do you solemnly swear that the testimony you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Sure.
Good morning, Doctor.
Good morning. Good morning.
All right, Mr. Lally, whenever you're ready.
It's
Thank you,
Mr.
Your Honor.
Lally. He's doing
Morning, sir.
something.
Good morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
My name is Dr. Garrey Faller, F as in Frank, A-L-L-E-R.
And what is your occupation?
I am a physician pathologist.
And where do you work?
I work currently at Signature Healthcare in Brockton.
And how long have you worked at Signature and in what capacity, sir?
Signature, I started, it's probably 6 months. I took a new job 6 months ago.
Already. With the facts that don't matter.
The chief of pathology and the laboratory medical director at Signature.
And where did you work prior to your work at Signature about 6 months ago?
Prior to that, I was at Good Samaritan Medical Center in the same capacity.
And how long did you work at Good Samaritan for?
Since 2015, late 2015.
And did you work in any capacity similar to that prior to working at Good Samaritan?
Prior to Good Samaritan, I worked at the Kearney Hospital, which is in Dorchester. Started that job in 1996. So I stayed on staff at Kearney Hospital up until actually closed 6 months ago. So I've been on staff at Kearney's for quite a long time.
Where did you go to school and what degrees did you receive?
I went to college at Tufts University in Medford, graduated in '87. From there, I went to Tufts Medical School and graduated in 1991.
And following your graduation, where did you go from there?
After medical school, I did a residency at Tufts Medical Center in 1991 to 1996.
And then where did you go following your residency?
And right from residency, my first job was at Kearney Hospital, which I previously mentioned, so 1996.
Thank you for
And doctor, are
closing
you
that.
board certified?
I am board certified in anatomic pathology and clinical pathology.
And what is a board certification?
Board certification is something we need to show that we are actually qualified to perform the job that we need to do, both in anatomic and clinical pathology. It's a written exam that we take and we need to pass to demonstrate that we're competent and know what we're doing.
First, in just general terms, if you could explain to the jury, what is pathology?
Pathology is, well, there are two basic branches of pathology: anatomic pathology and clinical pathology. Anatomic pathology is basically, an anatomic pathologist is a physician or MD or a DO trained to make diagnoses on patients via looking at tissue biopsies, organs, tissue fluids, and we're also trained in autopsy pathology as well. So basically, an anatomic pathologist, we look at tissues via glass slides. Slides are made, and we every day make the diagnosis of, somebody has a cancer or somebody doesn't have a cancer, benign. Look at colon polyps, breast biopsies, pretty much anything that comes out of the operating room or a physician's office, any sort of biopsy.
Now, we look at
Clinical
slides,
pathology,
doctor.
on the other hand, is basically a clinical pathologist is a physician, an MD or a DO, who specializes in the clinical lab, which basically is any fluid specimen, including blood specimens. When you go to the hospital and you have your blood test and it gets sent to the lab, the clinical pathologist is ultimately responsible for the quality of your lab tests and quality, and basically that's it.
And so the time that you worked at Good Samaritan, did that cover the date of January 29th, 2022?
Yes.
And again, what was your title and what was your
Again,
job at Good Samaritan in the month of January 2022?
I was the chief of pathology at the time and laboratory medical director.
What did you do as the laboratory medical director?
Laboratory medical director, basically, the laboratory medical director is responsible for the ultimate quality of any, either whether it's a biopsy, somebody's biopsy, or lab result. The laboratory medical director has to make sure that the final result is of excellent quality. So there are many different things that we need to make sure that things that are in place, as far as need to make sure we have the correct amount of workers. You want to have enough workers. You want to make sure they're competent. So as many, there are policies for competency for all the lab techs and phlebotomists and even pathologists. So basically the laboratory medical director, if something goes wrong, it's ultimately his or her fault.
And the lab at Good Samaritan, is that lab accredited?
Yes, it is.
And by what body?
We are accredited, or Good Samaritan is accredited by the, we call it the CAP. It's a College of American Pathologists. They are considered the preeminent accrediting body for hospitals. They've been around for probably 70 plus years or so.
What is accreditation? What does that mean?
Accreditation is basically something that says that your laboratory is following guidelines and providing excellent quality. To be accredited with the CAP, every 2 years we have a laboratory inspection. They don't tell you when they're coming. They will give you a 3-month window and they'll come and inspect you to make sure we have a good quality lab. Each section of the lab, pathology, the clinical lab, microbiology, chemistry, hematology. The CAP has a checklist with numerous requirements that one needs to fulfill. There are probably over 3,000 items that they look at.
And was your laboratory a Good Samaritan? Was the accreditation up to date on January 29th, 2022?
We were accredited, still are.
Now, in Good Samaritan Medical Center, when a blood test is ordered, what types of things is the lab testing for?
I think the most common tests that are performed when you go and you have your blood tests is one is a chemistry test where we sodium, potassium, chloride, glucose. We also, a common test is a CBC or a complete blood count, where we look at your red blood cells and your white blood cells and your platelets. Those are the two most common tests.
And why is blood testing ordered in the course of medical treatment at a hospital?
When you're admitted to the hospital, usually you're sick, so the physician is usually a standard, ordering chemistry and CBC to see if there are any clues in those tests that could help the doctor take care of you. If they look at a BUN and creatinine, maybe if they're elevated, you either could it be dehydrated or have renal failure. If you look at liver function tests, maybe there's something wrong with your liver. So it's just a general, a good look at the patients to see if there are any clues that could help them.
And as far as the blood testing results are concerned, how does that assist either a doctor or a clinician in treatment and diagnosis?
Basically, what I just said. If there's nothing, if the results are normal, that sometimes helps too. Rules things out if they're normal. If they do a CBC and look at the hemoglobin and it's low and patient's anemic, maybe the patient might need a transfusion. So there are many different case scenarios where the results can help the provider, the clinician.
Now, with reference to alcohol, does the Good Samaritan Medical Center, do they also test alcohol within the blood?
Yes, we do.
And why would that assist medical treatment and diagnosis?
I think if a physician is wanting to know if somebody's been drinking or has alcohol on board, or maybe not, maybe a patient has ingested maybe drugs of abuse. So they'll test for alcohol to see if it's positive. And if it is, then it helps confirm that the patient has been drinking.
Now, are there any policies and protocols at Good Samaritan Medical Center with reference to how blood is taken and how blood is tested?
Yes, we have numerous policies. We have one policy specifically for phlebotomists. Those are laboratory technicians who draw the blood. So we have a policy for them to explain exactly what they need to do. And also in the laboratory, we have numerous policies basically for any tests that we provide. And so we have a policy for alcohol testing as well.
May I approach the witness, Your Honor?
Yes.
Doctor, I'm placing before you two sets of documents. Just ask you to review those generally and look up when you're finished. And do you recognize what those are, sir?
Yes.
And can you explain to the jury what is contained within each of those two sets of documents?
Okay. The first one is a patient preparation for specimen collection. This is the policy that I was mentioning, specifically designed for our phlebotomist to detail the procedure of the blood draw. Basically goes through one of the most important parts of the process is correct patient identification, where we need to correctly identify the patient. We have the patient state his or her first and last name and state it out loud to make sure it matches which the patient that we're trying to draw. And then we also match up the bracelet to the medical record number on the patient's bracelet. So one of the most important things is correct patient identification. The rest of this policy goes on and just pretty much details what to do next, including finding the veins, cleaning the site. It has some information on if there are any complications. So it's basically the entire process of the blood draw. The second one is our alcohol policy, which pretty much details in detail what goes on behind the scenes for an alcohol blood test in our hospital.
May I approach you, Andrea?
Yes.
What goes on behind the scenes? Could that be any more vague?
The next two exhibits.
All right, thank you.
Your Honor, for the record, it would be the patient preparation for specimen collection, the next exhibit in line.
All right. Exhibit 35.
Are we at 35?
And the ETOH policy would be the next exhibit number 37.
Thank you. Exhibit 36.
Yes.
Excuse me.
That's-
What goes on behind the scenes? What does that even mean?
Now, doctor, what types of precautions are in place at Good Samaritan with respect specifically to alcohol testing in the blood? Or I should say taking the blood sample from the patient.
Yes, one of the major things we need to do with taking somebody's blood for alcohol is to obviously not use an alcohol swab. Normally, when you have your blood test, they cleanse the area with a swab that contains alcohol. So in our policy is a specific statement that says, do not use alcohol swab because potentially when you're drawing the blood, if you suck up some of that residual alcohol, you could cause a false positive. So we have in our policy, and it's every hospital should have the same policy where we use a swab that has no alcohol. We call them a moist towelette. That's what we refer them to.
Moist towelette.
Also in the emergency room, my supervisor pretty much removed probably 95% of all the alcohol swabs. So just in case a phlebotomist forgets to not use an alcohol swab, they are hard to find. We need to keep a few there because we need to use alcohol wipes on certain tests like blood cultures and stuff like that. So
when were the alcohol
Bizarre.
swabs removed from the emergency department?
it was before my time.
So fair to
Not
say
sure.
prior to January 29th, 2022?
Correct.
What is a phlebotomist and what do they do?
So a phlebotomist is a healthcare professional who specializes in drawing blood. So they're the ones who are trained, competent, and know what to do when they draw a patient's blood.
What kind of training do phlebotomists receive at Good Samaritan?
We try to hire phlebotomists who have been trained. It's just easier. So they can have a high school background, but if we train on site, they just need to be trained on the proper protocol, proper procedures, and demonstrate competency.
Is there any sort of proficiency testing related to phlebotomists at Good Samaritan?
There's no proficiency testing for phlebotomists, but there's competency assessments. So with phlebotomists or any laboratory technician or even pathologists, there are strict guidelines for competency. We have to always make sure people know what they're doing, and it's a CLIA or a federal government regulation or requirement. So when anybody first starts in a hospital, the requirements are, one, initial training. You can't let anybody come in on their, without not knowing what they're doing. So we have to document that they have the initial training and they're competent. And then the law says 6 months from that, we do another competency assessment where we look at 6 elements of competency defined by CLIA, and 6 months from that, 1 year from the start date, is another competency. And then after that, it's annual thereafter. And that goes for phlebotomists, and then it goes for any laboratory technician.
Doctor, once the blood is drawn by the phlebotomist, what happens then?
So the phlebotomist will draw it at the time. They need to have the specimens labeled in the patient's room, because you don't want the phlebotomist to mislabel. So everything gets labeled at the patient's bedside with an initial and with a phlebotomist's initial and date and time. That blood test will then be sent to the lab. In this case, the blood was drawn in the emergency room, so it gets packaged into a plastic bag and sent in a pneumatic tube up to the laboratory.
And once it's sent to the laboratory, what happens with the sample from there?
Once we receive it, it's called receiving the specimen. There will be a technician who then goes into the computer, enters the phlebotomist's name from the tube into the computer system, enters the time, and the technologist will look and see what was ordered, and then do the appropriate next step based on what was ordered.
And in a case in which alcohol is one of the items that are ordered, what is the next step as far as the testing goes?
So the next step with alcohol testing, we use a specific tube, so the phlebotomist would know what tube to use. It would be a light green tube that has lithium heparin in it. It's an anticoagulant. We don't want the blood to clot, so that's why we use an anticoagulant. So the first step when testing for alcohol is that the test is designed to be performed on serum or plasma. And to get that, the next step would be to centrifuge the blood. A centrifuge is a machine that spins the blood rapidly. We spin it at around 3,300 RPMs, which is pretty fast, rotations per minute. And the reason why we spin it, because centrifugation will allow it to separate the blood components based on the density. So the heavier stuff like the red blood cells will go to the bottom, and the lighter stuff like the watery component of the blood will go to the top, and some of the white cells go into the middle. But for alcohol testing, we are targeting the top part of the blood component, which would be plasma.
And then once it goes through through the centrifuge process, what happens then?
So once it's centrifuged, we have the separation of the blood components. We have the plasma ready to be tested, so that technologist will walk the specimen over. It's probably 10 feet from there, and put it onto our Roche Cobas machine. That's our machine that performs our chemistries as well as alcohol testing. It goes onto a machine. All the testing is basically inside of a black box. And the label present on the blood tube will dictate what the Roche machine will test. So based on the barcode label, once it's on our machine, it knows what test to do, and it will perform an alcohol test.
And Doctor, for our stenographer, do you know how to spell that Roche Cobas machine that you were just referencing?
So ROCHE, Roche, and Cobas, COBAS.
Thank you, sir. May I approach, Ron?
Yes.
And so how does it do the testing?
Doctor, showing you another
Magic?
series of documents again, and you can just look at that and look up when you're finished. Do you recognize those records, sir?
Yes.
And what do you recognize those to be?
These are the medical records of Karen Reed.
And sir, is there an indication within those records as far as the date of treatment for Ms. Reed?
Yes, there's a bunch of dates in here.
As far as the treatment is concerned, sir?
Yes.
And what is the date of treatment?
Oh. 1/9/22.
Sorry, is that 29/22?
That's what it says on this.
How bad are this guy's eyes? Why does he have glasses on but not on?
Admit date, it says 1/29/22.
Thank you, sir. That's fine. Doctor, if I could direct your attention further into the document to a previously tabbed portion, do you see any indication in there as far as a result for alcohol testing?
Mr. Lally, typically you need to admit the exhibit before you go testifying about the contents of it.
Yes, I do.
And with respect to that result, have you reviewed these records prior to today?
Yes, I did.
And if you could explain to the jury sort of the timeline from this blood sample as far as, let's start with first when it was ordered.
So when it was ordered, it was 9:03 in the morning.
Okay, and when was it
Okay.
taken, sir?
The blood test was taken 5 minutes later, so 9:08.
And then what happened, or what is the next time that something of any significance happened with it?
5 minutes from that, 9:13, we received it, and 9:53 in the morning, the result was entered into the computer. So it was ordered at 9:03, and I believe it was 9:53. The results were in the computer.
And may I approach you, Daniel?
Yes.
Because it will be admitted, and so nobody really cares. It's
Commonwealth
just
seeking to introduce and admit as the next exhibit.
Any objection, Ms. Little? All right, thank you.
it's just me pointing out part of the overall competency issue that we've had with Mr. Lally.
Yes.
We're at 37 now.
And doctor, what was the result of the testing for alcohol in the defendant's blood when it was taken shortly after 9 a.m. on January 29th?
93 milligrams per deciliter.
Okay. Nothing further, Your Honor.
Okay. Ms. Little?
Elizabeth Little again. I didn't get my banner ready because I totally
Good afternoon,
forgot.
Dr. Faller.
Oh, good afternoon.
The Good Samaritan lab is a clinical lab, not a forensic lab. Is that right?
Correct.
And hospitals are not in the legal business of calculating an individual's blood alcohol concentration. Is that right?
I would say 99.9% of the time we are not in the legal business. We are testing alcohol for the diagnosis of alcohol intoxication. But occasionally a case may come, very rare, to a hospital, and it ends up being a legal case. It's not common. I think uncommon.
And you'd agree that there are differences between screening tests that are conducted at hospitals and forensic tests that are conducted by law enforcement, right?
Yes.
The purpose of testing in a clinical setting is to assist in the diagnosis and treatment of a patient, right?
Correct.
And physicians need to analyze blood quickly. They need to get the results so they can see what's in a patient's system and then effectively and efficiently treat that patient, right?
Correct.
Whereas in a forensic setting, tests for blood alcohol concentration are designed to produce results that are reliable and credible for use in court. Correct?
Correct.
He didn't like
You
that
testified
distinction.
earlier today that your lab is accredited by CAP, which is the College of American Pathologists. Do you recall that testimony?
Yes, I do.
But CAP is a clinical laboratory accreditation, not a forensic accreditation, right?
We don't have the forensic accreditation for Good Samaritan.
In fact, Good Samaritan has never been investigated or accredited by any forensic accreditation team to ensure that you perform all of your tests with the integrity necessary to support results in court, right?
We've never been, we've never had the forensic accreditation, but we have very good quality lab results, which I could go into further.
But you've never been accredited by a forensic accreditation team, right?
Nope.
And the lab at Good Samaritan has never been accredited by the ANSI, which is the National Accreditation Board known as ANAB. Are you familiar with that organization?
No.
Are you aware that ANAB is the forensic accreditation body that in the United States that ensures that laboratories' procedures meet the minimum standards necessary to ensure results are reliable and credible for use in court?
Sustained.
Now, the most reliable method of forensic ethanol testing is called headspace gas chromatography, or HSGC. Are you familiar with that process?
Yes.
And HSGC is the method that's used by forensic labs to test for blood alcohol content, right?
Correct.
And that's because forensic tests require the testing of whole blood for the presence of alcohol, right?
Correct.
Can you briefly, just for the jury, describe sort of the difference between a whole blood test and a serum test?
Sure. So whole blood, to put it simply, when you have your blood drawn, you see the fluid coming out all red. That's whole blood. We don't do anything to it. We don't spin it down. We don't centrifuge it.
Got that,
is whole
guys?
blood.
The fluid that comes out
is
that's red is
the
whole
specimen of choice for forensic blood ethanol testing. Hospitals, on the other hand, our methodology, which is just as good as the forensic headspace gas chromatography, is based on looking at the serum or the plasma. So we don't, that's what I meant when I explained that we need to centrifuge it, take the liquid portion off the top. So in the hospital, we tested on the serum or the plasma. Now, did you ask me the difference? You want me to go into the difference?
That's enough, doctor. Thank you.
Okay.
I'll ask some additional questions
Okay.
to kind of clarify. And in a forensic lab, they actually require the testing of whole blood, correct?
Correct.
And HSGC directly measures ethanol in the blood.
Correct.
And this method is designed to be accurate and reliable for forensic purposes for use in legal proceedings, correct?
Correct.
But the testing in this case was performed using the hospital's clinical chemistry machine instead of a forensically defensible method like HSGC, right?
Correct.
And that clinical chemistry machine performs what you just testified to, a serum test, right?
Serum or plasma.
Serum or plasma. And hospitals use serum or plasma testing because it's actually quicker and more efficient than HSGC, right?
Yes, it's less labor intensive. It's easy to automate, but at the same time, very, very good and very accurate.
But serum testing does not actually measure alcohol directly. It instead measures the presence of what's called NADH, right? Say that again. Yes, I'll repeat that. That was my fault. Serum testing does not actually measure alcohol directly. Instead, it measures the presence of NADH. Is that right?
Almost.
Well, NADH is a byproduct of alcohol, right?
Correct. I can go into the testing how methodology that we use to explain it if you want me to.
Well, serum testing measures the presence of NADH, correct?
It measures the rate of change of NADH production, so it doesn't actually look at just NADH, and it measures the rate of production, and I can go into more detail on that. Alcohol testing in the lab is correct.
I'll ask you some additional
Okay,
questions
sure.
about NADH and we'll
Sure.
get there.
Yeah.
So you can do this now, but let the doctor answer his question fully next question, okay?
He wasn't
And
answering. He
the
was getting
following
non-responsive, Judge.
Doctor, the higher the NADH in a patient's system, the higher the serum test result, correct?
That may not be correct, no. It's the rate of change of NADH production based on our methodology. I can go into that. So our test system is a little bit different than the forensic testing system, but it's
We know.
also very good and very accurate, and almost when we compare our methodology to the Headspace, we get the exact same results, and when we compare and with peer laboratory comparisons. But what we do is and I think the jury needs to know this, maybe some of you might understand the chemistry behind it, but we do, we take the patient's sample, and it's based on, we add, because when there's alcohol in the specimen, we add, actually, in the test system, alcohol dehydrogenase. It's the same enzyme that's in the patient's body. In addition, we add a surplus of NAD to it. NAD is similar to NADH. They get converted back and forth. So when we put it on our test system, it's alcohol dehydrogenase is in there. And what happens is, when there's alcohol, it combines with NAD that we add to it. It creates NADH. And then in our machine, there's a spectrophotometer, which can monitor the rate of NADH production over baseline. And we use, there's something that measures, a photometer that measures the NADH production. It looks at light in this physics and looks at 340 nanometers, and it's pretty accurate. It will monitor, it will tell you, it will tell the system how much NADH is produced, and that amount is directly proportional to the alcohol in the patient's sample. So it's a very, very accurate test, but there are some limitations that I can go into.
So wait for another question.
Okay.
Next question, Ms. Little.
Yes, so serum testing can be subject to errors, right? And there are limitations.
There are some limitations that I can explain, just like headspace gas chromatography may have some limitations too, but I can go into them.
Why don't
Next
you?
question.
What are some of the limitations of the serum testing?
Okay. So the serum test, as with many tests in the laboratory, different things can interfere with our laboratory tests. And the three most common ones, which are unlikely to affect ethanol testing, is we abbreviated HIL. We want to look at those three things. One is hemolysis, which is H, and the other one is I, icterus, which is high bilirubin. And the third is L for lipids. High lipids will interfere with alcohol testing or with any testing based on that same methodology. Our machine, the Rose-Kobash machine, and all the machines out in the market today are very sophisticated. If we have elevated levels of any H or I or L, it will flag it and raise the potential for a problem. The next thing on the list is that our alcohol testing is not absolutely specific for ethanol. There are two possible other alcohols that can cross-react. One is propanol and butanol. But then it goes clinical history. Did the patient ingest those two alcohols? And third is there's some unusual hematologic malignancies like Waldenstrom's macroglobulinemia that can interfere. So it's always have to correlate with the clinical situation. The next one, sometimes there can be patients who make endogenous, make their own alcohol. So very rarely, some patients may truly have a positive result. That could be from our test or Headspace. They make their own, so we have to rule that out. It's a rare condition. And the next one is one that's in the literature, which is LDH and lactic acid. If a patient has a markedly elevated LDH or lactic acid, those one is an enzyme, and the other one is an acid. That can cause false positives. Now,
if I could stop you there, Doctor, I think those were the four that you identified, the four limitations: the lactic acid.
I don't know how he's breaking them up.
If I could just
Go
ask
ahead
you
and ask your next question.
If I could ask you a few more questions about LDH and lactic acid.
Sure.
You're aware, Dr. Faller, of the medical literature establishing that the presence of LDH and lactic acid can lead to falsely elevated serum readings, correct?
Correct.
And that's because lactic acid or LDH actually forms NADH.
Lactic acid, I'll have to go into a little bit of chemistry. Lactic acid and LDH, lactate dehydrogenase, they both act on each other. And LDH and lactic acid needs NAD plus to break it down. So in theory, when you're testing a serum, a plasma for blood alcohol, if there's extra LDH or high levels of LDH, high levels of lactic acid, you add it to the test system, and then Roche throws in, or Siemens throws in the NAD, it will form NADH. That was first documented, I think, back in the older versions of these ethanol testings back in the 1990s, when they stumbled on, they were looking for biomarkers or reasons in kids with SIDS, little babies, and they found that two of these babies had a positive alcohol. But
Doctor, if I could just ask the next question, if that's okay.
Sorry.
So in other words, NADH studies have found can actually be formed by certain biomechanical processes other than the presence of alcohol, right?
Yes.
Are you aware that the National Institute of Health has found that liver diseases, kidney diseases, muscle injury, trauma, and even anemia are some of the health conditions that can lead to a rise in serum LDH levels?
Yes.
Are you aware that Ms. Reed was severely anemic in January of 2022?
Sustained.
Are you aware that the medical literature has also found that patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls?
I'm going to allow that.
I haven't read anything specifically related to the NADH level, but but I want to go back to the point where our laboratory, our testing is not based.
question-
Let him finish
Non-responsive.
his answer.
It's the rate of change of NADH. So if somebody has NADH on board, I believe it's not going to affect the result. It's the rate of change. And it basically, back to the anemia, I haven't read or heard of that.
That was stricken. That was not
Okay.
allowed.
It all goes back to the lactic acid and the LDH.
That's what she
The
said about MS.
NADH doesn't matter. So looking at multiple sclerosis patients, they can have elevated LDH and lactic acid, but it's not to the extent that it can interfere with the alcohol levels. There was a study maybe 7-10 years ago.
Your Honor, there's no question pending.
You asked him about a study, if he was aware of the studies.
I asked, and that's a yes or no question. And he's,
All right, Doctor, we're going to hold that there for you and ask the next question.
Doctor, have you reviewed the August 21st, 2013 peer-reviewed article entitled Serum NAD through Disease Course in Multiple Sclerosis, which was sponsored by the Center of Healthy Brain Aging by the University of New South Wales? Which,
Can you do that again and slow down, please?
sure. Doctor, have you reviewed the August 21st, 2013 peer-reviewed article entitled Serum NAD Levels through Disease Course in Multiple Sclerosis, which was sponsored by the Center for Healthy Brain Aging by the School of Psychiatry at the University of New South Wales in Sydney, Australia, which specifically found that patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls?
Objection.
I'll strike the part of what the article held. Is he aware of the article?
No, I'm not, to be honest, no.
Dr. Faller, did you consider Ms. Reed's anemia and multiple sclerosis condition when you conducted the alcohol test on January 29, 2022?
No, we don't. No.
And again, serum tests like the ones conducted in this case don't test for ethanol. They only test for NADH, right?
We test for the rate of change of NADH production.
And Doctor, you did a number of other tests on Ms. Reed on January 29, 2022. You tested for additional drugs, not just alcohol, correct?
Correct.
And all of those results were negative.
Correct.
Thank you. No further questions.
Okay.
That basically mirrored the cross from last time, although he was a little more prepared and more explanatory.
Doctor, are you aware, I know your lab at Good Samaritan did not do this process, but are you aware through your training and experience of any sort of mathematical conversion that can be done from a serum reading in milligram per deciliter to a blood alcohol concentration in whole blood?
Objection, Your Honor.
I'm going to allow it. The door was open.
How was it opened?
Go ahead, sir.
Yes, I am aware. Yep.
And please describe what you're aware of with reference to that.
Well, with blood alcohol concentrates goes to, when it's in your blood, it goes more to the watery components of your blood. So when I described the process earlier, whole blood is before we spin it. And when we test the plasma, which is specifically testing the watery component. Now, people have done studies like how much percentage of water is a serum versus whole blood. Basically, to put it simple, there's a higher percentage of water in the serum versus whole blood. So a hospital result will always be a little bit higher than a test on whole blood. It can be, I think the ratio, the conversion factor is anywhere from 1.1 to 1.18. So it could be 18% or 11% higher in serum versus whole blood. But we don't do it. That's what I read. I will defer that to the experts.
Now, doctor, you were referencing in your cross-examination about a study that you were aware of about 10 years ago or so regarding MS and alcohol testing. Is that correct?
It was more on MS, looking at the results of lactic acid and LDH to see how high the levels of lactic acid can go in a group of multiple sclerosis patients. When reviewing that, we found that the range went from some normal range, 16% of the multiple sclerosis patients had normal lactic acids, but the remainder had elevated levels. But those levels were not anywhere near the required levels to produce a false positive. Our package inserts and for the Roche testing system, the Roche has, it's an FDA approved test, and they have to do in-depth, detailed testing before they allow any hospital to do a test. And they have listed, levels of lactic acid beyond which the test would not be reliable. But the results, based on this study of 600 multiple sclerosis patients, 2 big centers in Italy and 1 in the Netherlands, show that the highest level of lactic acid in the MS patients did not achieve, didn't get close. Usually patients with MS that are asymptomatic can have normal or low normal levels, or slightly elevated. It was the ones that had more symptoms that had elevated levels up to, I think the highest was 6.5 millimoles per deciliter, which is not high enough to interfere with our result.
Now, with respect to the lab at Good Samaritan Medical Center, the interference that you were speaking about earlier on cross-examination, what would happen if any of those types of interference were to occur during the course of the testing?
Objection? No, I'll allow it.
The 3 main ones, which I detailed earlier, is the hemolysis, icterus, and lipemia. Our machines are sophisticated. It will detect it and say, it will flag it and say, please do not result it, or we'll have a disclaimer saying, interpret this result with caution. The results may not be accurate. It hardly ever happens with alcohol testing. But if it did, we would get a result like that, and we probably wouldn't report it.
And from your review of the defendant's medical records, specifically her testing from January 29th, did you notice any interference or any reports like that in her record?
No.
Now, the testing that you're doing at Good Samaritan is in relation to patients such as that might have cancer or heart disease or something like that, correct?
Correct.
Now, you were talking or started to speak on cross-examination about the good quality lab results that you have from your lab, and you wanted to go into that further. Could you please expound upon that for the jury now?
Objection.
We have you mentioned proficiency testing before. So
Expound
all
on
hospital laboratories are accredited by
Ask
the
a question
CAP
about
or
it.
have to participate in proficiency testing. What that means is that every 3 times a year, and they give us 5 unknown samples. And we have to test it, report it back to CAP, which also reports back to the government. And we have to basically get the correct answers. And with alcohol testing, it's probably one of the best tests in the laboratory. Always have right on the money results. But at the same time, we're also able to look at results of all the other labs that participated in this proficiency testing. So we can look at different methods. We can look at labs that had the same method as us to see how we're doing. And usually with this proficiency testing, we have 3,000 labs across the nation that have the same methodology as us, so we can compare to them. And also, interestingly, we can see the labs that are using headspace gas chromatography. And out of interest, we can see, how do we compare? And we have exactly the same results on these proficiency testings. We also look at some statistics as well, not going into them, but we can look at some stats like standard deviations and SDs. And actually the hospitals with enzymatic testing have slightly better stats with that compared to Headspace. Pretty close, but a little bit better.
And doctor, from your review of the defendant's medical records and the blood testing in this case, was that done in conformity with the policies and protocols at Good Samaritan?
Objection. How does he
We
know?
have policies in place to be followed, and there's no reason not to think that somebody didn't follow policy.
Thank you, sir.
Because they did
Anything else, Ms. Little?
No questions.
All right,
The
doctor,
one-
you are all set, sir.
0.1% of the testing that you do. They did the rare one that requires special
Do you have
procedures.
another witness, Mr. Brennan?
I do.
Okay.
The Commonwealth calls Jason Becker.
Oh, we do have another witness. My goodness. Making up some time here. Jason Becker.
Do you solemnly swear that the testimony you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God? Good afternoon, sir.
All right, Mr. Brennan?
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please introduce yourself to the jury?
My name is Jason Becker.
How old are you?
I am 36 years old.
Do you live in the area?
I do. I live in Canton.
Tell us a little bit about your education.
My education, high school and college UMass. And I went to EMT school a little over 10 years ago and paramedic school.
Tell me a little bit about EMT school. How old were you when you started EMT school?
When I started EMT school, roughly 21 years old.
Why did you decide to go to EMT school?
I wanted to save some lives.
Tell us a little bit about EMT school. What did it require?
EMT school is a couple months of classroom stuff, and then you do some ride time on the ambulance. Paramedic school is a little different. It's about a little extended, 2 years worth of training. You're doing hospital, ER time, and ambulance time also.
How long did you serve as an EMT before you went to paramedic school?
I worked as an EMT for approximately 5 years.
Can you estimate how many dozens or hundreds of calls you were on during that time?
Hundreds.
Why did you decide then to go get paramedic training?
I wanted to be on the fire department, and it was a prerequisite.
Did you complete paramedic school successfully?
I did.
Were you still working as an EMT at the time?
I was.
And inevitably, did you seek to have a different job? Did you try to be a firefighter?
I wanted to be a firefighter, correct?
Were you successful in doing that?
I was.
Tell us a little bit about that, sir.
In the Canton Fire Department. So I got on the Canton Fire Department, and then they send you to the fire academy, where you train to be a firefighter.
So you had EMT training, paramedic training, and then firefighter training.
That's correct.
On the Canton Police Department, did you serve dual roles as a paramedic and as a firefighter?
Fire department?
Yes.
Yes, sir.
firefighter.
Yes, sir. Firefighter and as a paramedic.
You served as a firefighter and a paramedic.
Correct.
In the Canton Fire Department, does it have more than one station?
There's 2.
Is there one station that's larger or smaller than the other?
Station 1 is the headquarters, which is larger.
Had you ever spent time at Station 1 as a firefighter or a paramedic?
I have. We rotate to both stations.
I want you to take us back to January 29th, 2022. Were you working that evening?
I was.
What station were you assigned to?
Canton Station 2.
Canton Fire Station 2?
Correct.
And that's the smaller of the 2 stations.
It is.
Were you working with anybody at Fire Station 2 that night?
My ambulance partner at the time was firefighter Daniel Whitley.
Was there anybody else who was working at Fire Station 2 in addition to you and Dan Whitley?
Correct. There was an engine company with 3 guys on it.
3 people were assigned to the.
The engine, correct.
Were you and Dan Whitley assigned as partners for the day, the week?
Correct. Yes, we were.
Which was it, the day or the week, sir?
The week.
So for the entire week, you're partners with a person, and does that rotate on other assignments?
It does. It rotates.
So on this particular week, you were assigned as partners with Dan Whitley.
I was.
What were your roles between the 2 of you?
Well, at the time, he was my preceptor. I was a new paramedic at the time. So I was more or less the lead tech on all the calls as part of my training. And Dan's been a paramedic for a long time. So he was there to teach me.
So would Dan Whitley be the lead on the call and he would help you?
I would be the lead.
You would be the lead.
Correct.
Did you get a call that early morning hours of January 29, 2022?
We did.
What was the call assigned for?
It was a call for Section 12 psych eval.
Very briefly, can you tell us what a Section 12 is?
Sure. It's a transportation order filled out by police, doctor, basically for us on the ambulance that we have to take the patient, whether voluntarily or involuntarily, because they're a threat to themselves or someone else.
When you received the call for Section 12, were you aware that there were other calls that Fire Station 1 had responded to that morning?
We were aware. You can hear the calls going out each station.
Were you or Dan Whitley any part of that earlier call that Fire Station 1 responded to before you got the call for the Section 12?
We were not.
So your efforts were after?
We were after, correct.
After you got the call to respond to a Section 12, did you head towards Fairview Road?
We did.
Tell us a little bit about the trip to Fairview Road.
It was a little extended because of the weather conditions at the time. Snowing heavily, windy, low visibility.
How long did it take to get from Fire Station 2 to Fairview Road?
Approximately 8 to 10 minutes.
Who drove?
Firefighter Whitley.
Now, on the way to Fairview Road, do you sit in the front of the ambulance?
We do.
Take us to when you arrived to Fairview Road. What do you see?
You see a bunch of police lights. Canton Engine 3 was already on scene, so we parked behind them.
Did you have it, without talking about what you spoke about, did you have a chance to speak to anybody at the scene?
We briefly spoke to the Canton police, and they briefed us and sent us to where the defendant was at the time.
Why do you have a conversation with other first responders at the scene before you do anything?
They're making sure the scene is safe to begin with, and they're unseen first, so they have a little more info than what our dispatch would have.
After you had that debriefing with colleagues, were you directed to approach any certain person?
I was.
Where did you go?
I went to the defendant, who was sitting in a black SUV type car.
Were there other persons inside the car with the defendant?
From my understanding, there was one person in the driver's seat.
And what seat was the defendant in?
She was in the front passenger seat.
Did you have a chance to speak to her?
I did.
And the person you spoke to who's in the passenger seat of that car, do you see that person in court today?
I do.
Could you point out and describe an article of clothing, please?
Miss Reed right there, she's in the blue, navy blue.
How long was your conversation with the defendant while she was still seated inside the vehicle?
Approximately 5 to 8 minutes.
At some point, did you and the defendant move to another location?
We did.
Where did you go?
So we went back to the ambulance.
After having a conversation with her, was she cooperative going back to the ambulance with you?
She was.
And did you ask her to be seated in the ambulance?
I did.
Was she cooperative with that as well?
She was.
After she was seated in the ambulance, did you close the doors and get in?
We did.
When you say we, who was with you?
Me and Firefighter Whitley.
So you and Firefighter Whitley were in the back of the ambulance with Miss Reed. Who was going to drive the ambulance?
Firefighter Sam Park.
Where did he come from?
He was on the fire engine that was already on scene.
I want to ask you questions now about what you did in the back of the ambulance and some of the conversations that you had. Tell us what your role is once you have a patient in the back of the ambulance. What do you do next?
I mean, each patient's different, depends on what the call is for. In this specific situation, it was more a psych eval, because that's what we're called for. Initial triage questions: is the patient cooperative, uncooperative, combative? I asked her name, her mental status, where she was. I asked her if she was suicidal, and if she was, did she have a plan? Did she want to hurt anyone else? Those are kind of the initial triage questions that I would ask.
Why do you ask those questions?
Just to get a kind of a judgment on the patient, reading the patient.
What's your role at that point? Are you an investigator?
I'm not.
Are you in any way law enforcement?
I'm not.
So what's your focus when you're speaking to a patient?
It's basically hearing them speak in their story. In this specific situation, we didn't know circumstances. We just knew that Miss Reed had found her husband, which she was calling dead on the side of the road. So it was a traumatic call.
So when you were there, you knew nothing about what had happened before you got there?
We did not.
And your role had nothing to do with any of that investigation?
We did not.
You were solely focused on caring for the patient?
Correct.
Did you have any other role other than caring for the patient?
Just making sure she got to the hospital safely. She didn't hurt herself.
During those conversations, are you and Firefighter Whitley doing the same thing or different things?
Again, it depends on the call. I was the lead tech, so I'm the one documented, giving a report to the nurses, the staff. So I was more kind of getting that information, my initial triage questions, and then just kind of sat and supported Miss Reed. And
were you writing down information, technical information about status and health on a report?
I was, yes.
While you were doing that, was your colleague speaking to Miss Reed?
He was.
Did you have a chance at times to hear what they were speaking about?
Yeah, and no.
At other times, did you speak directly to Miss Reed?
I have.
Can you describe her demeanor, her temperament?
Initially, she was agitated because she didn't feel like she needed to go to the hospital. She said the statement she made, she didn't mean. She just kind of said in jest because of the events that she went through. So but then there'd be periods of which she'd be calm, and then it would fluctuate. She would have like pressured speech, repetitive, but all in all, she was cooperative.
At some point, did you have a chance to speak to her directly about her mood?
About her mood?
About her mood.
About her mood?
I don't know if I understand the question.
Okay. Did she say anything to you about her last interaction with what she referred to as her husband?
Objection. Sustained.
Did she make any statements to you when you were giving her treatment or speaking to her about her husband?
Objection. I'll allow that, it came in.
One of the reasons why she was saying suicidal stuff is because the last conversation she had with her husband at the time was an argument. I didn't feel like it was my role to really find out the details on what was said. But that's what she said to me.
That the last thing she said to him was an argument?
Yep.
Sustained.
Did she tell you what the argument was about?
She did not.
Inevitably, did you get a chance to bring her to the hospital?
We did.
Did you stay in the back of the ambulance with her?
I did.
Did you continue to have conversations with her?
Yes, I did.
Did you hear conversations or parts of conversations she was having with your colleague?
I had parts.
When you got to the hospital, what happens next?
So we brought Miss Reed into the hospital, registered her, bring her to the psychiatric section. Is it?
Thank you. I have no further questions.
Mr. Jackson?
Thank you.
This guy's been good. No need to really cross him.
I have just one, Your Honor.
Yes.
Good afternoon, Firefighter Becker.
Good afternoon.
When you first arrived at the scene, there was at least two Canton police officers there still.
Correct.
Do you remember their names?
Officer Sarif and Officer Mulvaney.
Okay. Their cruiser was there. You said that an engine was still there.
Correct.
And was there another ambulance there, or the other ambulance had already left the scene? They'd cleared.
They had already transported to the hospital.
Remind me, you were in ambulance two? Or,
I was ambulance 2.
got it. You parked behind the SUV where you ultimately made contact with Miss Reed, correct?
I think it was more in front of the SUV because the way the SUV was parked.
Got it. Got out of the ambulance, ultimately made contact with Miss Reed through the passenger door.
Correct.
Had a short conversation with her there.
I did.
You said it was maybe 5 to 8 minutes.
More like 5 minutes because of the weather conditions.
Okay, nothing of great consequence. I'm guessing just an initial, I think you called it sort of a triage assessment.
Well, it's more of just introducing myself and asking her how she was doing.
Got it. And then there was one other person in the cab of the vehicle as well.
There was.
Female, male.
Female.
So there are two females, one Miss Reed, one another female. Did you see any other civilian females out there?
I didn't see.
Okay,
But
so at least where you were, the contact that you had with Miss Reed and this other female, there was just two of them, not a third one.
from what I saw, correct.
Did you get the other female's name?
Not at the time, I did not.
Okay.
Did she give you a phone?
By the way, have you since gotten her name?
Based on a conversation Firefighter Whitley and Miss Reed had back in the ambulance.
Got it. Okay. And who is that other person?
Miss Kerri Roberts.
Okay.
Did Kerry give you a phone?
When you first observed Miss Reed, did you note whether or not there was anything unusual about her physical appearance, meaning anything on her?
She did, yes.
Describe that for the jurors, please.
She had some blood around her mouth, her neck area.
At that point, were you concerned about, obviously you're concerned mainly about her safety and getting her safely to the hospital, correct?
That's correct.
Were you worried that that might be her blood?
She had said that she had given CPR to her husband.
Okay, you jumped a question ahead. I was going to say, did she tell you that it was in fact not her blood?
She did, so that kind of, in a way, ruled it out.
Okay.
No injury for me.
And you didn't indicate, you didn't notice anything about her that looked like she was physically injured or physically in harm?
I did not.
Okay. She indicated that she had given CPR, mouth-to-mouth attempts at mouth-to-mouth resuscitation to Mr. O'Keefe, correct?
She did.
And that would account for the blood on her face and in her hair and on her neck?
That's what she told me.
Okay. And based on your observations of her, you didn't have any reason to quarrel with that?
Correct.
Okay. You indicated that her tone was somewhat rapid and repetitive. Is that right?
It fluctuated. So at times it was, yes.
Did it appear to you at that time that she had gone through a pretty significant trauma as best you were trained at the time?
A little bit more of a foundation. I'll give it to you.
Sure. Have you ever, in your course of training,
described
seen
it
individuals
previously
who
as
have
a
gone through
traumatic.
some sort of a traumatic event?
Frequently.
Frequently.
Everyone's different though.
Understood. Obviously, everybody's got their own personalities and the way of dealing with those things, right?
Sure.
Have you been able to, through your training, assess whether, at least in your belief, your observations, if someone has gone through a relatively traumatic event, as opposed to just someone whistling down the sidewalk?
Yeah.
Okay. Did it appear at that time when you're interacting with Ms. Reed that she was showing the signs consistent of having gone through a trauma?
At the time, yes.
Okay. So hence the rapid speech, the repetitive speech, things of that nature.
Correct. For her. For the defendant, some people don't have repetitive
Understood. I'm
speech.
just talking about your observations of her at that time.
Yes, sir.
Her demeanor was consistent with having gone through a significant trauma.
For the situation, sure. Yes.
Okay. You said that she went from calmness to agitation. The agitation you accounted for being, I don't necessarily want to go to the hospital. I don't want to be sectioned, correct?
She felt like she didn't need to. It wasn't, she wasn't going to act on her comments about wanting to harm herself.
You called it, I think in a report, it's SI, suicidal ideation.
Correct.
That's obviously of great concern to you and your partners when you're assessing a patient, correct?
That's right.
You don't want to leave someone on their own if they're going to self-harm, correct?
That's correct.
You pretty quickly assessed, I'm guessing, Firefighter Becker, that she was not, in fact, in the position to self-harm, that I think you said that the statements that she originally made, if John dies, I don't want to live, were not necessarily at the level of actual suicidal ideation. Is that right?
Yeah, I mean, at the time I believed her because of the information we got and what she went through.
I'm sorry, I didn't quite understand your answer.
Sorry, can you repeat your question?
Of course. It's probably my fault. At the time that you assessed her, even though she had made some comments about if John doesn't live, I don't want to live either, you did not elevate that to the level of her being suicidal at that moment.
So I couldn't rule it out, but
Okay.
I didn't think it was a huge threat at the time.
Understood.
But
That's
we
what I was trying to get at.
couldn't rule it out, so that's why we had to take her to the hospital.
Understood. I mean, you had a section 12. You had to take her irrespective of what you ruled in or out, right?
Right.
Okay. Firefighter Whitley was with you in the back of the ambulance the entire time you were with Miss Reed, correct?
Not the entire time. He was before we decided transporting. He was kind of in and out, trying to find more of, talking to the police officers, find more of a story of, what happened,
Okay.
why we're taking the defendant on a section 12.
Once you and Miss Reed were in the back of the ambulance, Firefighter Whitley then joined you in the back of the ambulance?
He did.
How much time lapsed?
It was a couple minutes at the most.
Okay, so it wasn't a lengthy amount of time.
It wasn't lengthy.
And he was with you during the transport, along with Miss Reed, for the whole transport back to Good Sam.
It's a good, yes.
And you said on direct examination, I think your phrase was, all in all, she was cooperative with us.
For the majority of the transport, yes.
Okay. Never became combative, never got physical, nothing like that?
No.
Okay. She did refer to Mr. O'Keefe as her husband or her spouse?
That's correct.
You're aware of HIPAA rules, obviously. You're in the medical field, correct?
Correct.
You're aware at the time that HIPAA rules would demand or dictate that unless you're a spouse or a parent or a child, there's certain rules against getting or providing information to someone who isn't one of those close family members, correct?
That's correct.
Okay. You previously indicated on direct examination that, I think your words were, that Ms. Reed indicated that her last conversation she had with her husband was an argument, correct?
Correct.
You've previously testified about that statement in other particulars, right? Other hearings.
I have.
You're paraphrasing. You didn't write down what she said about her previous interactions with Mr. O'Keefe, and you didn't record those on a tape recorder, correct?
I wrote down in my report that she said she had an argument.
Right. You didn't write them down at the time. That was a bad question on my part. You weren't taking notes as she was speaking.
Yeah, it could have been. I mean, it's kind of for every call, we jot down notes on like a notepad, just
Okay.
so, when we give the staff a report, we can read off it.
Do you have those notes?
I don't.
Okay. Do you think you took notes or no?
To be honest, I'm not sure. I could have been typing them on the computer. That's what we typed the report on
Okay.
at the time.
Do you have an independent recollection of taking notes, either handwritten or on a computer as you sit here right now?
I couldn't tell you if I did one or the other. Sometimes
Okay.
I write on the computer, sometimes I don't.
Or you might not have written anything down, correct?
Correct.
Okay. So in any event, you weren't taking down, even if you were taking notes, you weren't taking down verbatim quotes of what she was saying. You were paraphrasing the information that was coming to you, correct?
That's correct.
All right. You had previously said or testified that the last time, let me rephrase that just a little bit. You previously indicated in recounting what it was that Miss Reed actually said to you was something along the lines of she was upset because her last words to him were because of her last words to him being in anger.
I object.
I'm going to allow the question.
Is that correct?
Well, I probably phrased it a little wrongly. The last words, it was the last conversation.
Okay, that wasn't my question. My question is a simple one. In a previous hearing, did you use the phrase her last words to him?
Yes,
were
I
in
did.
anger?
I did.
And that was at a hearing where you were under oath, just like you are now, correct?
Correct.
That was a little closer in time than we are now. It was maybe a year ago, correct?
Correct.
Actually, my mistake. It was about 2.5 years ago. It was a grand jury, correct?
The grand jury was before, yes.
Okay. And the phrase that you used was, and I want to concentrate on that for just a quick second, Firefighter Becker.
Sure.
The phrase that you used at that time was that she said, quote, like her last words to him. She was upset about her, quote, last words to him. Is that right?
I object.
All right, can I see counsel at sidebar, please?
So this is Mr. Brennan invoking that rule, hearsay, that it's her own statement. She doesn't get her own statement. The problem is they're not offering it for the truth. They're offering it to show inconsistencies in how this witness has described it. Are those inconsistencies material or not? That would be for the jury to decide. But that's the defense argument on this. It's not hearsay because they're not offering it for the purpose of proving that Karen said it one way or the other. They're offering it to prove that he has given inconsistent accounts of what she said. Therefore, his reliability about what she said is questionable. That's it. We'll see what she does. I don't consider this amount of cross necessary at all. Why does it matter? Why does any of this matter? Does any of it prove she hit him with the car? This guy would have asked him, did Kerry Roberts give you a phone? No, thank you. And I would sit down. That's all I want out of this guy. What he gave on direct was not damaging at all. Who cares if he's been slightly inconsistent? It doesn't matter. Ellen's red and angry. He's not going to be allowed to ask it.
May I continue, Your Honor?
Yes.
Thank you. When you were recounting the conversation that Ms. Reed indicated that she was upset about, you also indicated, in addition to using the phrase her last words to him, you also said that it was earlier in the night, correct? They had an argument earlier in the night.
I don't recall.
Bev sustained the objection.
Now, just a moment, Your Honor.
Yes.
May I approach?
Yes.
you don't mind, take a look at the top paragraph, very, very small print. Let me know when you've refreshed your recollection.
Yes.
Great. May I approach?
Yes.
You got it.
When you wrote your report, you had indicated that when she was describing the argument that you testified to on direct, it was about an argument that was, quote, earlier in the night.
Earlier in the night, correct?
Okay. And then you recounted that statement, that same statement in the grand jury later on as at least including, quote, her last words. Is that right?
Her last words.
You were talking about an argument that they had, and then she was upset, and you were paraphrasing her. And one of the things that you paraphrased was, in fact, your statement was she was upset that was like her last words to him, correct?
She said that.
Yes.
Correct.
Okay. Were you also made aware, did she tell you that her last words to him were in voicemails? Did she say that?
She didn't give any details.
Did you ask her, what were your last words to him?
I did not.
Did she ever say whether or not she believed he ever received her last words to him?
There's no other details than, there was no other details other than what she said.
Okay. But she did, when she was having this conversation with you about her last words to him, she did actually take out her phone and show you a bunch of missed calls to him at the same time, didn't she?
She tried to, yes.
Okay. In your mind, did you put two and two together that what she was actually talking about were the missed calls and her being upset about her last words to him, being very angry on those missed calls, those voicemails? Did you put those two things together?
I didn't.
Okay. Thank you. That's all I have.
Okay, Mr. Brennan?
So when Ms. Reed told you that she was sad because her last conversation or her last thing that she had said to him was an argument, did she ever suggest that was in a voicemail?
Objection.
Oh,
Did she ever suggest it was in a voicemail?
She did not.
Did she ever suggest that she didn't actually speak to him, but instead it was some type of message?
Objection.
I'll allow that.
Did she ever suggest that?
She did not.
In fact, you wrote a report saying that there was an argument earlier in the night, didn't you?
Objection, Your Honor.
Sustained.
You then were interviewed, weren't you? Were you
Yes.
interviewed on February 14th, 2022?
Yes.
And you referred to the fact that she told you there was an argument earlier in the night?
Argument early in the night.
And she was telling you this when you were speaking to her that morning?
Correct. Around 6 a.m.
Right.
Yes.
And earlier in the night, do you know if she was referring to 12:30
I did not know.
or 12:15
No.
or midnight?
I didn't know the time.
So his answer is he doesn't know.
You testified in the grand jury, and Attorney Jackson just asked you some questions about part of the statement you made to the grand jury when he said, like her last words. Would you like to put that in context of the whole statement you made? Do you remember
Her last words.
Do you remember the entire statement that you made in the grand jury about the statement that was made to you?
I'd have to.
May I approach?
Yes.
You'd have to what? Read it.
This is page 81.
No, he probably doesn't
line 1
care,
through 4.
Mr. Brennan, but you clearly want to put him
read
to
this
put
one.
it in context.
1 through 4, please.
Yes.
Now, when you made that statement you were asked about in the grand jury, you didn't just say, like her last words, did you?
No.
You explained your memory to the grand jury?
Objection.
Ask him what he told the grand.
Okay. The grand jury, do you know it was on April 21st, 2022?
Yes.
Okay, and did you tell the grand jury? So she
Objection.
So I'm going to see counsel at sidebar for a second, please.
Oh my gosh. This is much ado about nothing, isn't it? Does this matter? Does this matter? Is this smart of the defense to highlight this point? I'm not sure I think that it is. I'm not sure I think it's really smart to hear this. They're going to hear the voicemails at some point. Yes, the voicemails are pretty bad. Karen is very unhappy. Very unhappy. So maybe they're just trying to take the sting out of it in advance. I don't know. I guess. Her being sad about them, is that helpful?
May I approach?
Yes.
So I'm showing you that statement that you made. That includes last words, but there's more to the statement, isn't there?
She was upset.
I'd like you to read
Oh, okay,
your
sorry.
entire
Sure.
statement, 1 through 5. You can read that out loud.
So she was also she was upset also because she said they had, the last time they had talked, she had gotten into an argument. So she was upset that that was like her last words to him.
And so when you were speaking about her last words to him, were you referring to the argument?
Correct.
You testified again regarding this issue, didn't you, in May 3rd, 2024?
Correct.
Okay. And at that point, did you think or believe that the conversation she was relating to you was about a voicemail? Objection.
I'm going to sustain the objection.
Did you use the word again on May 3rd, 2024, argument? Objection.
I'm going to allow this.
I used argument.
May I approach, Your Honor?
Yes.
Why?
Can I actually read your prior statement on page 10, lines 9 through 13? Objection.
I'm going to see you at sidebar again and bring these documents, please. Bring all of it.
So they were not allowed to impeach him with the prior inconsistent statement, right? They had to move on. But now what's happening is that Mr. Brennan is rehabilitating him with a prior consistent statement, even though he wasn't allowed to be impeached. So if this doesn't get sustained, it tells you there's a little bit of a different standard being applied here. He gets to rehabilitate an impeachment that wasn't allowed to take place because the statements are hearsay when Karen wants to use them to prove the truth, but not when Brennan wants to use them. I don't know the logic that's going on here. I really don't. I really don't. Mr. Brennan hasn't set a very good foundation of, exactly what he's doing, what the inconsistency is, and so how these new statements are consistent with what he said before. Oh man, guys, does any of this even matter? Is this helpful? I don't think this is helpful. To now be hammering in on all the different versions of what Karen said about the last contact she had with John being negative. This would not be my strategy because I'd have asked him, did Kerry Roberts give you a phone? And I'd have set my butt down and I'd have saved all this for argument. I would save all of this for argument. All he said on direct All he said on direct was the last conversation she had with him was an argument, didn't ask about the details, didn't know what it was about. We already know there was conflict at the end because of the voicemails. You can just make the argument in closing. Isn't it reasonable to think this is what she had in mind when she was talking about it? She left him these voice messages. They were angry. She had driven off and left him there to send a signal. I'm done with you. Done with you taking me for granted. Done with you not being considerate of me and my needs. You want me to leave and do what I'm going to do? Then I will. I'll just leave. Aren't those things consistent? You don't have to try to get the opposing witness to say the thing the way you want it said, because they're not going to, and they're going to resist, and then you're going to squabble, and you're going to end up emphasizing the thing you're trying to argue with them about.
May I?
Yes.
Thank you. Sir, when you wrote the report of your notes to put in your report, do you remember the word argument?
I did.
Do you remember her actually saying the word argument?
I did.
Do you remember her ever saying any word about voice messages?
I did not.
You said that there was somebody in the front seat of the car with the defendant,
It was.
and you later learned from the defendant it was a person by the name of Kerry Roberts.
Correct.
Can you share with us the context? How did you learn that?
The defendant and my partner, Firefighter Whitley, had a conversation.
Objection.
I'm going to allow it.
So the defendant brought up how if her husband had died at the time, she didn't know how she was going to take care of his kids.
Objection.
I'm going to allow this.
And Firefighter Whitley mentioned that she had like a strong support system. You know, all the friends are on Canton, and
Objection, Your Honor. May we approach?
Yes.
I was going to say it's double hearsay. This is all for impeachment. So it looks like, okay, now if I go back through this, the issue is she's only allowing them impeachment on like limited specific words that are inconsistent. She doesn't want to allow them to get into a lot of detail. You know, the context of the statements. No, you can argue that last words is inconsistent with argument, is inconsistent with, you know, voice messages. Didn't say voice messages, didn't use that specific word. So that's kind of how she's constrained the cross-examination, impeachment, and then because she's restrained the impeachment, she has to constrain the rehabilitation as well. So they get to point to specific words that are consistent or not. But now he's trying to well, for one thing, he's going beyond the scope of cross, because all that they brought up on cross was just that he learned since the time. He didn't know Kerry Roberts' name at the time, but he learned it after the fact that her name was Kerry Roberts. There was no like challenge about that. That is not opening the door to, you know, what did Whitley say? What was this entire conversation about Kerry Roberts? So we're still stuck in this framework of, you know, is it inconsistent? Is it not consistent? Does it call for rehabilitation? Does it not call for rehabilitation? She's already limited it. And now he's like, we're getting into a paragraph. A paragraph recitation of something that doesn't contradict anything that the defense elicited. So I think that's what we're dealing with here, is it's beyond the scope of the cross. Part of the issue is, yes, because Whitley's statements outside of court are also hearsay. Karen's are subject to an exception. His are not. Have to fit within a hearsay exception or not be offered for the truth. Are they being offered for the truth? Kind of seems like they are, because they're not being offered for impeachment because there's nothing to impeach or rehabilitate. They're not being offered to rehabilitate because there's nothing to rehabilitate. He didn't say anything. He didn't say anything contradictory. Brennan's just trying to get him to elaborate on what he said before. But your chance to ask that was on your direct. That's more or less where I think we're at. So is it going to be limited? Is it going to have to stop?
When you spoke to the defendant and she shared with you that her last words with
Oh God, we're going back to this.
Were an argument, why didn't you ask for more detail about that?
I didn't feel it was at the time we went about the call as that we didn't think we would be witnesses in a murder trial. We were there to support Karen and ultimately get to the hospital safely.
And you were asked about trauma, and you said that you observed that the person may be in trauma, Ms. Reed.
A traumatic event,
Traumatic event.
Right.
Do you have any idea what caused that traumatic event?
I did not.
Thank you. I have no further questions.
Anything?
Very briefly, you indicated that you were asked on
Let it go.
redirect examination by Mr. Brennan whether earlier in the night could have been 12 or 12:15 a.m., correct?
That's what he asked, yes.
And earlier in the
Don't
night
do
could
it.
have been 6 o'clock
Do
p.m.
it. Don't
Early
do
in
it.
the night, yeah, correct.
Could have been
Said
5
you
o'clock
didn't
p.m.
know.
Could have been,
Could have been 7 o'clock p.m.
sure.
Okay. You were also asked whether or not Ms. Reed actually specifically mentioned voicemails when she talked about those last words. And you said she didn't,
That I remember, correct.
but she did show you her phone.
She tried to.
And she did show you a bunch of missed calls to John O'Keefe, correct?
I wasn't going to look through her phone. I don't know who she called.
Thank you. That's all.
When she said about the argument, she said those were the last words, the argument, right?
That's correct.
Sustained. All right. The jurors disregard that last statement. All right, you are all set.
All right. Thank you. You guys.
Is this a
These
good
guys
place
hate
to
each
stop
other.
for the day?
That's not helpful.
If the court pleases, yes.
Jurors, we could do 6 minutes, but I think this is probably a good place to start. Why don't you? So, as I understand it, folks, we're on schedule, right where we thought we would be. We're going to release you for today. Now, when I told you this morning, and I've told you other times too, that when you're out in that room waiting for us, we're in here getting work done to make things more efficient for the trial.
Well, sometimes you
especially
are.
a trial this long. We've decided that we're going to spend Monday afternoon again trying to streamline this trial and deal with issues that we have to deal with. So Monday for you will be a half a day. All right, so I just wanted to tell you that before you left today. Please, again, those 3 cautions: do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it, let us know. And I guess the 4th caution is the same as I've been saying. Please be very careful with your social media.
All right, have a good weekend. We'll see you Monday morning.
All right, so what, please?
And I'd like to see
Very
counsel at
careful.
sidebar, please.
Oh, and they're going to sidebar. Be very careful with your social media. Oh yeah, these guys hate each other, and it's starting to seem like that might be driving a little bit more of what's going on than the strategy. And if that's the case, I don't like it. I don't like it one bit. I don't like it one bit. That is undisciplined. That is undisciplined. Nope, you get pulled into a dog fight if that's not your fight. That's not where you want to be. You got to fight your fight and follow your strategy. I'm just waiting to see if they go anywhere else, or if it's sidebar and out, or if we get anything else on the record. So to recap, no ARCCA today. The ARCCA's deadline to produce their stuff that she put in the order was this morning. Don't know if that got like implicitly extended until Monday also. I personally wouldn't trust that it is if it's not in writing that it is. So I don't know if they've had to come up with that already, and then they'll just show up in court on Monday. But Monday afternoon, the half day, that's when we're doing the ARCCA voir dire. So this, whatever Judge Cannoni has in mind to give the opportunity to the defense to do, I don't know what, with the voir dire is happening on Monday. It's not the normal way that these things happen, or what they are for. The voir dire is normally for the opposing party to be able to identify any sort of foundational issues that need to be addressed. What the defense is supposed to do with this voir dire, not clear. Only general impression I have is they're going to be expected to justify why they should be able to call ARCCA at trial based on whatever the judge has in mind about whatever she thinks they've done wrong, all of which is just kind of implicit and not really out there. We know that she's suspicious of the communications, so I'm guessing that's what they'll focus on. And then we know that there's a risk because of the time frame here, that new opinions and new work that ARCCA has done, the Commonwealth is complaining. We don't have a chance to respond to it. Defense has said that's your own fault because you produced your own stuff so late. So there's a risk. She might say, yeah, it's too late. You don't get to use their new stuff. So you definitely want a record. If I'm the defense and I think she's maybe going to exclude this, I want a record of what it is. It's like everything else, 99% of appellate issues, it comes up, you want to challenge it, you want to say this was not fair that I wasn't able to do this, this was an incorrect decision. You're going to have to show what the effect of that was on the trial. You have to show it was a harmful error and not just a theoretical one that didn't really have any practical consequence. So I want on record, here's what these guys did, here's what they were going to say, here's how it affects the trial and our theory of the trial, and this is why it's critical. I want to make my record of that. So that's what I'm doing if I'm the defense in this situation on Monday. I'm taking a proactive approach to making my appellate record. I'm assuming she's going to throw him out. And if she's going to throw him out, I'm making a factual record about why she's wrong to do that. It's all I can really think of. Court is still in session. You know, they haven't released everybody. Still over there at sidebar. Didn't like the bickering with Becker at all. I really didn't. All you've emphasized is, God, they must have said some pretty awful things in the last words. That's all you've accomplished. It's like, wow, those voicemails must be really bad because that's what was on her mind. You know, this is your explanation, defense. This is your version. Is that those voicemails were so bad that that's what she was freaking out about the next day? That's how you prime the jury now. I understand. I understand. Oh, we have to poke a hole in that because Brennan said in his opening statement that they had an argument like as John got out of the car or when he got out of the car or something like that. That's his theory. So we have to undermine that. No, you don't. If it doesn't matter, you don't have to undermine it. If Hank Brennan gets up in his opening statement and he says Karen Reed has blonde hair and she wears really nice expensive clothes, you don't have to nitpick. You don't have to undermine if her hair is actually more of a lighter brown than a blonde. You don't have to nitpick about, you know, she doesn't wear like couture. She doesn't wear like the highest end clothing. You don't have to undermine everything the prosecution does. And if you do, if you try to do that, it just makes you look unreasonable. You look far more reasonable when you find common ground with people. And nevertheless, you can have an alternative interpretation at certain points. But if you disagree about everything, you just look disagreeable. And if you look like you disagree about everything, you look like your perspective is not a reasonable one. You don't have to undermine it just because he said in his opening they had an argument then, because you know what? If John O'Keefe wasn't hit by a car, it doesn't matter. If John O'Keefe wasn't hit by a car, it doesn't matter if they had a blow up. It doesn't matter, guys. It doesn't matter if hands were thrown. If it was like the biggest, blowest up argument that they ever had, it doesn't matter if she did not hit him with her car. And that's where the opening was supposed to get us. It was supposed to focus us on what Juror Ronnie told us. This is what we struggled with the most. This is what I wish they would have focused on, the technicals of the vehicle and the injuries. They didn't add up. Wish they would have focused on that. We were set up to focus on that. And now we're quibbling about how she described their last argument. Guys, I don't know where we are. That was the beauty. That was the beauty of that framing. It's so simple, distills it down. If she wasn't hit by a car, all the rest of this stuff matters. And then it doesn't matter. And then guess what? Then you have some high ground in closing. You get to point out, we spent an awful lot of time here during the Commonwealth case listening to a lot of stuff that doesn't matter. It doesn't even matter because Karen Reed doesn't hit him with a car. And they tried to spin it all and turn it all into something to try to distract you from the fact that Karen Reed didn't hit John O'Keefe with her car. And they took all that time. We barely even asked their witnesses any questions because it doesn't matter so much. It was such a good strategy, and I don't see them implementing it. I don't see them implementing it. And I just don't feel like playing to the bloodlust, you know, the folks who just want to see a battle. They just want to see a throwdown, you know, don't really care about the substance, just want to see combat. I don't think that is a good strategy to win a trial. So I hope that's not what it is, but I just don't like what I'm seeing. Easy for me to say sitting over here. I'm fully aware, not living and breathing the case. I don't know what they've talked about. I don't know what they've decided their strategy on. Maybe people already told Mr. Jackson this morning, you should maybe, lay off and not get so combative over stuff that doesn't matter. Try to focus on that. And now he gets on the field and, does it anyway. I don't know. I don't know what's going on behind the scenes. I don't know if they've decided there's a reason why they need to do this. But I'm not finding it effective. And I'm doing my best to explain why. Not because, I would do a better job. We're going to wrap up and I'm going to go outside and take a nice walk. And
All right, we'll see you Monday.
all right, that's it. And these guys are all going to go back to work and they're gonna be prepping for next week.
So Tori,
I get it. But I'm just doing my best to explain why I don't think this is landing and why I'm concerned this is not addressing the problems they had in the first trial. Juror Ronnie told them, and they were doing such a good job of addressing that, but they haven't followed through. With the opening. Oh, guys. Well, we'll have to see how it unfolds. Let's get back to some of your comments. Charles Argo, nobody knows where the caller actually was. Also, depth of field are important in photography. Yes, depth of field is very important. And that's one of the things that gets affected by focal length and distance and stuff like that. If you're standing far away from something with a wide angle lens, it's very flat. You have a wide open depth of field, like everything from what's really close to you to everything that's really far away is very broad and in focus. But if you're standing in that same position and now you put on a telephoto lens and you zoom into something closer, the thing that you zoom in on is going to be in focus and everything in front of it is now going to be blurred. You're going to get depth of field. You have a very shallow depth of field from the same perspective using a different lens. I shouldn't say the same perspective, from the same vantage point using a different lens. So it can absolutely affect the perspective that you get from a photograph. Nobody knows where the car actually was because we hear kind of different versions of where the car was. There's no documentation of where the car was, and witnesses kind of put different cars in different places over the course of this whole evening. And so there isn't a single cohesive story about where each car was at each point that everybody's in agreement on. That's the issue with where the car actually was. Some people say Brian Higgins' Jeep is parked out front. Other people talk about driving in and out without ever seeing a Jeep there. They talk about where they park as if there's not a Jeep there. So there's some conflict about what cars were where, and that includes Karen's as well. Casey Cat, Turtle Boy says they'll be back at 11 a.m. Great. I'm glad we stuck around then. Thanks for giving me the heads up. Sorry I didn't get to it earlier, but no harm, no foul. V. Gray, were there stories about people getting hit by snowplows before John O'Keefe's death? I think Karen's statement about him possibly being hit by a snowplow should be contextualized. Why would she think that? Yeah, I don't know. That's a good question. I mean, all I can really think of is just she's imagining what could have happened, if it was something bad, something where he wouldn't have called, something where he wouldn't have gotten a ride back to the house because of the kids. What are the things that could have happened? Hit by a snowplow, If he was trying to walk home, it's dark, visibility's bad. Maybe it's just natural for her to jump to that because it's a blizzard, but I agree with you. It would be very helpful to know, have there been stories about people getting hit by snowplows? Is that something that it's common to worry about? I got to tell you, I've lived, I mentioned before, I kind of laugh at you Boston snow people because I was a Tahoe snow person. Okay. We know snow. You get a lot of snow up in Lake Tahoe. I lived up there for 3 years before I went to law school. Not uncommon at all to get like 3 feet overnight, and then the best part is the next day you go outside to shovel and the sun is shining and it's a bluebird sky, 300 sunny days a year in Tahoe. Oh, I loved it so much. You'd be warm, pleasant birds chirping. It was just absolute winter wonderland in that environment. So you get a lot of snow. You have a massive amount of snow management. You have plows going constantly. You have trucks. You learn like the systems for how they create the berms and where they put them and all that kind of stuff because you just see so much plowing. And I got to tell you, I really can't remember in all of 3 winters that I spent there dealing with that. I can't remember ever worrying about getting hit by a plow or like wondering if someone would get hit by a plow. So I do wonder if maybe there's some context there that would lead her to jump to that. Because my initial thought is not, that's just me. Obviously, it's just me. And we've already established I'm pretty low on the neurotics. I don't worry about stuff. I'm very low neurotic. So I wouldn't be like racking my brain more than likely, trying to think of things. I would be more likely to be sitting there going, well, it's probably fine, but things are seeming off. And so I'm going to want to investigate. Just how I imagine myself in that situation. Of course, never been in it. You never know what's going to happen until you're in it. But we've all been in stressful situations and things where we're not sure and stuff like that. So my mind does not immediately go to, just because it's snowing and there's plows out, somebody's going to be hit by a plow. A lot of plows. It's not something I'd be worried about. But I don't know. Maybe there have been stories. And if there were, I agree with you completely. That would be very helpful. I think that would tend to undermine an implication that, she knew what happened and was, looking for a cover story or something like that. The Goodmans gifted a membership. Thank you so much for your generous contribution. The Goodmans, thank you on behalf of the person who got that membership. Brennan and 2 potted plants. Jury has to be wondering why they keep hearing about testimonies last year. Well, they know now. Mr. Whitley told them. Prior trial? Yeah. Yes, it was at a prior trial. So they know now it's out. They've heard it. But they can't, they can't harp on it. They can't elicit it. They won't be able to bring it up again. If the jury didn't catch that, then it's gone. But I would think some of them probably caught that. There was a prior trial. Now, as far as why are we hearing about a prior trial? Sure. They're probably wondering that, but there's a lot of like the process, the procedure side of court stuff that jurors are going to wonder about, and they're not going to know. Like the whole formalities of everything, they may very well wonder, like, why are we doing this? How does this work? But they won't know, and it doesn't really matter. It's more for the lawyers to care about. But they know it's a trial now. They've been told that. Marissa T, I think Victoria George gave tips regarding the view. That would be a good use of Victoria George if that's the case. I think that's a very good idea. She was there. Now, since she didn't deliberate, if the jury followed their instructions, they wouldn't have talked about it before she was excused. And so she wouldn't know what the other jurors thought about the view or what their takeaways were or anything like that, in theory. But she would certainly have her own impressions, what worked for her, what made sense and what didn't. So yeah, I think that's a very good observation. That would be a great use of Victoria George. And Wouldn't surprise me if they did that. Zoo Blues gifted an Andrea Burkhart membership. Thank you, Zoo Blues. Thank you for your support. Kathleen R. Why two YouTube sources say they're back in court at 11 Eastern for what that's worth. Thank you so much for the heads up. We were here. We were here anyway. We stuck around. Might as well. They didn't kill the feed, so take a wait and see. What an odd order of things to me. Everybody convenes at the courthouse and then leaves and then comes back, and then you bring the witness in again, and then everybody leaves again. I don't know. I thought they were going to do him first and then go on The View, and then, you just get back to the courthouse, get their stuff, and they can go. I don't know. But they didn't do it that way. Jennifer Devine, I think if I was Karen, I may be mad at John for going in that house. She didn't go in for a reason. Anger is a stage of grief. Anger is a stage of grief. And I think, breakup is something you grieve. A breakup is definitely something that you grieve. And you have to reach that point of accepting that it's over. And it does sound like Karen had kind of already started down that road. She knew there was a problem. She was getting tired of, continuing to have to deal with it. She's trying to find solutions, but she's kind of got a foot out, coming to that point of realizing this isn't going to work, but she's not there yet. She's not there yet because she's still hanging on. So yeah, I can see a situation where that grief process, particularly in a breakup, you're gonna have to work through some anger because you're gonna be mad. Why the fuck couldn't he just give a shit? Why couldn't he just care? Why couldn't he just be interested in being nicer for the sake of my feelings? Anger back and forth with self-blame. That's like the most common kind of dynamic during a breakup. I hate that person. They suck so much, but was it my fault? Could I have done something different? Oh, it's not a fun place to be. But that definitely makes a lot of sense to me. She's already seeing that the relationship is coming to an end. She's going through that process. Yeah, you're gonna have some anger at some point. Grace, important perspective about her emotionality. It's been longer since his death than they were even together. Yeah, this is a very good point. This is a very good point. They were together, a couple years during COVID to 2022. So a couple years really at the most. And they had known each other before, they had dated before, but as I recall, it was quite a long time ago. And this was not a situation where they had stayed in close touch. And then, rekindled. They had just moved on into their separate circles and then reconnected. It took an effort to reconnect later on. So hadn't been together for that long. This is the second try anyway, already been on this merry-go-round and it didn't work. Thought it would be better this time. Wasn't. And now, yeah, a lot of time has passed. And frankly, some people just don't show emotion like other people do. Some people don't show their pain. I'm not really one to show my pain, guys. So I was, when things happen, like when my dog dies, I'm going to kind of back out until I'm, kind of comfortable. I can handle it. I can talk about it. I'm not going to randomly cry. I don't want to randomly cry in front of people. That's the worst, the worst things I could imagine. So I'll just back away until things are okay and I feel like I can show myself in a not pained situation. Some people are like that. Karen could just be like that. She could just be someone that is not inclined to show her pain. So There's a lot of explanations for it. American Dreamer. Everyone should watch 12 Angry Men, 1957. Still good. It is a good one. It is a good one. It's a good one about, groupthink, integrity, standing against the mob and not just going along with what's easy. Doing the hard thing. There's a lot of good messages in that movie. It's not necessarily the most legally accurate, but it's okay. Not everything can be the first season of Law and Order, which is like so legally accurate that we would be advised in law school for like criminal procedure and stuff. Watch Evidence, watch Law and Order, like the old original one, because they would use that as their plot hook in a lot of the episodes. They like to take obscure legal rules or requirements or things like that and make that like the hook of the case. Oh, they didn't properly Mirandize him because they didn't consider him in custody, but he was, things like that. And it was a good way to kind of learn the rules like that if you were so inclined. But not every show is going to be like original Law and Order. So Buzzcat. Karen didn't have time to even begin to start grieving. She was immediately suspected and had to focus on her own freedom. Yeah, I think the timeline of all of this, the re-traumatization, it's like, whatever you experienced as your initial trauma, because you've lost your relationship and you had this terrible experience of discovering him and the effect that would have on you, and everything else that you're dealing with as far as coming to terms with the kids. The relationship with the kids has changed. Your life patterns now are completely different. That in and of itself is a shock with a breakup. Somebody that you talk to every day, suddenly now you don't. Suddenly now you don't. And it can be a big adjustment. But she immediately, she didn't have the space to be able to kind of process that and work through it. She immediately is hit with this accusation that it was you and this threat that it's you. And yeah, it's a threat. A threat is going to take your immediate attention. If you lose somebody you love, okay, somebody you love, you're at the funeral, it's fresh. And if a grizzly bear comes out of the woods and starts to charge that grave, your focus is going to be on getting away from that bear. It's not, your priority is not going to be, I got to continue to grieve. I got to work through this. I got to process it. No, you're going to put that aside and you're going to deal with the threat. So yeah, she's had to do that. That wasn't her choice. There's a lot of complex things that go into why Karen presents the way that she does. Equality. It's like picking a good jury is half the battle. It might be more than that. Picking a good jury is very difficult, and there's so much luck of the draw that's involved. I know I've told the story before about the time when I had a judge who was like a very he's very prosecution friendly judge, and I'm doing a trial in front of him. It's like my second or third trial, and the prosecutor does something that's objectionable, like mistrial level. I think he asked the witness, the law enforcement witness, on direct examination, if my client invoked his Miranda rights, and I objected. You don't get to comment on somebody's exercise of their Miranda rights if they choose not to talk. Whatever. I forget exactly how it was, but so that's objectionable. And so it's the kind of thing that you can move for a mistrial, and so I did, and Was it that egregious in hindsight? No, probably not. But the judge gave it to me, and that should have been my alarm bell. It should have been my alarm bell, because I remember thinking, I really like this jury I have. I had a great jury. I had a really great jury. And I remember going back in for the retrial on that case and looking at the panel, and my heart sinks. So they start to talk to this stony panel that does not like me or what I'm there to do one bit. Had this revelation. Oh, the jury I can pick is only as good as the panel that I am given to choose from. And I did not have a good panel. I did not get nearly as good of a jury as I had that first time. And I still wonder about that judge. And that judge knew. He knew I had a good jury. He knew, and he knew I should be careful what I ask for, because he went ahead and gave it to me. It is at least half the battle. The jury is critical. Rudy Dub with a super chat. Thank you so much for that, Rudy Dub. Judge Bev's Wurzel Gummidge hair. I'm gonna write this down, because I'm gonna have to look up Wurzel Gummidge. I'm sure this is a reference to a character or something that I don't know, but now I want to see what it is. To those talking about Karen Reed's lack of emotion, she stated she had his phone, which is like a diary. I think she saw everything he was up to, and maybe it wasn't pretty, which would taint her view of their relationship. Yeah, she did. She got his phone extraction and stuff, and we've seen how John behaves. We've seen how John behaves. He likes to text the girls, stay in contact with them. He likes, Carrie Roberts checking in, seeing if she can do anything for him. Aruba's not coming up this trial. Aruba's not coming up this trial, but we heard about it last trial. And it doesn't sound like a fun thing for me. If I were on a trip like that in Karen's position, kind of got some insight into that babysitter with benefits comment. John's just running off to drink with all these people, leaves Karen to look after the kids. Yeah, not real cool. So that's possible. It's possible she learned more through the course of the investigation that changed her perspective. Ryan Bibbs gifted 5 memberships. Thank you so much for that, Ryan. Really appreciate your support. Helen Lewis, why would her attorneys let her do all of those interviews? They had to have known her words could be used against her. Sometimes you wish as an attorney you had the power to make your client not do something, but you don't. You can't imprison them. You can't literally put duct tape over their mouth. They do have free will, and they don't always follow your advice. We don't know the answer to this. We don't know if they told her, Karen, this is a crazy idea. You shouldn't do it. And she says, I'm going to do it anyway. And they tell her it's going to backfire. And she says, I don't care. We don't know. We don't know if they told her, Karen, here's the risk of what could happen. And, if you say anything at all, they will cherry pick it. They will distort it. They will twist it. They will put you in a position where you might need to get on the stand to explain it. And she says, I get it. It's worth it to me. We just don't know. It's ultimately her choice. It's ultimately her choice. They have influence, but you don't always have control over what your client chooses to do. So if this was, I have a hard time imagining that this was a cavalier decision, just because, of course, it's very obvious to any attorney. You minimize what you say. Anything you say can and will be used against you, and it will not be used fairly and objectively. It will not. So you already know the game. You would not give your adversary ammunition, even if you think She's innocent, so she's not going to say anything that would harm her. Innocent people get convicted because they believed, if I'm innocent, that will protect me. What I say can't be used against me. So they go and talk to police. And then guess what? It's used against them. It happens all the time. So you know the game. You know that even if you think she doesn't have anything incriminating to say, it doesn't matter. They're going to take innocuous things and twist them and present them in a way that makes it look like they're incriminating. Because that's what the game is. That's what prosecutors do. That's the whole strategy behind the Reid technique. Get him to just admit to something small, you know? Didn't see if you can build it. No, I mean, you know, but at least you got something. Well, he admitted he was there. He just said he didn't do it, but we think he did. That's the game. So I can't imagine they were just like cavalierly like, oh yeah, I'll be totally fine if you do that. I have to assume that the bare minimum that happened here was, Karen, here is an outlining of the costs and benefits. You can make your own decision. I can't imagine they recommended it. They maybe didn't explicitly say, I don't think you should do it. They might have left it at you can make your own decision. But I don't think this decision was made without an awareness of the potential downsides. That would be extremely irresponsible. So I don't think that's the case. I think Karen decided that what she got out of doing the interviews was more important than the potential downside of the words being used against her. Are they, super damaging so far? I mean, it's hard for me to know how they're landing with the jury. I don't find them that bad. But I don't know how they're landing with the jury. She's definitely established probably OUI, If they were charging her with that, she's probably guilty. To the extent that count 2, the vehicular homicide charge, the manslaughter, that requires proof that she was operating under the influence. She's pretty much given them that element. But it doesn't matter if she didn't hit John with a car. That's why that theory is so good. That strategy is so good. Wish they'd stick to it. Edward Kirkpatrick, pancreas and other damage attributed to early hypothermia with John, also signs of alcoholic. John was sobering up at 4:20 in the afternoon on the 28th. Yeah, I noticed that comment. I noticed that comment where in the text messages, he says, I'm sobering up and you're like just about to go back out. If that's literal, if he's like, literally, I'm just now getting sober. Yeah, I'm concerned. I'm concerned about that drinking. I don't know medically if these things are going to look similar. I don't know if there's, going to be ways to distinguish. This is the type of damage that alcohol causes. This is the type of damage that hypothermia causes. I certainly buy, yes, alcohol abuse will very much cause organ damage. Whether that could be mistaken for hypothermia, I don't know. I'm sure we're going to hear from the defense pathologist who says there was no hypothermia. Because that's what Dr. Scorty Bello had relied on when she made the determination. In fact, I think I might. Do I? No, I don't think I do. I say I think I might have her testimony right here in my notes, but I don't. I'm in a different part of the trial there. That was her basis for finding hypothermia was organ, some issue with like the way the cells change in the organ. Don't remember it off the top of my head right now. I think it was the pancreas. But if that can be explained by chronic alcohol abuse, bet we're going to hear that from the defense expert. So that'll be interesting to see. My Mini 67. For reference, I used to drink 1.5 liters of vodka 3 times a week and still went to school most mornings. Stopped drinking at 19. Dang, girl. I mean, yeah, that's a lot. That's a lot. It's a lot of alcohol. The quantities you hear of, you work in like a, even like a treatment program, rehab facility, read a lot of these police reports. My goodness, the quantities are just mind-blowing. They're mind-blowing. I'm really glad that you were able to turn that around. And I'll bet life is better because of it. Could be wrong, but my suspicion is it probably is. Canoni's baloney, Jadzia 1969. Couldn't an early view help them to better visualize the testimony? That might be the counter argument. It's just the question is going to be how well are they going to be able to retain what they see at the view, to compare that against the testimony if they don't really know what matters at this point. The attorneys can give them some idea. Here's what matters, but they've kind of given them a lot now. They've sort of told them, well, it all matters. Go there and pay attention to all of it very closely because it will matter. So I think, that's going to be the concern. If it was just a question of visualizing the testimony, you can do that with the photographs and stuff to get the general idea, but then take them out to the view so that they can see very specifically. And then they have more context to know, here's why I need to look at this. Here's what I need to look for, because they'll know what their own concerns and questions are based on having heard the testimony. So I think, yeah, this is probably the justification for it. Maybe let them see it before they hear all of the testimony about it, and then they'll have a better frame of reference. Maybe. I guess it just depends on what you want the purpose of the view to be. Do you want it to be just a very general context, understanding the risk that later on, as they've heard more and they're starting to try to sort things out in their minds and trying to figure out how to resolve conflicts, like, for example, was a Jeep parked there or not? They know nothing about that at this point in time. And they have no idea if or how they would need to pay attention to that. If they knew, there might be an issue with a Jeep being parked out front because some people say it was there, some people say it wasn't. And we've heard descriptions about where other vehicles were parked in relationship to each other. And if this Jeep was there, it puts them in a different position and kind of different movement and stuff than if the Jeep wasn't there. How much room would we have? Does that make sense in our explanation? To resolve this dispute about the white Jeep, they don't know anything about that. If they knew all of that and knew that they had those questions before they were going to the scene, then they know what to look at. They're going to look at that front curb. It's not a curb, but the front property boundary where people would park. How much room is there? How close is it to the driveway? Between the driveway and the fire hydrant, how many cars are going to fit in there? Can I visualize how they would be parked? How they would have to move if they're going to move in and out between each other? They don't know that right now. So if they get that information and they're trying to sort it and they're trying to think back about the view, they weren't paying attention to it. It's not clear that they would be able to recreate that and use the view for purposes of answering that question. So maybe that's the point. They don't want them inspecting things that closely. Is that drawing the line too close to investigation? I don't know. But I think those are basically the two different ways to look at it. Is it helpful now so that they can see it when it's described? Is that what it's most helpful for? Is it most helpful later for when they have questions that they can go and see for themselves in an effort to help them resolve that? The Chugi Show Live could even have something to do with the current residents. They might be given a list of dates and asked what would be the less disruptive for them. That is very true. That is a great point in terms of the timing of the view. They don't get to control who goes on the street and who goes, on the sidewalk and who's going to be in the general vicinity. But in terms of, if anybody's going to be going on the yard, going in the driveway, going up to the front door, yeah, you're going to need permission to that. And frankly, even if you're not going to, just as a courtesy, you probably would give them a heads up. You probably would do that. And so that's definitely possible. If they need the homeowner's permission to be able to go on the property, mill about, take their time, see things from where they want to see them, then you're going to do it when the homeowner says you can do it. So good idea and suggestion there. It's very plausible. Tactical Clo, Fort Myers. Hi, why can't we get the tow truck driver video? I believe I remember hearing the trucks have cameras. The tow truck driver is on the defense's witness list, so we might. I don't know. We might. If he's got a camera, I don't know if he's got a reverse camera. What we saw, what we have seen from the dash cam of whether it was Trooper Buchanan or Trooper Proctor's car now, I don't really remember. No, it wasn't. It was from the Ring camera from Karen Reed's dad's house. He had a Ring camera. It's pointed out down the driveway. And so you can see the tow truck, pull up out front, and then Karen Reed's car being taken out of the driveway and loaded up onto the tow truck. Her car is never in front of the tow truck. So if it's just a dash cam type video for the tow truck, I don't know if it would help as far as getting any view of Karen's car or the damage on Karen's car. If he's got a reverse mirror, reverse camera, maybe he'd see stuff. I don't know what they would have. I don't know what they would have, or if it would be helpful, even if they did have it. But you'd expect the tow truck driver, if nothing else, to himself have some observations of that vehicle. And frankly, you'd expect him to have some documentation of the condition of the vehicle. Of course, you'd expect the police to have that too. They didn't do it. But the tow truck driver has a little bit more of his own skin in the game because he doesn't want to be the guy that tows the truck all the way back to Canton. And then it gets there and they're like, this taillight wasn't like that when you put it on the car. When you put it on the truck, he's going to be like, oh, yes, it was. Here's where I documented it. So I would definitely expect that. And that's why I think there's a reason that guy is on the defense witness list. But of course, we're not going to know till he shows up and we hear. Elraz, your question about DV relationship patterns and evolutionary function. It all goes back to attachment theory. Check out information on Bowlby and early attachment theory. I'm going to write that down. I will look that up. That is an angle. I will tell you that wasn't necessarily the angle I was thinking of it from. I'm going to look at it for sure. I was thinking of it, quite frankly, from the standpoint of short-term and long-term reproductive strategies. You will see different types of behavior play out depending on whether somebody is pursuing a long-term reproductive strategy that tends to promote, bonding, mutual care of the child, stuff like that, versus the, get pregnant and go, get as many as you can type of thing. That's kind of the framework I was thinking of it in, but yeah, I could see how that could relate to attachment theory. I don't know. I'll follow this up. Thank you for the recommendation. Definitely sounds like you have more of a grounding in it than I do. I'm just kind of thinking off the top of my head how that might work. So I'll check that out. 5 a.m. research. Come out, relying on you for a ride in case my buddy doesn't show. My response would be, here's $5, get a cab, parasite. But what do I know? Oh, the text just didn't make him look good. They just don't make him look good. They really don't. I hear some comments that, oh, it looks like, Karen's really demanding, Karen's really needy. I really didn't see that. I see Karen is being assertive. Karen's not a shrinking violet. She's not going to pretend she doesn't have feelings she doesn't have. She's not going to squash her feelings just to appease him. She has a sense of self-dignity and self-worth, and so when she has been hurt, she wants that addressed. And it doesn't seem like an out-of-line expectation for a partner to support you in your emotional well-being. Does that mean placate you? No, of course not. Does that mean, give you everything you want? No. Everything you want when you want it, no matter what? No, of course not. But what it doesn't look like is I'm sorry plus excuse. And then later on, when that hasn't fixed it, I already told you I'm sorry. I don't know what else you want. That to me was major tell. He's done. He doesn't want to talk about his own contribution to the relationship problems. It's her fault for not getting over it. And yeah, the assumption, he keeps telling her, Karen, do what you want. Do what you want. He's not going to tell her he wants her to be there. He won't do that. He won't reach out. He won't show affection. He's withholding it. So he won't tell her he wants her to come. Tells her, do what you want. And probably what happens is that she takes the high ground, and makes up. And that's seems to me to be pretty consistent with what we've seen. John likes women who seek him out. John likes women to come at him. He wants to be chased. Some men are like that. Some men want to be chased, and some men want to be chased so much they want to make it hard. They want to make it like a challenge. It's like it speaks to how good they are that like they can treat her really bad and she'll still chase him. I'm not saying, John is necessarily like that, but see a little bit of it. He says all kinds of nasty things to Karen because she gave his kids Dunkin' Donuts. He gives her a real hard time and then expects her to come to him, get over it. Taking it for granted then, she needs to make a plan, but that her plan is going to be coming and staying in Canton for the weekend after she just told you, I don't really want to be in this environment because it's toxic. You don't like how I interact with your kids and it causes all this conflict. So I want to minimize that. And he's disregarded all that. He hasn't listened to any of it. Just assumes, oh, you're going to be staying here for the weekend. So your hot water problem doesn't matter. I mean, if you haven't been in a relationship like this, it's really hard to know what you would do. It's patterns. Keep coming back to that. It's patterns. People tend to find themselves in the same types of situations that they've always been in because that's familiar and it feels safe. It feels comfortable, even if it isn't actually. It's the devil is better than the one you don't. So if what is people relating to each other in this dysfunctional kind of way, that's normal and that's going to feel safe. I don't think I'd be real down with it, but I don't know. It's hard to say until you're in it. U.S. RICO. If they are ever held responsible, could Jen M be charged with accessory to murder or accessory? Thank you. It would just depend on the statute of limitations. So typically, most places there are either extremely long or no statutes of limitation for murder. And typically charging somebody as an accomplice is the same as charging them as a principal. And so if they help carry out the crime or cover it up, they are just as liable as the person who, inflicts the fatal blow. So, big if. But from a legal standpoint, is the charge available? Probably. I don't know. Let's see if I can Google real quick. Statute of limitations for murder in Massachusetts. See what we get. No time limit. No statute of limitations for murder. So, yeah, if they have the case and they charge her as an accomplice, they could. Damaris San Giuliano, I have a feeling the Commonwealth witnesses feel pressure and weighty responsibility to assist in convicting Karen, hence their testimony and manner this time. It makes a lot of sense. The pressure's on. They got to double down. They're Team Commonwealth. And so Team Commonwealth didn't get the win last time. So players got to put in a little more effort on the field. I could see that perspective. I can definitely see it for the ones that self-affiliate with the prosecution. Folks that don't, maybe not. I don't know. It'll be interesting to see how some of those more neutral or neutral-ish kinds of characters might play out this time. And by that, I'm thinking about like Dr. Scorty Bello. I think is really the main one. Whose side is she on? Is she going to be more helpful to Karen, less helpful to Karen? She's the Commonwealth's witness, but they've kind of diminished her. Especially now, this time they're bringing aren't they bringing in a whole different pathologist? They're like second guessing her. I don't know. I'll be interested to see. I didn't necessarily get a read on Mike Camerano in the first trial as being particularly pro-guilt, but this time I did. Maybe if I was seeing him for the first time this time, I wouldn't think so, but it's just because I have that contrast. I saw him get more negative on Karen, even slightly. Last time they never even bickered. This time, but they bickered. That little bit of extra effort, move the ball forward for your team. It could definitely be some of that. Scooter 54, why is Brennan recalling Trooper Guarino? I don't know. I did get reminded because I forgot. He's been in a car accident. Like he got hit by a DUI driver, and I guess he did get pretty severely injured. I don't know much about the details. So it could be that some of this is an accommodation to him. He maybe can't sit very long. An extended, examination would be uncomfortable. Could just be because he's trying to sort of set the stage for the way he's telling the story, just to get out what he needs to get out before they get into, I don't know, too much of the aspect of the investigation. Like rather than making the investigation the story, they are using the investigation to just present the pieces that the witnesses will need to explain to be able to tell the story the way that Mr. Brennan wants to tell it. I don't know why they're doing it that way. The bottom line is the defense isn't objecting to it, so they don't think it's a problem. But I don't know what their thought process is. Pebbles, if DA Morrissey is on the defense witness list, do you think it would be a good strategy to question him on the extremely unethical hostage video? I would love to see Morrissey on the stand. I don't think that would probably be a good idea, because all you're then going to do is put that hostage video in front of the jury, and kind of like we saw with Mr. Jackson this morning, what that means, because you're going to quibble about it. If you're questioning him about it, that means we're not taking it at face value. So we're just going to keep going back and forth with the things he said in the hostage video. Are the things he said in the hostage video helpful to Karen? Things that you want to emphasize and stand out in the jury's mind? Not me. Not me. So I wouldn't do this. I wouldn't do this. I think the only way I'm calling District Attorney Morrissey to the stand is if I've got him linked to the cover-up. If I've got him linked to the cover-up somehow, then maybe I'll call him. I'll put him on my witness list regardless of whether I have it or not, because I want to keep that door open. I don't want to not be able to call him if something comes out at trial, because anything can happen at trial. Proctor suddenly volunteers. Well, the only reason I sprinkled that taillight around is because Morrissey told me to. Well, I'm probably going to be more inclined to call Mr. Morrissey now. And if he wasn't on my witness list, I can't. So, you know, I'm not sure. I'm pretty sure he was on the witness list last time and didn't get called. Can't be 100% positive right now sitting here, but it's very common to put on your witness list people that you just want to have that option, even if you don't intend at the moment that you're making your witness list to necessarily call them. You just want it to be an option. So I don't know that they have any plan for Mr. Morrissey. That's what I would do. You know, if I were looking at this, I would not call him to talk about the hostage video, because I don't want the jury to see the hostage video. And if I bring it up and we talk about it, they're going to see it, and it's probably going to get emphasized, and they're going to hear it over and over. So I would not do that. Norma F., can Proctor take the fifth and not testify? Great question. Great question. So you have the Fifth Amendment privilege to not respond to any question that has a reasonable likelihood of putting you in jeopardy of a criminal prosecution. Doesn't matter if it's a small petty crime. Doesn't matter if it's a big serious crime. If your answer could implicate you in a crime, you can take the fifth and refuse to answer. So you cannot broadly take the fifth and refuse to testify about anything at all. He has a lot of things. He was the lead investigator in the case, so he has a lot of things that he can testify about concerning his role in this case that don't implicate him in criminal behavior. You know, the fact that the case was assigned to him does not implicate him in criminal behavior. The fact that he was partners with Buchanan does not implicate him in criminal behavior. So it has to be considered really question by question. It's not a broad privilege. It is a quite narrow one. I think what would be an interesting question here, and I'm not sure the answer. It's never come up. I've never had to research it. But the fact that he's already testified. He's testified to a grand jury. He's testified at this previous trial. May have testified in his IA hearing or given a statement or something like that. If he's already made these statements, is that an argument he's waived as to that statement? So he can be compelled to answer the same thing. Him answering it now on the stand doesn't put him in any greater jeopardy than having answered it before already does. and by answering before, he waived. I'd be inclined to think so. There is some not particularly defense favorable case law on the Fifth Amendment, where it pretty much says, like, if you want to invoke your right to silence, your way to do that is by staying silent. Like, you have to just do it. And it's I got to tell you that the Fifth Amendment case law is a mess. It's just it's not, no, lay people don't know what their rights are. Lawyers, here I am telling you, here's like a nuance in this area of invoking your privilege against self-incrimination, and I'm not sure if it works, if it could be held against you or not. Sometimes if you just sit there silent, that can be used against you, but sometimes you absolutely have to sit there silent, because if you just say, I want to exercise my right to remain silent, that's not valid. That's not valid. And then if they provoke you into saying something, you've waived. So probably a pretty strong argument that the invocation of the Fifth is the exercising of it when it comes to silence. It's not like saying I want an attorney, which also there's a gazillion rules around, guys. You can't say I think I want an attorney. You can't say I should probably have an attorney. You should probably not say I'm not answering any more questions if my attorney isn't here. All of these things can be potentially equivocal invocations. See, you got it. You can't just exercise it in a common sense way. You got to follow the formula, say it in the magic words, unequivocal. Don't say I think I need a lawyer. Say I demand my lawyer. You got to make it as clear and unequivocal as possible. But yeah, I think there's a decent argument that you've already waived as to anything that he already answered in the first trial. He already waived his right as to those statements. So you could compel him to, if I'm right, you could compel him to answer everything that he answered in the first trial. A Fifth Amendment invocation would not be valid. It's just if you go beyond that. If you go beyond that and ask him things that might incriminate him, then potentially he could take the Fifth to that. So, yeah, he could. It's definitely not impossible. KC Cat, have you seen the creator with the medical grade arms and exact taillight doing experiments on video? Every time the arm is broken in multiple places when using Commonwealth theory. I haven't seen the arm videos. The only one, I can't remember the name of the creator now too, and I'm sorry, it's B something with like numbers. So I can't remember it off the top of my head. But he did the tail light video, the breaking the tail light. We just talked about it, I think yesterday, maybe the day before. I found it fascinating. I thought this was a great video. This is exactly the kind of thing that I'm like, I hope this is what the defense is having ARCCA do. Go out and bust that tail light and then light it back up so that we see, when we're looking at all these dark videos, what that tail light would look like if it were in the condition the Commonwealth says that it was in. And if it doesn't look like that, then it wasn't in that condition. Very compelling video. Thought he did a great job. I know he's made other ones. He's continued to do all kinds of stuff with the tail light, and I know he did some stuff with arms. So I think that's who you're talking about, but I haven't seen any of those. Yeah, I just don't see how you're going to hit an arm with a car. The difference in mass. I mean, what does a human arm weigh? 15 pounds, a guy's arm, 20 pounds, 30 pounds. If he's real jacked, he's probably real jacked. I don't know. I'm not sure, but it's not a ton versus a nearly 2,000 pound vehicle. I assume, also, I don't know what the gross vehicle rating of Kerry and Reid's SUV is, but, somewhere between half a ton and a ton, I would expect. It is a massive weight discrepancy. mass discrepancy. And so, you know, the force that vehicle at that speed is inflicting on this arm, you don't just get some scratches and not even a bruise. You know, forget about the lack of projection because it's not your center of mass that's being hit. You just be spun, you know, or your arm would be knocked and you might trip or something like that. But it's hitting your arm really hard. Really hard. Yeah, I'd expect you to have broken bones, but at a minimum, you would have major contusions. Major contusions. Kelly Brennan's lost big boy pants. I think the defense are going to go hard loud on changed testimony and lack of memory by everyone on this. This will stick in jurors' minds. I don't know. I mean, yeah, it seems like that's what they're going to do. It seems like that's what they're going to do. This can be a double-edged sword, guys, because part of the problem is that it's sort of normal for there to be minor changes. We talked about this. This is memory. Memory is not perfect. Memory is a rewriting. It's very fallible in every single one of us, and it's perfectly normal for pretty much everybody who is telling a story to have minor inconsistencies between the times that they tell it. So if it's going to be good for the goose, it's going to be good for the gander. There's probably going to be inconsistencies in defense witness testimony. And now we're going to have Brennan, you know, do the same thing. So if you're kind of setting that as the standard for who you should believe and who you should give credibility, you might kind of be shooting yourself in the foot a little bit. If minor inconsistencies are enough for you to discredit anybody, then unless your witnesses have their prior testimony memorized and repeat it verbatim, that cudgel can be wielded against them too. So I don't like that as the standard. I just don't. I prefer a standard where, yes, we understand there can be inconsistencies. That's pretty normal. The only ones we're going to focus on are the ones that matter. If there's an inconsistency that's significant, then I'm going to be able to draw a distinction between I was able to show you when this witness said something different, it was about something really material. Mr. Brennan over here is quibbling about, did she say argument or last words, just for example. So yeah, I do think this is what they're doing. I get it. I just don't agree with it. I don't like it. I don't think it's effective. This is the same thing they did the first time. It's not consistent with their theory of the case. It doesn't matter. Everybody can tell different stories every single time. And the only thing that still matters is, did John O'Keefe get hit by a car? Casey Cat, thank you so much. The creator who did the experiment was Be in Trouble 31. I knew there were numbers in there. Be in Trouble 31. I'm one of those people that's terrible with names anyway. I hate it. I'm really sorry. I would like to be better, but I'm just not. I'm one of these people. I will meet you. You'll tell me your name, and 2 seconds later, it's gone. The only way I remember people's names is by saying them, and preferably saying them multiple times. So I'm going to keep saying Be in Trouble 31 in the hopes that it will stick, because he has made fantastic videos. I found that one just really, really intriguing. So love to see stuff like that from ARCCA. Zencat, question for Andrea, the ace gardener. If the ground is frozen hard, would blood still soak in or pool on the surface? Well, of course, I'm not a soil scientist. But no, if the ground is frozen, blood is not going to seep into it. A frozen object it's got water. The water is in a solid form. It is not receptive to liquid moving into it. So no, the blood is going to pool on the top. how is this all going to work with things like temperature differentials and stuff? Okay, the body heat and the heat of the blood, and that's going to warm the ground. But then how's that? Is the cold of the ground? How's that going to equalize? I don't know. That's way out of my pay grade. But as a general proposition, if the ground is frozen, the blood is pooling on top. It is not seeping into the ground. Liquid does not flow into frozen ground. So there's no point if your ground is frozen solid in the winter, you don't need to go water. Nothing's going to happen. Yeah, there's going to be a lot of blood, and we don't have a lot of blood. I really hope we have some more about that too. That was an issue in the last trial. We're kind of like left out there waiting to hear, where is all the blood? And we never heard about that one way or another. Obviously the Commonwealth didn't tell us, but it just wasn't a point the defense raised. To me, that's very significant. It's an important just point to clarify if he could have been killed by this car accident in the way the Commonwealth is describing. He landed there. Where's the blood? I would buy that it's in the ground under the right set of circumstances. I don't buy it's in the ground if the ground is frozen. So I need an explanation. I'd like that to be fleshed out. Hopefully it will be. Hospice Jess, and why would law enforcement delete the best clip on the Meadows ring cam? If they want to pin it on the girl, why delete that? Because I don't know. Maybe it's too clear. Maybe they can see, like, if she's picking out a piece of glass, leaving it at John's, or a piece of plastic and leaving it at John's. I mean, it's not like they recovered every single piece of plastic, right? They had the little section that was missing after they recovered all the 47 pieces of plastic and took them to the lab, and the lab painstakingly taped them all back together. And there was still a chunk that was missing. So, like, the fact that she picked out a piece and left it at John's, they could say, "Oh, it was that chunk." But if everything else was missing, there was like nothing really to hold in that chunk. I don't know. I really don't know. Without seeing it, it's kind of hard to say. You would kind of think, everything else being equal, that might be helpful to the Commonwealth. To see Karen, acknowledging a broken taillight at 5:30-ish in the morning, after she's gotten home from dropping off John, but before they found him again, before they headed back and found him. I don't know. It's a good question. $1 million question is, where is the Ring video camera, and who had access to it? Why is it not there? I would like to get an answer from Ring, because that is a big question. Melanie, I think the fact that Kerri only told the truth to, quote, the other investigators makes it clear that she lied / perjury to the grand jury. Let me go back and look at what she said exactly about the other investigators. Gotta find her cross in my notes, going back to day 2 here. Spoke to the DA's office a dozen times. Nelson, that was that whole thing about the 50 some times she's been in contact with the prosecution team. met with other witnesses, met with Brennan. What she saw as the injury. Interviewed on January 29th by Dunn and somebody else. She was in shock, so that's why she didn't mention anything about the tail light, about Karen showing them the tail light. She didn't want to accuse anyone. Didn't want to accuse anyone. Maybe the simplest explanation is that it didn't happen. Nothing, in fact, got deleted from Ring. Maybe that's actually the answer. It didn't happen. And there's been no deletion of Ring video. But we don't see them leaving, so that would be why. If they just left the same way that they came in, you know, just walk back, don't have this moment where Karen shows them the taillight. But when would you delete that? I don't know. I'm gonna kind of follow this through a little bit more. She had prior testimony. The first interview was with Dunn and Chico. Second interview 3 days later was with Connor Keefe and Kathleen Prince. That was on February the 1st over at Jen McCabe's house, where they'd been assisting each other's memories by creating that timeline. Later that night, she wanted to talk to Proctor because she remembered for the first time that first phone call from the morning where Karen said, "Is he dead?" I think a plow hit him or whatever. The fourth interview was the one where she signed the consent form for her phone. It was right after Karen was arraigned. They gave over their phones. Fifth time in front of a grand jury. Didn't hear about the Google hypothermia, but did testify about it to the grand jury. Later, you were asked about that statement. You were interviewed by a separate law enforcement agency. They asked if you heard Karen say anything to Jen about Googling. You told them, "I didn't hear Karen ask Jen to Google anything." And that was when they looked at the 302 and refreshed her. That's what she said. She did not hear Karen ask Jen to conduct any Google search. I mean, it could, or it just could be that they asked a better question. Honestly, they made it more clear exactly what they were asking about, what they were talking about in terms of, when we say that you heard, do we mean that you heard yourself, or do you mean that you heard someone tell you so you know about it? Really wasn't a great question. They might have asked it better. I can't with what we have. I don't think get to lying, perjury. Certainly it's possible. Very conceivable explanation of what happened, but I don't think it's been definitively established. Definitely not enough to prosecute, because Lally asks really bad questions. If I'm the defense attorney on that On that case, I'm going through that grand jury transcript of her testimony, and I'm identifying all of the terrible questions that we know that Mr. Lally asked. They're like 10 sentences long, all kinds of subordinate clauses that trail off and lead nowhere and then circle back and reference other things, and terrible, terrible questions. I'm going to set the stage. This is the context where she's dealing with trying to understand this guy. So yeah, she might have misunderstood the question. That's what I'm doing if I'm the defense attorney for Kerry Roberts on a charge like that. So I don't think it's definitive, but is it conceivable? Of course, absolutely. Lucy Fair, morning, Andrea. Regarding the text, sounds like Karen needed reconciliation, John needed space to process, and neither communicated their needs effectively. A crucial dance in healthy relationships. Yeah, communication is the key. It is the key. And just because people have, different tendencies with how they behave and what their needs are and so forth, doesn't mean that we're just going to automatically be on the same page. Doesn't mean that we're bad people and that we can't learn to accommodate that. You have to want to. But yeah, you can learn to communicate better what your expectations are, what the consequences are going to be if they aren't met, and yeah, what you need. So I definitely think communication is pretty much the top requirement for a good, healthy relationship. Bella's mom, do you think Kerry was told to get the O'Keefe's and plant the theory that Karen hit John? Peggy said they had 4-wheel drive. I don't know. One of the things, honestly, that I thought about after we saw Peggy O'Keefe testify and we heard about this antipathy, that she seems to clearly have for Karen's contempt for Karen. What is she doing here? All that type of thing. We already know she didn't like Karen. And then we hear that story from Karen in the interview clip that they played. She leans over the table. Looks like he was hit by a car. Looks like he was hit by a car. What crossed my mind is that what was going on this morning was not they had hatched a plan, the conspirators had hatched a plan, and they were executing it with foresight and strategy. No. What crossed my mind is that this has all just been panic and opportunism, waiting for the opportunity to be able to put things together, to come up with something that was going to work. And that it's very possible that he was hit by the car generated from Peggy. She's the one that had the idea. Because she already thought that. She already hates Karen. She's already inclined to think Karen did something wrong. Why did you just drop him off there? And like Karen said, she sees the busted tail light. Maybe he was hit by a car. Maybe it came from Peggy. And that was just the opportunity. That was just the opportunity that the hoaxers needed to put that together. Can we make that fit? We saw her there at that corner. We have the text with John about coming in. We'll use that. The broken tail light, we'll make up a story about how we saw the broken tail light. Maybe it could have gone the other way. I mean, maybe as it comes out, there would be things that would foreclose that, but I don't think so, because it doesn't seem like they had a theory from the go. Yeah, they had a lot of butt dial conversations and stuff like that, but they had to continue to keep doing that after the fact. If you'd come up with a plan before Karen Reed ever shows up at Jim McCabe's house, and then all they have to do is execute it, they don't have to have all that sketchy behavior. It's almost kind of because they don't have a plan and they have to adjust to things as they're unfolding. That's why they have to continue to meet at Link's house and meet at Jen's house and go back to Brian Albert's house and, listen in on each other's interviews and stuff and get it all coordinated. It's because they're just taking advantage of the opportunity that presented. They were going to play dumb. I think that's what the strategy was. They were going to play dumb. There's a man in the snow. There's a man unconscious in the snow, playing dumb like you don't know who he is, like you don't know why he's there. You knew who he was and that he was coming to that house at your invitation the previous evening. So I think they were going to play dumb until they couldn't. He just never came in. I don't know. No idea. Never saw. And the pieces came together and they were able to make it fit. Think about that. Think about that. Let me know. Let me know if there's something that like precludes that makes that not possible. But I think that might be plausible. And it might, these guys aren't masterminds. These guys aren't criminal masterminds. Rarely are criminals masterminds. But these guys are not. I'm sorry, criminal mastermind does not take their SIM card out of their phone and put it in a separate bag and then take their phone and the SIM card bag and drive them to a military base and put them in a dumpster the day before there's going to be a preservation order telling you you can't get rid of your phone. That is not criminal mastermind stuff. So I don't think it was Kerry planting it with the O'Keefe's, honestly. I'm starting to think this is all Peggy's brainchild. Not because she's trying to pin it on Karen or whatever, but she just already suspects her. And it was an opportunity. I'm like, all right, well, we can make that fit. The taillight's busted. Let's go with that. Maybe. Lucy Fair is a YouTube member. Welcome, Lucy Fair. Thanks for joining us. Pine Writer, severe myopia causes that type of document reading by the good doctor. His glasses did not have the transition lenses to account for his age-related close-up reading. See, this is why I love the chat. That's why I love you guys. I don't know. I don't have glasses. I don't wear contacts. That's right. My perfect eyes. No, I'm not really like that high on my eyes or anything, but yeah, I do. I have good eyes and always have, and I don't wear glasses. I'm getting close to 50 and don't need them for reading or anything yet. I'm sure it'll come. So I don't relate to bad eyesight. Sorry guys, I don't know what that's about. So good to know. Good to know. Why wouldn't he be wearing the right glasses? Just out of curiosity, if anybody knows why. Are they like bad for some reason? Are they bad for, I'm assuming we're talking like a bifocal-y kind of thing, but I could be wrong. I'm just not sure. Like I can see how you would need some glasses for some purposes at some ranges that would be bad for like other things, that's why you have bifocals. Would there be a reason why it just seemed, I don't know, seemed weird to not have them, but maybe he wasn't anticipating reading. I don't know. I don't recall if he read last time. I'm pretty sure he did. But perfectly good explanation, sounds like. I wasn't, trying to hold it against him or anything like that. It just was very noticeable. My goodness, that guy is having a hard time seeing that document. CT is a YouTube member. Welcome, CT. Thanks for joining us. Jonna, thanks for turning on my brain and helping me see all new perspectives on this case. I love your calm, reasonable opinions and legal insight. Well, thank you so much for that, Jonna. I appreciate it. I'm a big fan of the marketplace of ideas. I love to chat. I love to throw ideas off each other, and everybody has different perspectives. And yeah, consider those. I think we're 4,900 people approximately here right now. 4,900 brains are better than one. A lot better than one. So it's one of the great things I love about this experience, this process of watching a trial collectively and processing it collectively. is that ability to spin things off of each other. Here's one from Christy Allman. I saw this fly by in the chat, and so I started it because the doctor was on Redirect then talking about the MS study and the lactic acid. They were talking about different studies. That's what the issue is. Ms. Little was referring to some study that had to do with NADH levels and how those correlated with MS. He was talking about something else that had to do with the lactic acid levels. So I don't know if it's, I don't know if it's a good study. I don't know if it's a limited sample size. I don't know anything about it. I don't think we even got the name. He didn't even know the name of this study that he was telling us all about. It doesn't matter. If it matters, we'll hear more about it. It doesn't matter. If it didn't matter, why did we bring it? But the defense has their own, they have their own pathologist. If this is essential, they can correct the record on that with the retrograde extrapolation, assuming they've properly disclosed it as rebuttal testimony or so forth. But yeah, they were talking about different studies. One had to do with NADH, one had to do with lactic acid. Chopped trials. My biggest thing with Kerri Roberts is her and Jen didn't know each other. Then they became besties to the point where they are dropping off kids together that day, and besties since. So weird. This is another one I can kind of see both sides of. Yeah, I can see how going through the fire with somebody might give you a kind of unique bond with that person. Even if you haven't, you don't have history in your relationship, just the experience itself could be so significant that that could bond you. I could see that. I could also see the possibility, Karen or Kerri didn't seem to have that high of an opinion of Karen either, did she? Kerri of the babysitter with benefits comment. I thought she was just a babysitter with benefits. Talking about John's randoms, and she was friends with John. She really wasn't friends with Karen. Kerri didn't like Karen either. So also very possible that what they bonded over is not liking Karen. How terrible Karen is. It's mean girls that tend to be around John. That's what we noticed. That was the pattern. A lot of mean girls around that guy. Mean girls bonding, doing mean girl things, maybe. But yeah, I can see how this also, looks a bit off. I can see how this looks a bit off. Just out of the blue, suddenly you have all this stuff in common just because you had one shared experience. I mean, I'm trying to think of a similar circumstance. I'm thinking of, like, I don't know, just the first thing that came to my top of my head was first fight I had, first boxing match. I remember my opponent. We ran into each other later, a couple years later, another tournament. Didn't become BFFs or anything like that. I don't know. It's probably not the same. Yeah, I don't know. I really don't. But I can understand. I can understand seeing that as maybe a little bit questionable. T-nasty. When evaluating a person for a 72-hour hold, if someone denies intent, they are free to go. This might depend on who you're dealing with. Honestly, there's like, okay, so by way of background, I myself did not do ITA, and in Washington, it's Involuntary Treatment Act, ITA defense. Jeff did. Jeff did ITA offense. So I heard a lot about that side of the process from him. But I ran into it a lot in my own practice, both because there is a often common pipeline between somebody being in crisis and somebody being criminally charged, people that are taken to jail that perhaps should be in the crisis situation instead, but aren't for whatever reason. We also ran into it a lot because we're in a small community, and you often end up needing to help people, like, for example, the ER, where people are taken when they're in crisis, and they're trying to get the crisis team to respond so that they can get their emergency bed back. There's not a psych bed open. They're saying there's no problem here. Like, there's a lot of different ways this has come up in my experience. And so I've seen it kind of in different communities, and it's honestly, the standards seem to be all over the place. If they want to put you in the hospital and detain you, they can probably find a reason why they would do that, even if you're saying, I don't mean anything wrong. I don't have that current intent. They can say, I don't believe you for whatever reason. You know, if she's not the one that reported it, the parents reported it. 72-hour hold, the standard is really pretty low. It's really pretty low. So I don't know. I feel like this might be circumstantial. I mean, I'll give you an example, kind of from my perspective, how bad things could get. We're not the only place in Washington that has a crisis management crisis. We don't have beds. We don't have resources. We don't have places to put people. And so, they end up in the ER, or they end up in jail. Like, that's just the reality. That's the housing situation. And then we don't have resources to stabilize them or transition them out or whatever. It's a mess. It's a mess. We're not the only ones with that problem. But that often shouldn't be the driver of whether somebody is detained or not. But the practical reality is it often is, because if you're the guy with the decision about should I detain this person, if you have to find a place for them to go, if you detain them and there's nowhere for them to go, you've just created a big problem for yourself. Your incentive is probably not to create big problems for yourself. So you just find ways that they don't need to be detained. So situation I remember was guy ends up in the ER because he drank, I don't remember if it was Drano or if it was lye or something extremely bad, extremely bad, required, immediate intervention. But they did. They intervened. They got there in time, intervened, stabilized him. Crisis team, he doesn't need intervention because now that the hospital has gotten, the Drano neutralized, he's no longer in danger. He's not currently drinking Drano in the hospital. He's fine. That's kind of how the standard can be. Now, granted, that's what they want to refuse, but it's not a tough standard. It's not a tough standard to hold them if they want, and they could easily write the report if they wanted to. They could say, well, she was incoherent. She was not super uncooperative, but somewhat challenging, and her mood was variable. And the parents had reported the comments. They were concerned about it. So, we determined it was necessary for evaluation. The 72-hour hold is just for evaluation. It's a low bar. So I think they could, if they wanted to not detain the person, be like, okay, that sounds good. But if they do want to detain you, I think they probably could, even if you deny it, because they don't have to believe your denial. They can come up with a reason why they shouldn't. Touche. I think Jackson wants to show that her anger was after he was ignoring her calls, not earlier, giving her the motivation to kill. I guess. But he was then suggesting, see, what I think he's trying to do is he's trying to discount there being, an argument between Karen and John at the car. That then she has the sudden explosive rage and goes forward and backs up the kind of way that Brennan told the story in his opening. Because Jackson himself brought up in his redirect, I'm like, please don't do it. Please don't do it. And he did. It could have been at 5. It could have been at 6. The argument could have been at 7. It's like, please don't do it. She already cut him. She cut Brennan off for that because he was doing that same obnoxious thing. The guy has already said, how many times do you want him to say, I don't know, when the argument was? He doesn't know. He doesn't know. You're just using your question to try to make a point. It's a little bit obnoxious. Please don't do it. He did it anyway. But he's suggesting it could have been the earlier in the evening argument. And that, I think, makes, unless she's, some psychopath, it kind of makes less sense that they had the argument, earlier. After he was ignoring her calls, meaning the missed messages, the missed calls that she was showing to Mr. Becker. But those, she never talked to John after that. There was no argument. I mean, maybe. I think the bottom line, he's trying to say it was the voicemail. So it was after she left. But she got mad in the voicemails for a reason. Was it just because he was not answering the calls? I don't know. She was mad enough to leave. And they have that clip. They're going to have the clip. Brennan's going to have the clip from the ID interview. Where she says she got mad and left. She's sitting here waiting. What the hell? Sitting here waiting. So I really, I don't know what Jackson is doing. Motive to kill doesn't matter if she didn't hit him with the car. I keep saying this. I know I keep saying it, but that's the bottom line. That's the bottom line. And if that's your fight, you should fight your fight. Don't fight the other guy's fight. Don't quibble over whether she has a motive or not, because then the jury might think that motive is important, and it isn't. All that's important is whether John O'Keefe was hit by a car. Bella's mom, why another voir dire when there was one in 1.0 and a testimony? I mean, Bev is using the voir dire as almost more of like an offer of proof. It sounds like it's really not a voir dire. A voir dire would be if we're doing this for the benefit of the Commonwealth. But the way she's described it, it's for the benefit of the defense. They're the ones that have to figure out what she wants and what they're asking and why. So she's making it sound more like an offer of proof. If it's an offer of proof, it's to show there's no shenanigans with the communication, no shenanigans with, retaining or not communication, and that there hasn't been misrepresentations about the substance of the communication. It's their offer of proof about that. And it's probably their offer of proof about what's their new stuff that they're going to present, that the defense wants to use at this trial that they haven't had the opportunity to disclose before. That's kind of how, I'm reading it. It really isn't a voir dire. It's probably kind of why it's confusing. If it was a voir dire, the ball would be in the Commonwealth's court. But it's not. She's made it really clear the burden here is on the defense. So it's an offer of proof, and it's basically she told him outright. Why should ARCCA be allowed to testify? I found a discovery violation. It's because she's looking for a way to keep him out or limit him. Tipped her hand on that. Apparent plastic. Was Turtle Boy in court? I didn't see Turtle Boy in court. They're doing a lottery this time for who gets the media seating in the court instead of having the chair battle that they had last time, which is probably wise because the chair battle was it was not a good system, very chaotic, much gamesmanship, promotes the Lord of the Rings type of attitude. Similar situation that we dealt with over there in Delphi. Although at least I get the impression the chair situation in Dedham there was like somewhat official. Over there in Delphi, this is just what we were able to agree amongst ourselves because the law enforcement was like, we don't care. We don't care how you sort out who comes in, and we're not going to get involved with it. So he, if he wasn't in court today, he probably just wasn't drawn in the lottery. Ryan Bibbs is gifted an Andrea Burkhart membership. Thank you, Ryan. Appreciate your support. The rural juror, I agree with you on the pigs wrestling mud, but the defense may be trying to give them multiple avenues to reasonable doubt in case ARCCA is out. Maybe if it's just, you know, I would have liked them to have addressed that in their opening. If they were going to have a real backup theory, if Karen Reed was framed as the backup theory, would have been good if it were spelled out a little bit more clearly and more specifically, because otherwise it does seem a little bit out of the blue. Okay, we've got the powerful Albert family. But what does that have to do with all these people? Just hasn't really been, the circle hasn't been squared on that. That may very well be what they're trying to do. It just looks a little unorganized, unplanned, kind of chicken with the head cut off, just you know, impeaching on what we can, where we can. No, if you need an alternative reasonable doubt theory, come up with one. Identify what is your backup theory of the case. If I can't rely on John O'Keefe wasn't hit by a car, then what am I relying on instead? This, you know, next kind of biggest backup theory they gave us is Michael Proctor messed up the investigation. So Michael Proctor didn't go down roads that he should have gone down. He didn't ask questions that should have been asked given the circumstances. That's not really directly relevant to people, you know, having minor inconsistencies in their testimony either. Because that's happening after the fact. I don't know. I just, you know, if it is, it seems like one that is not. It's not all the way thought out. It's just kind of happening. But it's possible. They're just like, look, we're gonna need some doubt. We're gonna get it where we can find it. Ugh. If that's the case, honestly, it makes me very nervous. Because you're kind of counting on luck. Shotgun approach. We impeach everyone. Maybe one of them will stick. I don't like that. Taylor Cook. The idea of fairness to the state is rather absurd. The whole process up until the point of being in court is absolutely slanted in the state's favor. Yeah, and the being in court part is slanted in the state's favor too. You notice how they get to go first and they get to go last? They get to have the first word and the last word. And it's slanted in the state's favor there too. I know the state has overwhelmingly, you know, the vast majority of the power in this situation. The Bill of Rights is protecting the individual against the power of the government. The Bill of Rights, they are constraints on the government. Because the government is so powerful and we are so potentially helpless. The Bill of Rights doesn't even come close to leveling the playing field. It makes it a little better, gives you a little bit of a chance. But no, it doesn't level the playing field. You are still walking into the courtroom as the defendant with that systemic disadvantage of being accused of the law and order side, the white hats, people that are there to protect and help you and to deliver justice. You stand accused by them. And then they get to talk first and they get to talk last. In conventional courtroom architecture, they also get to sit closest to the jury. The conventional architecture, instead of front to back like we have them in this tiny courthouse here, where they're both to the side of the jury, but one's further ahead, one's further behind. Conventional courtroom architecture would be you have your defense table, your prosecution table, and your jury box is going to be over here on this side, the witness over here, the court up there. Prosecutor conventionally gets to sit closest to the jury. I mean, even very little things, they have advantages. The state has so much power that the idea that we need to bend over to make sure it's fair to the state is ridiculous. Kind of on board with that. Does that mean it should be unfair? No. But that's really not the primary concern, is it? With all of the resources that they have to wield and the authority, the deference that they get, the power that they have to, get evidence, etc. The risk that it's going to be unfair to the state, pretty low. And Hank with a super chat, just a super chat. Well, thank you, Anne. Really appreciate your support. Thanks for being here with us this morning. James Casatelli, if I'm on the jury of another case where I don't already know all the details and this is how the lawyers were acting, I'd be furious at them for wasting my time. I'm not learning anything from this. It does run the risk of making it look a little petty, doesn't it? Because this isn't what you told me this was going to be about when we were at opening. You didn't tell me this was going to be about what this was going to be about. You, prosecutor, told me it was going to be about facts, science, and data. And barring that, it was going to be on, what Karen said that corroborated that. You, defense, told me it was going to be about how John O'Keefe didn't hit Karen with the car. Or Karen didn't hit John O'Keefe with the car. It's day 4 of early mornings, guys. You told me it was going to be about Karen didn't hit John with a car and that can be proven. And the only reason people think that is because we have this lame investigation, this terrible, shoddy, biased investigation by Michael Proctor. And that has something to do with wanting to protect the powerful Albert family there in Canton. So what is the words Karen used? I mean, it slightly ties into the Commonwealth theory, right? She told you, but whether they, they had an argument or it was her last words, I don't know that I'm learning the most significant stuff from this. And it does. It runs the risk of it's kind of starting to look a little bit petty. This isn't the stuff that matters. And yeah, as a juror, most people don't want to be there. I would love to be there. I'd love to get called for jury duty. Last time I received a jury summons was, about 20 years ago, just about right after I graduated from law school, moved back up to Washington, about to start my clerkship. Then I get a jury summons for the federal court down in San Diego, where I'd gone to law school. I don't live there anymore. Couldn't do it. Haven't been summoned since. I'd love to be able to sit on a jury. I'll probably never get that chance. But most people don't want to be there. So yeah, they want it over as soon as it can be over. And you're not necessarily giving them a sense that you're respecting their time if they think you're being petty. Ryan Bibbs gifted 5 memberships. Ryan, thank you so much for that. Really appreciate your support. Meg, her voicemails accused him of cheating. Then she woke up and called everyone saying he must have had an accident. What changed? I don't know. I don't know. I think, her first reaction, she's John, you're a pervert. I guess that's probably accusing him of cheating. The voicemails, you're a pervert, you're a fucking pervert. I hate you. She says very not nice things. It's going to come out. I think what changed is her expectation that if he was just out cheating, he still would have come home because of the kids. He wouldn't have just cheated and hung out there and abandoned the kids. So it was only when she woke up and realized he's still not back and the kids are here. That's what she kind of told everybody. He would never not come home. I wasn't even supposed to be here. So that'd be my guess about what changed. She didn't expect him to not come home, even if he was cheating. This is John O'Keefe of the superficial relationships. Hit him and quit him. Maybe he'd just be on his way back home, take care of his kids. That would be my theory if I'm the defense. What changed? He didn't come home, and he would never have not come home knowing that the kids were there and she wasn't supposed to be there. Lori Bobori, is it weird to anyone else when PM paramedic EMTs refer to Karen Reed as the defendant rather than patient or Ms. Reed? That hadn't stood out to me, but it's a good point. They do like to, just another one of those advantages they have, point the finger at you, call you the defendant, depersonalize you, dehumanize you, and emphasize the fact that you stand accused. If you keep calling her Karen or you keep calling her Ms. Reed, she's a person. And so you might have empathy with her. You might relate to her. From a prosecution standpoint, the more you can make that person over there an it rather than a who, then it makes it easier to separate that person from the jury. Jury can turn off their feelings. It's not a person like a person I would empathize with. It's an other, it's an it. So it's a very, very common strategy for, police, prosecutors and stuff to use the defendant if they can. So this does, signal probably possibly some coaching, some prep. Prefer that you refer to her as the defendant. For clarity, we're trying to have all the witnesses do that for clarity. Something like that. Or maybe, maybe it's just part of what we've seen with the, supporting your team. If you're on Team Commonwealth, you're on Team Convict. You see, that's how they call her. You're going to call her that too. Maybe. I don't know. It hadn't caught my attention that paramedic EMTs were calling her the defendant, but you're right. Now that you mention it, I can think of like once or twice. This guy, Mr. Becker, he did seem to focus on, Ms. Reed a little bit more when he identified her. He identified her as the defendant. But yeah, no, you're right. He did at the very beginning when they first got there. I parked behind the engine, spoke to the police that were there, and they sent us to the defendant. I put that in my notes. And the defendant was sitting in a black SUV. Yeah, I guess maybe he did. Maybe it didn't catch my attention because it's just background for me. I'm kind of used to all the witnesses, prosecution witnesses doing that. Didn't necessarily stand out to me that this is a paramedic EMT. They don't encounter her most of the time as a defendant. They counter her as a patient. So that's, they even said, never expected to be testifying in a murder case. So you wouldn't make that association. You would associate her with your role in it. And she was your patient. I think this is an excellent point. Thank you, Lori Bobori. I hadn't thought of that at all. Mike from Providence, with all the confusion with Safari tabs, with how long to die in the cold, why can't they get someone from Google directly who can definitively say when the search results were sent to the device? We wondered that last time. Is this something that you can look for through Google? I don't know. I don't know. Never had to try to identify the specific time of a specific Google search from a specific device. I don't know. I don't know if it's feasible. I don't know if there's some technological limitation. I can certainly say there's, challenges when it comes to subpoenaing Google. But those are practical. Those can be overcome. I don't know. Seems like a good side approach, doesn't it? An alternative approach. Why hasn't either of them done that? I can see how maybe the Commonwealth wouldn't do it, because if it comes back and shows there's been a search at 2:27 a.m., that's Brady. You got to turn that over. You got to turn that over. So you just don't ask. The defense, though. Defense, the problem is probably the way it works in Massachusetts. To do the third-party discovery, you got to get the court's permission. So they're going to tip their hat or tip their hand to the Commonwealth that they're looking for this. If they didn't have to do that, if they could just go and subpoena it themselves and never have to tell anybody unless they're going to use it at trial, then probably would have happened. And then, not officially in trial or whatever, but here while we're chit-chatting about what everything means, we might assume, yeah, they probably would have done that. So if we're not hearing about it, it's probably not good for Karen. But that's not how it works in Massachusetts. They would have to tip their hand. And so now they're in the same risk as the Commonwealth, that whatever answer they get, they're going to have to turn it over, because he's instantly, if it's not already required, Brennan is going to send them a discovery demand. Send me what you have on Google. So it's a high risk question for either of them to ask. This is for anybody that was watching Delphi, one of the questions that came up, you had all of these eyewitnesses to Bridge Guy. They claim to have seen Bridge Guy out there on the trails that day. And not a single one was asked, is this gentleman right here that's sitting in the courtroom, Mr. Allen, is that the man you saw? Not a single one was asked to identify Richard Allen. And this was the same situation. It's because it's a high risk question for both sides. The answer is going to devastate one of you. So nobody's going to ask it. They're just going to let it go unsaid. If the Commonwealth asks and Google says, yeah, it was at 2:27, we're done. We're done here. Your case is destroyed. A little bit more leeway with the defense. It's not critical. It's not critical information, but it maybe for face-saving purposes. You've already dug in on this 2:27 a.m. And if you go and find out, nah, it never happened, you're going to have to backpedal. That's not so good. That might be the reason why, because they don't actually want to know the answer. They prefer to be able to proceed with the uncertainty, and each side can tweak that to their advantage the way that they want. Lucy Fair, on 2 a.m. butt dials, perhaps they waited for Lucky to make first pass and calls were to confirm it. Didn't expect a second pass and wanted to pin on him. Very possible. Very possible. Just keeping tabs. You know, you drove back. You drove back to CPD. Who's there? Who's out? What's going on? Get the lay of the land. Yeah, it could be. Wait for Lucky to make the first pass. The timing does, raise some question. Why at 2, 2:30, something like that. I forget the exact timeline. It's the only other thing on the timeline that we have that we know was going on other than Hoslong to die in cold. It's the only other thing that really fits in there. So yeah, I think that's possible. I think that was always kind of one of the opportunities they had in mind, one of the possibilities. We'll just play dumb. We'll just play dumb. He'll probably die in the cold. And, maybe they'll pin it on the plow driver. Maybe they'll believe that he tripped and fell. Maybe they'll think Karen did it. It doesn't really matter to them as long as it's just, don't look over here. We don't know anything. Possible. Sham wow. How do 2 talented lawyers who are married solve their differences? There's a lot of things that we don't agree on. That we have different perspectives on in a lot of ways. But I respect my husband as a very intelligent person. That's why I married him. He's the smartest man I ever met. I'll scoop that one up. And so I respect it. I respect his opinion. I appreciate that it's not going to be knee jerk. It's not going to be, groundless. It deserves respect, even if I don't agree with it. I don't know. I guess maybe that's your answer. Just have some respect for each other. Helps if you like each other, helps if you like your partner. Then you won't humiliate them in front of the entire world when you have your big moment on the stand and be like, oh, I've been married too long. If you actually like the person you're married to, you won't do that. Yeah, just respect and communicate and just always try to be better. Nobody's perfect. Nobody's perfect. You make mistakes. Try to figure out, care about that. Care about the fact that you made a mistake and that has an effect on this person that you love. And so, what can you do to not inflict that on them? Instead of kind of like being self-focused and, me and I have these problems and, I want this, I want that, you can focus on your partner a little bit too. I can be care about you and what do you need? He puts you first sometimes. Partner is a special person. So TG, would you agree that it is highly probable we have another mistrial here? Combine local powers dynamics with a highly publicized case. What odds do you give this being another mistrial? I mean, yeah, it seems not implausible. Oh man. I'm not a bookie. I don't really set odds. I would say it definitely seems like a higher likelihood than just an average trial because of the polarization. The sides are set, and the odds that one party got exactly the jury that they want and the other party didn't is low. It seems very low to me. So I think the real question here is a mistrial more likely than any other resolution? If I say probably, then I got to put this at least 51%, don't I? Guess I got to put it at about 51%. Yeah, I think more likely than not. Just the circumstances, and now the fact that everybody, just about everybody who came in for jury duty had heard about the case. Not everybody's going to fess up to having opinions, let alone, fixed opinions, ones that you wouldn't be willing to modify with the addition of new information or whatever evidence at trial. But that doesn't mean your ability to say that you would do that doesn't mean, that you actually would. So it just seems like a very low likelihood that they've been able to weed out the jury, have them separate from those positions that have just already formed. Your FKR, your AFKR, No, nuance is not allowed anymore. Haven't you heard? You don't get to be nuanced. You gotta be on a side. You gotta be firmly on a side. You gotta not change your mind. Obviously, my opinion, having watched this trial before, going on the evidence, don't think John was hit by a car. So I don't think Karen Reed is guilty. But I'd be open to change that if you can show me a plausible explanation for how all this works that's consistent with the evidence that we have. Because I definitely did not see it in the first trial. So for me, that's the bottom line. If she didn't hit him with the car, she's not criminally responsible for his death. Period. If the jury is willing to just look at the facts and they can just follow the facts, given how the case is presented to them, which I do not have a lot of optimism about after 4 days in, I don't have a lot of confidence that the jury is going to be able to focus, laser sharp on, was John O'Keefe hit by a car? Because there's all this other stuff going around in the horizon. If they just focused on that, and that was all that mattered, and that was all that they were going to take into consideration in making their decision, then yeah, I think she gets acquitted. If this is all just objective, purely on the facts, on the evidence. But it's not. It's happening in this context where people have already made up their minds about stuff. And we've talked so many times about cognitive dissonance and confirmation bias and all that. You're going to see the stuff and interpret it and tell yourself stories to reinforce what you already believe. That's what people do. If you are vested in your decision. So, unfortunately, I got to put a mistrial at about 51%. John Harmon, she give phone to the showed the MC to guy in the ambulance. That was her own phone. That was Karen Reed showing him her own phone, is how I understood it. Not that it was not that this was John's phone, and he kind of wanted to distance himself from it too. I didn't want to look at her, I wasn't going to look at her messages, look at her phone or whatever. So I don't think he took anybody's phone. I don't think she gave him anybody's phone, but if, to the extent there was a phone going on in the back of the ambulance, it was her showing him, here's all the missed calls I made to John on my phone. They show up as missed calls. So that's how I understood it. Would have liked to have had that clarification on whether he was the first responder Kerry Roberts gave the phone to. We know he's not, but get it on the record. Make it clear. Auto Doctor 911. How much coaching is okay? What is sanctionable if not okay? You do not get to tell witnesses how to testify. You don't get to tell them what the answers are. You don't get to be like, I'm going to tell you this question, and this is the question I'm going to ask, and here's how I want you to answer it. No, that would be bad. That would be sanctionable. But short of that, there's some flexibility. You can encourage answering different ways. You can practice. You can practice. I'm asking you this question. You give me your answer. I can point out that your answer might have, the potential to be misunderstood because of this. Think about that. I'm not telling the witness what to say. So I'm not coaching the witness. I'm not doing anything proper, but I am kind of helping the witness testify better, testify more clearly. So that's where the wiggle room is, kind of in there. You can't tell them what to say. They're the only ones that know what the truth is. So that's pretty much where the line is. But how they say it and helping them, be clear and present in ways that are most effective and most accurate. Yeah, you can help them with that. Emily Sparkles. Yesterday, Emily B. read the verbiage of count 2. It's very confusing. This may be why defense is digging deep with each witness. Well, it is. Count 2 is the voluntary manslaughter charge, and it's as the result of reckless conduct. It caused the death of another person, of John O'Keefe. And so one way that can be established is by, she drove drunk. But that's not the only way. And so I kind of recall Juror Ronnie in his interview talking a little bit about what the jury struggled with a little bit with count 2 and why he temporarily was kind of receptive to that. And it was this idea that, well, had she not driven drunk, John wouldn't have died because he wouldn't have been there. Whatever happened wouldn't have happened. And so, is that a way to shoehorn this event into voluntary manslaughter, even if she didn't necessarily hit him with the car? So that's a different problem because that's getting into causation. That's getting into an issue with causation. Karen's conduct has to cause the death for it to be actionable, and causation in criminal law is not but for, okay? But for Karen Reed's being hired at the place that she was hired at, such that she earned what she did and was able to buy this Lexus in order for her to be out there that evening in the car with John, is a but-for cause of all of this happening. Okay, but that's not criminal. That's remote. That's remote. So it can get confusing. It doesn't have to be like a completely unbroken chain of events. Like the exact proximate immediate cause. If you hit somebody and they're injured and they get taken to the hospital and then they experience complications and die, you're going to be held responsible for the death, even though their complications kind of intervened. If they hadn't gone septic, they might have lived. But they went septic, but they died. Doesn't matter. You set that chain of motions, chain of events in motion, and it's close enough in that causal chain that you're going to be responsible for that. So it can be a little bit of a fine distinction, but the point here would be, if, for example, hypothetically, John O'Keefe died because he went in the house and he got in a fight and a dog chewed on his arm, and as a result he fell back and he split his head and he was instantaneously disabled, rendered unconscious, bleeding, severe brain injury, and was ultimately placed in the cold and died. Those are a lot of intervening events between Karen's decision to drive drunk and drop him off and John dying. This is not just a normal, foreseeable thing that happens that I put in motion, like disease processes resulting from an injury are. Infection from a wound is very foreseeable, very predictable. Doesn't happen every time, but it's not a surprise when it does. Somebody getting beat up because you drove up and drove drunk and dropped them off at a party, and things went too far, and then needed to cover it up. That's not really a foreseeable and natural logical progression from the decision to drive drunk. So that's a causation issue, and that's where that limitation is. That's where the distinction needs to be made. I can understand, maybe fighting it on the driving drunk side, just to try to take some of the sting out. It's just they're probably not going to win on that. It's not the strongest one. It's not the strongest one. I think they do way better on focusing on, look, if something else entirely different happened to John, that's not something she caused. So she's not legally responsible for it. Her driving drunk didn't cause anybody to beat John up. She didn't foresee that. She had no idea it was going to happen. It's a causation issue. But it could be. I mean, you're right. That could be. They could just be thinking we need to really, really attack this alcohol prong, this intoxication prong. But now that they got Karen's words, we heard in like several separate clips. Yeah, I was clipped. Yeah, I was probably OUI. Yeah, or I was buzzed. Yeah, I was probably OUI. Yeah, I probably shouldn't have been drinking. Yeah, I probably would have been safer if I hadn't. That's probably not a winning strategy. You got to pick your battles smart. You got to focus on the ones you have the best chance of winning. And they got a way better chance of winning on that. If this other thing happened that Michael Proctor never bothered to investigate and look into, for example, I'm not saying it did, it's just a possibility. And if it's a plausible alternative possibility for what happened, then it's reasonable doubt. If that happened, Karen didn't cause it, so she's not responsible. Whatever clever. Are there ethic rules re-witness prep? It's the same thing. Like I mentioned before, both parties are really on the same footing here. You can't tell the witness what to say is really the main thing. Obviously, you can't tell a witness to lie. That would be like a whole level beyond just the sort of ethics of prepping a witness. You don't get to tell them what to say. You can help them work on the best way to say it and the best way to communicate, what you know their story to be from, their previous interviews, other times you've talked to them, so on and so forth. You can help them refine it, but you cannot tell them what to say. Edward Kirkpatrick, he's waived so much of his fifth already via prior testimony, so he can't really hide behind it. That's my thought too. I think he's waived it. I think by answering the questions on the previous occasion, he waived his right to remain silent as to those questions. Even if he did invoke his fifth, prior sworn testimony is an exception to the hearsay rule when a declarant is unavailable. And a declarant is unavailable when they take the fifth. So they'd be able to get it in through his prior testimony anyway. So the only thing I think he can invoke the fifth on is anything he hasn't already testified to that has the tendency to incriminate him. So Sallyport video stuff, maybe. Cell phone stuff. Handling it. Had that code, maybe. That pus code. He and Trooper Buchanan both testified last time. They sat and watched her put it into her phone to get Michael Camerano's contact information for them. And then they verified it with her. They had her freaking code, and yet somehow it didn't get passed on. Didn't get passed on to Trooper Guarino here. Tammy Martin, do you think Brennan will stop ARCCA? She really wants to. She really wants to. I mean, I think that's clear. She's reaching for reasons, justifications to interfere with what ARCCA is able to do here. She has previously tipped her hat to, I'm not going to exclude them as a sanction because of Karen Reed's right to present a defense. And that is a very important consideration and limitation. So giving Judge Bev the benefit of the doubt, she recognizes you take them away, you're saying Karen Reed can't defend herself. So you have to have an extremely good reason if you're going to do that. So what might justify that? Well, if she, let's just say hypothetically, she gets from ARCCA in the production they were ordered to make, the 70 some text message, whatever, the many text messages, and then they get on the stand and they testify about their phone calls and they talk about how they were tweaking their testimony. We're saying this hypothetically because it seems pretty improbable, because they both had the same report. The Commonwealth and the defense had the same report. So if the testimony was different at trial than what the report had called for, it would have been called out. You would have noticed, hey, you modified this. So I think it's pretty unlikely that that happened. But hypothetically, if something like that if they were able to go in and establish that the defense was able to influence how ARCCA produced their opinions and then lied about that, yeah, that would probably justify excluding them. Short of that, if you don't like how the attorneys behave, you got lesser sanctions that don't implicate Karen's right to present a defense. You can make the attorneys pay a bunch of money. You can kick them off the case. So other things you can do that are short of excluding her ability to defend herself against the crime. So I think it's very unlikely that ARCCA gets excluded entirely. But I do think she is building up to the possibility of, I'm not going to let you put on your rebuttal. I'm going to limit them to just what they put on the first time, because we can assure ourselves it was untainted. No substantive change from their report. The report was clearly not influenced by the defense, as long as we can establish there's no communication between the defense and ARCCA, before the report. But late stuff, it's late. She can say, I don't think it's justified. Is it going to be the best reason? No, but it's also not completely taking away her right to defend herself. Just her right to respond to the nonsense of the Commonwealth's case, which in itself is kind of a response to ARCCA. I would think. Surely Judd Welcher has read ARCCA's report. So I could see that. It's easier to justify. It's not as egregious. Still limiting her right to defend herself, but You know, fairness. And, technically they shouldn't get to respond. Well, no, I guess that's not true. They should be able to respond to Judd Welcher because they are. They are the defense. They are the ones responding to him. I think she wants to. She's trying to keep that door open. It's tainted, it's too long, you haven't acted in good faith. I don't know. The rural juror, David Yanetti, referenced specific Proctor texts in his opening. Why do you think AJ didn't? He just called him a cancer, no specifics. Well, he did. AJ did mention the specific text about, he focused on, he's a Boston cop too. That's the one he focused on. With David Yanetti, he got that drama moment because we didn't already know about the no nudes yet, and the other horrifying things that he was saying about Karen. Here, I mean, the main point that they're trying to draw out and emphasize in the opening is why the bad investigation, because he's a Boston cop too, and that is what matters. That's how we square the circle. He wasn't hit by a car, and there was a shoddy investigation, because if the investigation was good, it would have pointed the finger at the Boston cop. And Michael Proctor made it clear that wasn't going to happen. So he did bring out that text. I like it because it's more targeted. It's more targeted. And maybe it'll have more shock value when it comes out down the road. The other things he was saying about Karen, maybe the jury already knows this. Everybody, just about everybody who came in for jury duty, overwhelming majority, they already knew about the case. Maybe they already knew about this. It was pretty headline grabbing. Best thought I can think of. I mean, it's more targeted. I like that. I support that. You don't have to read every single text. They're not all important, but for purposes of your theory and why all of this happened, he's a Boston cop too that one is critical. That's critical. So that's why you pointed out in opening. And the others, they aren't as important. They're supporting. They certainly support your theory that he was biased and he was never going to give her a fair shake. But the reason why is what's important. And the why is because of the powerful Albert family. He said they're going to be protected. He's a Boston cop too. That Southern blonde lawyer, Brennan, trying to rehab the non-impeachment and Yanetti redundant crosses. Are both sides losing sight of the forest for the trees, trying to rack up every point in a game where total points don't matter? Kind of getting that impression. They're more interested in the fight than in what they're getting out of it. They're more interested in the engagement than what ground they are taking. I don't like that. I don't like it. You got to keep your eye on the objective. It doesn't matter if you win every single fight over here in an area of the playing field that is insignificant, that doesn't help you win the war. You got to fight over the stuff that matters. Don't fight over that stupid little gully over there. Fight over the hilltop. Doesn't matter if you beat up everybody over in the gully. It doesn't matter. As soon as you take the gully, you're going to get overrun from the gully too. Just a matter of time. You got to get that hilltop. That's the way you're going to make your advance to the ground that you're trying to take. Capture the other side's resources. You got to keep your eye on the prize and fight over what matters. See, I think part of what you lose sight of is that you take damage every fight. Just about. I mean, if you don't, you're always at risk of it, and chances are pretty good. They might be able to mark you up some. You may not come out of the fight, smelling all that great, looking all that great. Just because you won the fight doesn't mean you didn't get a black eye, you know? So how much damage do you really want to take if it doesn't matter? I do. I think it might be losing sight of the forest for the trees. It's so easy when you're a defense attorney to just, probably for prosecutors too, you're so embedded in a case, you've lived and breathed the case, you know it in and out, you know so much, you know so many of the details about it that it's hard for you to step back and see it as if you didn't. It's the same problem I'm having with trying to watch a retrial and think about how this is landing on fresh eyes, because my eyes are not fresh. I already watched the trial. I already got an idea of what's coming. And so if you haven't strategized this, if you haven't planned it out, if you haven't put in the prep ahead of time to already know this is what my objective is, this is what I need to establish to get to that objective, here's how I'm going to do it with each witness, here's how I'm going to do it with each piece of evidence, here's how I'm going to do it in my opening and my closing. It may not go exactly to script as at trial, because things rarely go exactly to script, but it gives you the structure that you need to know how to adjust. And so if you haven't done that, it's really, really hard to sort through on the fly with all of these details that you know in your head, which ones matter and which ones don't. And so it lets you get sidetracked. Oh, he said this thing and that's not true. And I know that because I remember it. I have this detail in my head and I remember the case so well. I'm going to call him out on that. You don't have to if it's not important. I do feel like there's just a level of antagonism here that is maybe driving how the parties are behaving more than what they're actually trying to get to. They just want to win. Yeah, lawyers sometimes they can be a little competitive. Maybe don't even necessarily care if they're right. They just sure do like to win. Maybe a little bit of that going on. Nikki O'Neill, it seems the Commonwealth are changing their theory from the last trial. Will ARCCA only be rebutting the new version of the theory? I don't know. ARCCA, I think is going to be a window into the fact that if the theory is changing, this is not the theory they started with. Potentially. I don't know. I mean, I would assume that the defense is always going to have the opportunity to bring in Trooper Paul, even if, say, the Commonwealth never calls him at all, and they want to just sort of forget all that. Call Judd Welcher, pretend like Trooper Paul's reconstruction never happened, and proceed on a totally different theory. I got to think the defense has the ability to bring that up. You were actually the guy in the MSP that was entrusted to do this, and you produced reports and you testified about it and you presented your theory, and now they're going with something totally different. I got to think that door is going to be open. It just goes to the credibility of the investigation. They need to be able to explain why did they rely on your theory enough to present it to a grand jury, present it in a prior proceeding, but now they've abandoned it in this trial. Jury gets to wonder about that inconsistency. So I don't know. I would not think ARCCA would be limited to just rebutting Judd Welcher. It's just that Judd Welcher is probably more credible than Trooper Paul. He's certainly got better. He's got a better resume for this type of thing. Gonna presume he's got a little bit of a better basic knowledge. He's probably familiar with Newton's second law. So I would expect they would focus on him just because he's likely to be the more effective witness. than Trooper Paul. And the reality is then, yeah, if the Commonwealth is discarding Trooper Paul, the Commonwealth is kind of conceding. That's not a good theory. So you don't have to spend time and energy and stuff rebutting that theory that even the Commonwealth is abandoning. All you're going to use it for is just to point out that's what you went with before and now you changed it. Hospice Jess, I've been picking up my kids with other parents all year whose name I had forgotten. Finally, one dad introduced himself to my son as Keith Score. Well, good. It's good for boys to meet men, all kinds. It's good for boys to have male influence, and a lot of it. A lot of different expressions of masculinity. I think it's generally a positive thing. Kelly Brennan's Lost Big Boy Pants is a new YouTube member. Thank you, Kelly. Brennan's Lost Big Boy Pants. Welcome to the channel. Appreciate you being here. Boston Brandy posted TikTok of Jeff Leary's call with Haggerty, the tow truck driver, in July 2023. No one took photos and he didn't see any damage on the car. It's important, right? And that's not taking photos is consistent with there not being damage on the car. I would ask him if there was damage on the car, would you document it? Is that something you could be liable for? Would you be concerned that somebody might blame you for causing that damage if you didn't document it? Try to make that record. I did kind of vaguely remember that he had made a public statement that it was out there. I didn't remember the context. So that's very helpful for anybody who wants to follow that up and see it for themselves. Didn't see any damage to the car. That's helpful. If they knew that in July 2023, why didn't they call him last year? I don't know. I wonder. Kelly Brennan's Lost Big Boy Pants. I once drove up my cousin's leg to his knee with my car like a ramp and then back down. He had zero injury, not even bruised. JOK still wasn't hit by a car. Dang. I'm wish it was on video, like to see it. I mean, I'm guessing if it's because it wasn't an impact, it climbed. I mean, yes, it's an impact, but it wasn't like a transfer kind of impact. It was a slow. I don't know. Crazy story. But yeah, I mean, it's true. It's true. Things can happen. People can go through some pretty remarkable traumas, experiences, and walk away, relatively unscathed. Can be really surprising sometimes. So I definitely can't rule it out, but the whole issue is that they walked away unscathed. They didn't end up dead on somebody's front lawn. So John was clearly not unscathed. Casey Cat, especially since the Alberts removed their concrete floor, not repaired, and totally replaced it. Is that where the blood was? Who knows? Who knows? If defense has evidence of it, we'll find out. If they don't, we probably never will. Kelly Brennan's Lost Big Boy Pants. K-Rob definitely said she picked up Peg and Papa as no four-wheel drive. Yeah, Kerry Roberts. Peg then said we both had four-wheel drive, so that's another lie and makes me wonder why she had to get them. That was a good point. That was a discrepancy that I noticed. I saw other people notice that as well. Her explanation why she had to go get them. You don't have four-wheel drive, so you're not going anywhere. I'm going to go get you. Peggy's been sitting in court the entire time. She knows that Kerry said that. But she still was like, we have four-wheel drive. And she's like, I'm coming to get you, coming to get you anyway. We could do it fine. Where's the discrepancy and who's the cause of it? I don't know. Maybe Kerri is inserting herself. You know, she wanted to be a part of it. She was going to inflict her help no matter what. And this was the kind of justification she made up in her mind, just like, you know, she's going to help John O'Keefe, even if he doesn't really need help. Nobody needs you to run to the grocery store, you know? Nobody needs that. Doesn't need you to do that. But you just kind of want to, you know? You want to have that connection. You want to have that little, you know, notice me, John. I matter. I'm important in ways these randoms aren't. So it could be something similar. She was determined that she was going to drive them there. She was going to get to the hospital. She was going to be part of what was happening, part of that process. And you know, driving them was her way, and that was how she justified it. Either subconsciously, you know, she really did think that, or just didn't have a better explanation. I don't know. But it's also, you know, not out of the realm of possibility that Peggy O'Keefe, I don't need any help. She seems very independent, you know. I don't need any help. I had four-wheel drive. I could have got there myself. Maybe. I don't know. Definitely a discrepancy, though. Patricia McLean with a super chat. Thank you so much for that, Patricia. Gabby Hartman, just a quick hello from Germany. I watch you all the time. I just never engage. I love your input. This trial frustrates me. Oh, Brennan's voice. I can't stand Brennan's voice either. But I have to say, I found it much more tolerable in the trial context than I found it in the argument. When he's arguing to the judge, it's just, it's the nasal quality to it that is, I find, very off-putting. But he also has more range in the trial context. He's not just kind of stuck on righteous indignation combined with nasal projection. It's just not pleasant. You know, he can be the painting the story, the sympathetic. He can be a little nicer. He can have the outrage still, but it's more variable, I think, than we got in argument. So it hasn't bothered me as much, but it definitely bothered me when they were arguing motions. Couldn't stand it. Thanks for being here with us, and thanks for popping in and engaging. Really appreciate it. Love hearing from people. To Truth for Liberty. If M2 were off the table, AJ would likely drop the intent worry. Thinks he's got to cover the bases with that hanging. Well, definitely intent is key. You know, and intent is key. She intended to kill him. It's the bottom line with murder. And so, yeah, it could be he's taking a shotgun approach. Murder has multiple elements we need to disprove. You know, we need to undermine every one of them as much as we can in case the jury doesn't buy it. It's valid. I just don't think it's very good, because you got to focus on, you got to target it for the jury. You can't be, it doesn't look as good to be like, this is wrong, and just in case that isn't, this is wrong, and just in case that isn't, this is wrong. It starts to sound like, you know, that whole, it was the narcissist prayer. I didn't do it, and if I did do it, it wasn't that bad, and if it was that bad, you deserved it, and if you know, and if you didn't deserve it, you know, I don't even remember how it goes, but that's kind of starts to be what it sounds like. Like, you just want them to reach this result, and you're going to throw everything out there that they might jump on. And I just tend to find that less persuasive. But it could be what they're doing. Just we need to hit on every element. I would have liked to have had that previewed and opening. It makes it easier to follow. Then I know why you're doing it. Oh, because it's not just the fact that Karen Reed didn't hit John O'Keefe with the car. It's also the fact that she didn't want to kill him. Why would she want to kill him? They had, you know, No, they didn't have a perfect relationship. They'd been working through it, yada, yada. And she was always the one appeasing him in the text messages and stuff. Karen was the one to try to make it up, not the one to, lose it and be like, fine, I'm done. That was John. John was the withdrawer. I just think, bottom line, she didn't hit him with the car. She didn't hit him with the car. That's game over. If you can focus on that and get the jury to buy into that, if you can get the jury to buy in on she didn't hit him with the car, then it's an uphill battle for the Commonwealth to convince you why you should convict of anything. But yeah, I agree. It could be just because he's focusing on all those different elements. So that's why they're going to challenge the BAC. That's why they're going to challenge the intent. That's why they're going to challenge, recklessness. Even if she was drunk, she wasn't driving reckless, kind of thing. It could be. It definitely makes sense. Track worker convinced John stumbled upon more than just some angry drunks. The McCabe's, Alberts, and Higgins all thought he was a narc for IA and feds. Could be. Could be. I don't know. I mean, that's something that that came up in the last trial. As far as the sketch witness behavior, yeah, it's possible. It actually is possible that the sketch witness behavior isn't because we killed John O'Keefe. It's because we got some other entirely different shady thing going on that we realize is gonna get outed if people start looking too close at why John O'Keefe died on our front lawn. The fact that this happens means we're going to come under scrutiny. We're going to be in hot water for a whole different reason. Whole different other shady thing that we were up to, That's possible. I don't know. I don't know what there's evidence of that would tend to substantiate any of this. We didn't hear anything about it in the first trial. So I don't know. If John had made complaints about one or more of them or something like that to IA, seems like, yeah, that would be a motive. Would the defense pursue it? I think they would. They wouldn't just pitch it as Brian has a habit of hitting people and Higgins had a thing for Karen. Higgins was mad about being ghosted in favor of John. So I don't think they probably have proof of that. I don't know that we'll ever know. The rural juror. Why would Jen not go in the house immediately to ask if John came back? She claims she thought he left with Karen Reed at 12:45. When they found him, why wouldn't she run in and ask Brian Albert if he came back, if he saw him? Well, because she's playing dumb. Because she has to play dumb. It's my theory. He's this man. I'm only going to slowly start to trickle out information to you about who he is and what was going on and stuff like that slowly to the extent that I have to. If they're just playing dumb and they don't have their story together, then you don't want the other people out. You don't want the other attention drawn to them. You don't want to pull them into the situation. You're going to try to keep it under control and then run back and tell them what happened so you can get your story straight. Which kind of might, looks a little bit like what happened. Let's say that what happened is consistent with that. What happened seems to be consistent with that. But if she goes and runs in the house and people are like, what is she doing? Why is she inside? Now they might ask questions. And if you're playing dumb, you're not trying to give anybody any answers. She didn't run inside because she got to play dumb. Her explanation for why she didn't run inside? I don't know. Let's ask her. She was focused on John, on her friend there in the snow. Let's see what she says. But that could certainly be argued and pointed out if this is how things happened. If he just suddenly was found out there after they had the party, he didn't show up. They saw him outside, but then they left. But then here he is in the exact spot where they left him. And when did he come back there? Wouldn't you behave differently? They can ask that. They can certainly argue it. Pee-wee Brennan's Playhouse Adventures. Is it just me, or is the extent of communications and the facts that it's text between Kerry and DA, UB, etc. jaw-dropping to you? The 50 communications with the prosecutor's office, that is jaw-dropping to me. That was big. That's a lot. I mean, I said yesterday, maybe the day before, I'm, losing track of the days now. There are prosecutors that go to trial and have never talked to their witnesses until the day of. They read the report, they see what the police officer said the person said, and that's it. 50 contacts with the prosecutors, with the law enforcement, sometimes with other witnesses around. Yeah, it is pretty jaw-dropping because it's just so not how you do things, which is taking us back to Michael Easter and why Michael Easter should be allowed to and needs to. The defense needs to make a record of what he contributes to this that the Commonwealth's witnesses are not going to, because the Commonwealth's witnesses are going to defend why they didn't separate the witnesses, why they had all these meetings, why they allowed all this communication and so forth, why they didn't discourage it. We heard that from them the other day. I wasn't told I needed to not talk to anybody. Okay. Law enforcement's going to defend that. What's their justification? Well, every investigation is different. Depends on the needs of the investigation. And that's why the defense is going to need a Michael Easter to come in and say that's horseshit. At the best case scenario is that you're introducing the potential for tainting the witness's memories. All this stuff that we talk about how memory works. Worst case scenario is that you are handing them opportunities to collaborate and conspire and make things consistent with each other. So of course you don't do that, and that's standard. Probably teach that at the academy. So yeah, that the whole extent of the communication, particularly the 50 times you've met with prosecutors and investigators and stuff, yeah, that's extensive. That's a lot. Gwynn Garnett, Hollic Price Google on defense witness list. Oh, that's right. There was a Google person on the defense witness list. I do remember that now. I don't remember if there was the first time. I sort of vaguely remember, maybe there was, because I just kind of vaguely remember Google and what the role of Google could be, because Google could be so many things. Google could be location data for somebody's phone. Google could be, geofence data for an area. Google could be search results. I kind of vaguely remember there was a Google witness on the list last time because that came up when we were talking about what that could mean, but I'd have to go back and double check. So I don't know. I mean, could be many things. Not sure what it is, but I hope they call that person this time so we can find out. Please put my curiosity to rest. Ian Thomas, fingers crossed the archangels prevail. Love your coverage, Andrea. Thanks, Ian. Yeah, fingers crossed. They seemed, pretty upfront, upstanding people. I can't imagine they appreciate kind of the implications that are being made here, that they've been, dishonest and sleazy and collaborated with the defense behind the scenes and lied about it. Can't imagine they appreciate that. And like I said, I just find the whole idea so improbable anyway, that the defense, influenced their testimony, because their testimony would have been consistent with the report, or the Commonwealth would have been able to point it out. And so if it's consistent with the report, unless you can prove defense somehow influenced the report through the FBI, come on. That's getting ridiculous. So I imagine they don't particularly like those implications. And they're going to be only too happy and enthusiastic to shoot that down. We'll hope that they prevail. Casey Cat, what would your take be after trial as one of these jurors when you find out one of the last trial's jurors is actually on the defense team? Guess it depends on what my view of the case was as a juror. If I personally, we're talking about me, actual Andrea Burkhart, I'm on the jury and I hear this case, and I don't get clearly I'm not voting to convict, not based on what I've seen before. Unless you come up with something pretty revolutionary, for me, I'm voting not guilty. But I don't get my way for whatever reason, and I find out after the fact, somebody joined the defense team and be like, oh, hey, I get it. I understand. I mean, it does say a lot, doesn't it? Says a lot. It's not just a coincidence. Even if it were just a coincidence, maybe it's a small community that you ended up working at David Yanetti's law office there in Dedham. I kind of doubt it's that small a community, but maybe it is. It's just a coincidence you ended up working for David Yanetti. You don't have to be assigned to this case. So it does seem pretty telling. I mean, it sends a pretty strong signal. At least this juror had pretty strong opinions about not guilty. So Mark Davis, one of the things that bugs me is the idea of Karen leaving if she thought John was inside getting friendly with another woman. Wouldn't most go inside to confront? Maybe, but not necessarily. Not everybody is confrontational. Some people don't like confrontation. Some people are uncomfortable with conflict. And, maybe the point for her is less what you're doing in there and just more the disrespect to me that it represents. Whether he's cheating or not, the whole, going inside and then just abandoning her, leaving her to sit there, not answering the calls, is disrespectful. It's inconsiderate. And so, just a different kind of reaction, maybe, than if you think you're going to catch him in wrongdoing and that's really your main concern. If his wrongdoing is your main concern, maybe you would. But if it's more just his disrespect to you, maybe you just pay that back. You're going to be inconsiderate to me. I'm going to be inconsiderate to you. You can find your own damn ride home. Maybe it's just about the disrespect. Paula Semick, I wonder if the interviews are because she needs money. I wondered about that too. I mean, it's definitely, like I said, she's a smart woman. She's trained in finance. She understands cost benefit analysis. She understands that extremely well. So, I'd be shocked if that kind of thought process hadn't gone into doing these interviews. She's thought about the possible downsides. It's just that for her, the upsides outweighed it. So she did it. And maybe the upside was money. I don't know. I don't know if she got paid for any of them. I don't have any idea. But I definitely consider that possibility. This defense is enormously expensive. This is going to suck dry all of her resources, trying to get all these experts, trying to, pay for the legal team, all that stuff, and, trying to hold on to some semblance of her life. She still has these medical problems and stuff. Does she still have her job? Does she still have her job? Does she have insurance? A lot of stuff to think about. So it's possible. I just don't know if she actually did get paid for it, but I definitely considered that possibility too. Ian Thomas is a YouTube member and has also gifted 5 Andrea Burkhart memberships. Thank you so much, Ian. Welcome. Welcome, and thank you for sharing the love. Edward Kirkpatrick, 911 call a man in the snow for her dear good friend JJ that she loved and adored. I know. This is the big tell to me that it's playing dumb. There's a man in the snow. You might start with that if you're like, I'm just trying to communicate why I need somebody right now. It's because there's a man that's unresponsive in the snow, but then I'm going to fill in the details for you. It's John O'Keefe. He's a Boston police officer. He was meant to be here at a party. We last saw him outside at like 12:30. I don't know if he's been here the whole time. Karen says he never came home, but he never came in, and we don't know where he's been in the meantime. Wouldn't you fill in some of the details? A man unresponsive in the snow. I could see that as your quick, initial summary of the situation and why I need help. But you're going to fill in the details, and that did not happen in that 911 call. I mean, it did reluctantly. And, many of the significant ones, no, did not get filled in that phone call. It'll be interesting to hear that again. And, yeah, see how that lands. Her dear friend, the man unresponsive in the snow. Mark Davis, the 50 communications isn't that significant if it also included the alleged witness intimidation. Kerri tried to bring that in, but AJ cut her off. Yes and no. Yes and no. I'm sure it did. I mean, I'm sure that it did include a lot of this. That was the reason, the justification for a lot of this communication. I would be interested in a time frame. It didn't get broken down. When did these meetings happen? Were they mostly, I don't know, before the grand jury? See, the issue is, when did Turtle Boy get a hold of the case? He didn't get a hold of it from day one. It was a little bit down the road before it kind of started catching people's attention, and there started to be suspicion on the third party culprits. So what did the communication look like before that? That would maybe give us a clearer picture of, is this all innocuous? Was this just generated by witness intimidation complaints, or did this precede it? Maybe it would have been helpful to break that down. I still think it's a lot, because that's a lot of complaints, even if it is. That's a lot of complaints. And I gotta wonder what you're complaining about that many times. I gotta wonder about that. If you're calling the prosecutor's office every time somebody says something mean about you on Facebook, that's a whole different problem. That's a whole different problem than coordinating. It's just it may not be meaningful. It just might be telling about the situation and kind of who we're dealing with and so forth. But the fact that she was the conduit and kind of acknowledged being the conduit, passing on information. Sometimes I'd ask Steve Nelson a question for Jen because we had the best rapport, and then I'd pass it along. And it tells me it's about a little bit more than witness intimidation. But we didn't get any kind of breakdown, so who knows? Trainwreck Entertainment. AV sent me. Can ARCCA sue the state for defamation? Loved your interview with AV. Thank you. Yeah, I enjoyed being on AV's channel. The state cannot be sued for defamation for anything that they have said relating to this litigation. They have litigation privilege is pretty much I hesitate to say an absolute privilege because I'm not 100% sure it is an absolute privilege, but it's very close to an absolute privilege. If you say it in the context of an official proceeding or an official report, or in some jurisdictions, it's even broad enough to include talking about, like you're not necessarily in court when you make the statement, but you're making the statement about what's happening in court, like in a press conference or something. Some cases will extend litigation privilege to that as well. But it absolutely applies to things that you say in court, things that you say in court pleadings and stuff like that. So no, it's privileged. It's privileged. This comes up a lot in accusations can be made in the context of a court case that can be very damaging to your reputation, and you don't necessarily have any recourse for it. Sometimes that can be gamed. Call it defamation laundering. You can't be sued for it if you say it in court, so you find a way to say it in court. Kind of thing happens sometimes. So no, I mean, I don't see an avenue. I don't know how broad the litigation privilege is in Massachusetts, if it's just what's said in the courthouse, or if it would encompass things said outside the court, not actually as part of the legal process. But I'm not aware of any statement there that would apply. Hank's been under the gag order. He hasn't been making statements. So everything I know of, he said in court, and that means no, they can't sue him for it. The whole reason for that is they want to encourage people. They figure that there's already this discouragement to say false things in court because you can be charged with perjury. So if you make up smears against people, you're lying. For it to be defamatory, it has to be false. You just go in and lie about people like there's already protections for that. But it's also just a context where they want people to be free to give more information rather than less. And so if it's important information, what I've heard about somebody, and it needs to come out in a case, even if it isn't true, I don't want to be sued for defamation because I'm subpoenaed and compelled to come into court, and I'm going to be thrown in jail if I don't ask the question that I'm answered about what's the gossip I've heard about this person. It does come up sometimes. Reputation can come up in different contexts. Self-defense is a big one. Person's reputation in the community, different reasons it can be an issue. Reputation for veracity. Credibility. Does this person known as a liar or a truth teller? So that's generally why they want to encourage more information in court rather than less. If people are afraid they're going to get sued for what they say in court, they're going to be more restrictive in what they disclose. So that's why we have the litigation privilege. But this is the consequence of it. That if you get smeared in court, you're not going to have any recourse for that. So, well, guys, it's 1:13. Even a little bit longer than we did yesterday. Oh my gosh, we're at 7:27. Guys, I'm gonna wrap up my closure here real quickly because I haven't poor dog. I haven't fed the dog yet. I'm going to go feed the dog. I'm alone here today. Jeff, you may have heard in the chat, is on a plane. He's flying back to see his family. He's got an event. I am holding down the fort, so it's kind of on me to take care of everybody, and I'm going to need to step out and do that now. But man, week one, I got to tell you, it hasn't been a real banger for me. I have not seen, not impressed with the Commonwealth. They have not moved the ball towards Karen Reed hit John O'Keefe with the car. In my mind, that's where I'm focused. Wish the defense would have focused there too, but they're not. Don't know if their approach is kind of overly distracting to the jury or off-putting to the jury or not. Just kind of feel like that's a risk of the approach that they're taking, but there's still a lot of trial to go. And of course, time is going to tell how all of this plays out. So told you before, some couple things I have on the back burner. If I get a chance this weekend, want to put out on Substack. So do keep an eye on that if that's the type of thing that you're interested in. I got some thoughts about this whole ARCCA issue and the discovery violation that Bev found. And now, of course, I've spaced off the top of my head. I have it written in my notes somewhere. The other thing that I'm interested in following up on. I can't remember it off the top of my head. It is what it is. If that type of thing is interesting to you, do check it out on Substack. Otherwise, we'll be back Monday, guys. We'll be back Monday, full day for us, bright and early. And we'll see what we get with ARCCA. We'll see what this offer of proof / voir dire ends up being. We'll see what comes out. Any merit to this concern about communications and tampering and so forth. We'll see how it goes, guys. So in the meantime, do take some time off to take care of yourselves. Enjoy your lives. Oh, and thank you so much, I got to say, to CH real quickly, because when I went off the stream yesterday, I stopped, and then sometimes I'll go back and look at the last few comments because I don't get to follow the chat. Said it before many times. I can't talk and read at the same time, so a lot of the chat passes me by. But I did go back to check yesterday, and what I see is CH paraphrasing my comment. Go move your biological container. And I died. I'm still I can't cope with that. My God, that was hilarious. You absolutely slayed me. I'm like, my God, what a ridiculous thing to say. And I did. I kind of said that. But I just loved it. It was very, very absurd. I found that so humorous. So I lolled. I actually lolled. I lolled several times throughout the course of the day as I remembered it. I'm lolling again now. Thank you for that. That just brightened my day like few things do. So guys, go move your biological containers. But if that's not what moves your soul, you don't have to. It's just that, your body is kind of programmed for certain activities and stuff. So it tends to be good for you. That's all I'm trying to say. Kind of classic Greek view of, you need to take care of the mind and soul, but you do also want to take care of the body. They're not really separate things. So anyway, I enjoy all of you, and I appreciate you appreciating my humor and my perspectivism and my perspective and the absurdity that is this life on Earth sometimes. So thank you so much. I just enjoy you guys so much, and I really appreciate you being here and sharing your ideas and everything. Look forward to catching back up with you on Monday, and have yourselves a wonderful weekend. Look forward to seeing you next time.